Steve Harrison, and Stephen Vladek. Went this way, not this way. Hello, gentlemen. Okay. On behalf of himself. Okay. Chair calls Robert Barnes. We show that you are registered for the bill and are here to testify on behalf of yourself. Is that correct?
I'm here to testify on behalf of my bank and myself, and I was a little confused when I was filling out the information, so I want to make that clear. I'm representing IBC Bank as well as myself.
Okay, thank you. Please proceed.
Okay, let me start by saying that I may be considered one of the last of the Mohegans. I have started my banking career in 1973. This is my 50th year of being a banker in Texas. I've had the pleasure of running two banks as president and CEO, and I'm currently the chairman and CEO of IBC Bank Austin. And I've listened to a lot of the discussion previously, and I would like to just give an overview of my experience in the business community. Over the last many years, I've seen many of my customers frustrated at the length of time it takes for a case to go through the courts. In many cases, being delayed, and the cost is catastrophic at times. And I just feel like we can do a better job. And so the idea of a specialized business court to me would solve a lot of the frustration that I see with customers that I've dealt with for a number of years. One, it would allow for efficiency. It would allow cases to move quickly and faster for a more efficient resolution. It would ensure judges with appropriate expertise and experience to handle these cases. It would help release the pressure on our courts of general jurisdiction. It will allow Texas to become more competitive, especially when we're competing with 29 other states that have a specialized business court. And finally, from the business perspective, it would provide the business community with predictability, knowing that their cases will be handled efficiently and by a specialized court. And from my perspective, I feel like these frustrations have never really been addressed in the last 50 years that I have been a banker, and I'm hoping that we can do a better job. And I hope this is the solution.
Thank you. Chair recognizes that Representative Murr has joined us. Members, does anyone have any questions? Thank you, sir. Chair recognizes Sam Hardy, and we show that you are registered on behalf of Energy Transfer for the bill. Is that correct?
It is correct, Vice Chair. And myself, I think I fat-fingered the login, and I apologize for myself and Energy Transfer.
Okay, and just so everyone knows, we have to get this correct so that the record is correct. So we'll be just checking. So on behalf of yourself and Energy Transfer, in favor of the bill, is that correct?
Correct.
Please proceed.
Thank you. My name is Sam Hardy. I'm the Associate General Counsel and the head of litigation for Energy Transfer. Prior to that, I was a partner at a boutique in Dallas and practiced almost exclusively in the area of commercial litigation in Texas and around the country for 12 years. I'm here to advocate for passage of the bill, both as a former private practicing attorney, as well as the attorney responsible for managing the litigation of our company and our family of companies. And there are I should really say four primary reasons why I think this bill should go forward. They're going to echo a lot of what was said today, but the first is predictability of outcome. I have come to appreciate as an inside lawyer when our company is entering into contracts with other companies, right? And some of our contracts are very large. 20-year oil and gas contracts may have $1 billion, $2 billion in revenue over the life of that contract. A risk is apportioned between those parties, and the parties apportion risk as a commercial reality in part on what will the outcome be if a dispute arises, and disputes unfortunately arise. the predictability of outcome in a court proceeding is essential to ordering those commercial endeavors efficiently, economically, and serves the interests of commerce generally as well as my company specifically. 2, timeliness. Our courts of general jurisdiction, even in Dallas and Harris County, where there is a somewhat specialized trifurcation between family, criminal, and civil courts, have to deal with anything that comes through the door. And if it's a family court emergency, if it's a temporary restraining order, if it is a car wreck, if it's a court of general jurisdiction, a speedy trial act case or criminal case, business court cases will get pushed. Trial settings will come. You might be 26th on the docket. You get bumped the week before after you spent all of the money getting ready for trial, and then you have to do it again 6 months later. So timeliness is important. Just as a data point, I had my staff pull. The 5 oldest cases I have, the oldest is a 2009 case, filed in Texas, was recently settled just a month ago. That case took 14 years to resolve itself. I have a 2013 case, 2014 case, and 2017 cases. So those are 5 cases of which, are going on 6+ years that only 2 of which have resolved, and they only just resolved this year. So timeliness is very important for expense as well as for, again, certainty and predictability in commercial relationships. Third, this court would allow uniform development of the law. One of the things that we heard a lot about Delaware Chancery Court today, I'm sure we'll hear more. One of the things that makes Delaware Chancery Court a destination court or choice of venue court in contracts is the development of that law, particularly in the areas of internal affairs, government corporate governance, fiduciary duty. So the development of that law that is uniform, systematic, well thought out, well reasoned, well developed, allows parties to understand the risks that they are taking when they enter into commercial agreements and understands exactly how litigation is likely to play out, which promotes settlement and the efficient use of court resources. And finally, having a business court will incentivize contracting parties that we contract with to cite venue and choice of law in Texas. Often that is part of a contractual provision, something that sometimes it's heavily negotiated, and having a business court that gives comfort to out-of-state or even foreign entities will help assure that dispute can be heard in Texas. We're a Texas company, we employ Texas folks, and in Texas is where it belongs. Thank you.
Thank you. Members, does anyone have any questions?
I do, Madam Vice Chair.
Chairman Moore.
Could you elaborate just a little bit on the last point that you made? I think that's interesting. So clearly you have experience dealing in both, I'd say, national or international business transactions. And so consequently, has it been your experience that when you're looking at venue provisions that parties typically don't look to Texas as venue for many reasons, but that being one of them?
Exactly right. That's exactly right, Representative. If we deal with parties, sometimes they're intrastate issues, sometimes they're interstate issues, sometimes they're international contracts. And foreign entities, and I mean non-Texas entities that we contract with, are, frankly, quite suspicious often of Texas courts. They feel like the Pennzoil case from way back when still echoes through the judiciary, still echoes through the sort of the legal halls. And but we are a Texas company, and we are, operate under Texas law, and we want those disputes heard in Texas. And so having a business court, we can say, look, you're going to be in a court that specialized just like Delaware, just like one of the other 29 states. You can rest assured that justice will be efficient, fair, and timely.
And so they vocalized the reluctance for those reasons.
Yes.
In the past. Okay.
Yes,
I appreciate that.
It has.
Thank you for your time.
Members, any other questions? Thank you. Okay. Chair calls Steve Harrison. And just so that the record's clear, you are here to testify on behalf of yourself against the bill. Is that correct?
That's correct.
You may proceed.
Thank you. And thank you, members of the committee. I'm Steve Harrison. I'm a trial lawyer practicing for 47 years in Waco. And I come to talk to you about what I hope are unintended consequences, but they are very real consequences of this bill. So envision a corporation, A and B, manufacturing a product which they sell in a commercial transaction to corporation C. Unfortunately, this product explodes. It destroys corporation C's facility and business and destroys the building and interrupts the business of corporation D. Now, causing property damage and business interruption in excess of $10 million for these that are affected. Now, that may sound like a law school exam question, but I do not come to you as an academic or a hypothetical situation. What I have just described to you is the West fertilizer explosion. Two manufacturers of ammonium nitrate sold the product to another corporation, the fertilizer plant in West. That explosion destroyed West Rest Haven, another corporate entity, nursing home. I and my firm represented that nursing home. We also represented 10 families of men who were killed in that explosion, as well as scores of others who were injured. Also involved in that litigation were substantial, in the hundreds of millions of dollars of subrogation losses. Insurance companies filed cases, one of which I'm given to understand involved $25 million in property damages. Now, if this bill was in effect when the West fertilizer plant exploded, the nursing home case could have been removed. The subrogation claims could have been removed to counties where no one connected to the case resided. The potential then, imagine this, in another county with a business court judge, discovery, motions for continuance, trial preparation is going on. In McLennan County, all of the personal injury and wrongful death cases are still going on. There were 39 contested hearings. So those hearings are now happening in two different places by two different judges.
Excuse me, sir, your time has expired.
May I wrap that up?
Please.
The huge conundrum comes when the case that has been removed comes back to McLennan County. Now there are two cases on the same subject proceeding in the same county with two different judges. You could have simultaneous trials going, and the havoc that as you might imagine, with conflicting rulings could happen.
Chairman Moody.
And not a civil litigator, so I'll tread lightly and make sure I don't sound too dumb. You're using the real world example of the West explosion in saying that bill as is would allow for some of these things to be moved over. And can you help me understand what in the bill is permitted? I just need to know what in the bill would permit that. Like, what do we drill down into the detail of why those would go or could go somewhere else?
By the language of the bill.
What part?
I don't remember the section, but it describes that the cause before the court relates to a commercial transaction. Now, that commercial transaction was the starting place for the causes of action that then became product liability cases, negligence cases that affected not only those killed and injured, but very substantial property damage claims between corporate entities. By the reading of that bill, one of those defendants could remove that case to this business court. I recognize that the bill excludes personal injury and wrongful death cases, so those, I presume, are continuing to go forward, but they're dealing with exactly the same liability facts as those property damage and insurance cases that are now removed to another court, a foreign court.
Okay, sorry, that was the part that I wasn't quite understanding in having it come back at some point and on two different tracks. I appreciate you kind of dumbing that down for me. Thank you.
Yeah, I was going to follow up on that line of questioning. So you've got one corporation suing West for business disruption, could be anything in excess of $10 million, since that seems to be the only threshold this bill has. But then you also have insurance companies who have paid out a variety of property claims, could be all the cars that were damaged, could be personal injury claims of people that were killed. And those, by their definition, may not be included in the bill at that level, but because it's an insurance company who's dealing with duty of care, duty of loyalty, duty of good faith, as exemplified on page 6, subsection 6, and those subrogation claims could easily, in their totality, exceed 10 million. So those could be part of the business case, but the underlying claims would not be part of the business case. And so then you've got a litigation that's got two different pathways with two different courts, rendering could be conflicting discovery rulings, just, not any consistency obligation. Did I summarize that right?
You did, and if you carry it further, if the 15th court is created, now the rulings of those separate proceedings are now going to not go to one court of appeals. They're going to completely different appellate settings.
Right, and this sort of this scenario is a real case that you handled that happened in this state. This would be sort of in conflict with some of the goals of a prior testimony of certainty and predictability when you have cases and claims that could be brought in multiple jurisdictions versus consolidated into one action, because some are applicable to the business court and others are not.
Precisely, and this real life example, keep in mind, this is pretty complex litigation handled by a district judge in Waco, Texas, who I must say brilliantly managed this litigation involving more than 200 parties, as many as 75 or 80 lawyers at a time, and yet was able to put his arms around this, manage this litigation. Imagine if it was being managed by two different judges in two different locations.
And not to mention, he was actually elected by the voters.
He was, and I must also say, I asked him what he thought about this bill, and he thought this was a terrible idea.
Members, any other questions? Chairman Murr.
I just have one question. Thank you so much for traveling all the way today to share your opinions. You heard me in my explanation of the committee substitute that we had included language that was modeled on our federal rules on supplemental jurisdiction. And so in that, and I'll kind of read that sentence to you, the business court has supplemental jurisdiction over any other claim related to a case or controversy within the court's jurisdiction that forms part of the same case or controversy. A claim within the business court's supplemental jurisdiction may proceed in the business court only if the parties and the judge agree. So given that, you're giving us the application of a real-world fact pattern, knowing the supplemental jurisdiction here, is it possible that the parties and the judge could have agreed that all claims would then be within the business court?
Well,
because we're applying real facts to theoretical.
short answer is not in a million years, because keep in mind, an agreement like that would involve 10 grieving families who lost men in this explosion agreeing to take the case to a business court in Amarillo, as opposed to in the community where these men lived and died. It just wouldn't happen.
That's fine. I'm just pointing out there is a mechanism that we've talked about here that would allow all those claims to be in one court. Thank you.
You're welcome. Thank you.
Members, any other questions? Thank you, sir. Okay, Chair now calls Stephen Vladeck.
Yes, ma'am.
Did I pronounce that properly?
Thank you.
And you are registered on behalf of yourself against the bill, is that correct?
That's right, Madam Chair.
Please proceed.
Thank you. Members, I'm Steve Vladeck. I hold the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law, where I teach constitutional law, civil procedure, and the structure of our court system, but I am testifying today in my personal capacity. You've heard and will hear from witnesses who support or oppose HB 19 because of their views of its policy wisdom or lack thereof. I think my colleagues to my left reflect that. I'm testifying against HB 19 for the same reason that I oppose HB 3166. I believe both bills are unconstitutional in violation of Article 5, Sections 6 and 7 of the Texas Constitution. First, Section 6 and 7 authorize the creation of courts of appeals and district courts wherein the state, quote, shall be divided, unquote, into districts. Since these provisions were added to the Constitution in 1891, they have been consistently and uniformly understood to require that these divisions be geographic, not substantive. That's why among the various specialized courts that have already been alluded to today, all of them are contained within geographic subdivisions, such as the Travis County Probate Court. Giving a trial level or intermediate appellate court statewide jurisdiction would thus run afoul of these provisions and would, in my view, be unconstitutional. Second, and specific to HB 19, Article 5, Section 7 also provides that, quote, each district judge shall be elected by the qualified voters at a general election, unquote. Thus, even if it were possible to constitute the entire state as a district, as HB 19 purports to do, such a district court would still have to be staffed by judges selected by the electorate rather than appointed by the governor. It's certainly true that a number of states have experimented with some kind of commercial or business court in recent years, but my own research suggests that in each of these states, either the business court has likewise been divided geographically, such as the Maricopa County Business Court in Phoenix, or has been created in a state the constitution of which does not require geographic subdivisions of lower courts, such as the Delaware Court of Chancery, which is created expressly by the Delaware Constitution, or the Georgia statewide business court. Indeed, the Georgia Constitution, in contrast to ours, expressly authorizes the creation of courts that deviate from the structural requirements of the Constitution, so long as the proposal is approved by a 2/3 majority of both houses of the state legislature. We do not have a similar provision, of course, in Article 5 of the Texas Constitution. Whatever the wisdom of these proposals, Madam Chair, the Texas Constitution requires geographically subdivided lower courts, and it requires direct election of judges. For those reasons, whatever other reforms might be warranted to our state courts to address the concerns animating these bills, I oppose HB 19 and HB 3166. Thank you.
Thank you. Oh, yeah, and sorry, this is, for this testimony, you're just here on
Yes, ma'am.
HB 19, is that correct? Okay. Okay. I'm going to master this timer one of these moments. Members, does anyone have any questions?
Representative Davis appeared.
Oh, Representative Davis?
I'm so happy y'all was concerned about me. Thank you.
Okay, I have a question. Please. So, again, because it's no secret as of today that I'm very concerned about the constitutionality of this. And so, since we have a constitutional expert, so there's multiple aspects of the constitutional challenges here at play, right? So obviously we have the election of the appointment versus election of a district judge. This could be solved if we created, as we've discussed with a few prior witnesses, allowed courts, jurisdictions, Harris County, Dallas County, Travis County, Bexar County, El Paso, all these, to create and elect a business court. That would meet constitutional muster in your view.
It would, Madam Chair, and it would because like the probate courts, like the domestic relations, I mean, like the examples you heard about earlier this morning, right? Those would be geographically created constructs that would be subdivided into the very districts the Constitution.
But that's a second issue, right? Is the geographical nature of it. The fact that they're trying to create a statewide specialty court has not been done in this state. Is that correct?
Not to my understanding, and I've looked.
And the specialty courts that they referenced earlier in relations to drug courts and things like that, those have very narrow geographic applications in their scope of jurisdiction. Is that right?
That's right. And some, Madam Chair, as you know, are created by the legislature by statute. These are the statutory courts. But all of those are defined at most geographically. Some are even further subdivided within counties and within these jurisdictions. Some, Madam Chair, are created by the district courts under delegations of authority to the district courts. None have jurisdiction that cross, right, the district lines that the Constitution contemplates.
Right. Another constitutional issue I'm concerned about is the fact that the proceedings can be held in any location in the state. And doesn't that also run afoul of some constitutional issues with respect to locations upon which matters, the venue locations where matters are to be heard?
So Article 5 does create venue requirements. I think the tricky part there is that at least some of those provisions do provide that those can be changed by law, including by the legislature. But of course, if you were to have a case requiring a jury trial, right, if you're going to have a case where you had any requirement of any people being selected from the district, moving the case to a different geographic part of the state would raise constitutional concerns all its own.
In terms of, let's say in the West example, if the business courts decided to have the jury trial in Tyler, Texas, as opposed to West Texas, that could be subject to constitutional challenges.
Potentially. I mean, so at least in the federal system, and in the Sixth Amendment context, there's something called the vicinage requirement, which is that when you are drawing a jury pool, it has to be not just from the state in which the offense was committed, but from the specific geographic district in which the offense was committed. And so insofar as the Texas Supreme Court might be inclined to recognize a similar requirement for civil jury trials in the state, you'd have that problem here as well.
Thank you. Members, any other questions? Okay, thank you, gentlemen. We'll proceed to our next panel, which is Brent Benoit, John Ale, Laura Tamez, and Mark Gropefield. You would all please come forward.
Stick it right there.
Okay. Chair calls on Brent Benoit, and just to confirm, you're here to testify on behalf of yourself for the bill. Is that correct?
That is correct, Madam.
Please proceed.
My name is Brent Benoit, and I'd like to thank the chairman and all the members of this committee for affording me the opportunity to deliver some remarks in support of House Bill 19. I am currently the Deputy General Counsel for NOV, formerly known as National Oil Varco. Before that, I was a litigation partner and co-head of the Houston Trial Practice at Lock Lord. I also served as the president of the Houston Bar Association. As you have heard, the creation of business courts in Texas is an important step forward for the efficient administration of justice in our state. But I would like to focus my comments on another benefit, and that is a more uniform, fair, and predictable body of case law in the cases that will come before these courts. Many significant business law cases are not uniformly distributed through our state courts. For example, in the shareholder litigation and corporate governance field, some courts handle a number of these cases. Other courts try relatively few, and still others may see rarely one, if at all. Our state judges are smart and hardworking, but when they all have differing levels of experience in these cases that raise issues of law that are just not present in the bulk of cases, the outcomes are not uniform and results can be unpredictable. In the context of business disputes, predictability matters. These cases often arise out of consensual business arrangements that were negotiated based on the party's expectation of how the relevant law will be applied. But when that law is applied unevenly and unpredictably, again, not because of the quality of our courts, but because of what may be a substantial difference in experience overseeing such cases, then business parties are left to guess as to how these arrangements may be viewed or interpreted in any given court. This is bad for the quality of justice, especially in these matters. Doing justice often necessarily depends on upholding and honoring the expectation of the parties. An uneven approach to these cases undermines this objective. In addition, this hurts the overall business environment of the state. A steady jurisprudence that applies evenly in these cases reduces the risk of operating and entering into business arrangements in Texas. This in turn makes Texas a more attractive place to do business and create much needed jobs. Simply put, when it comes to the adjudication of business disputes, we are falling behind many of the other states that have already incorporated business courts into the judicial system. Another point that I'd like to just briefly make is on the efficiency point, to echo what the gentleman from Energy Transfer mentioned. I have a case right now that was filed in 2017. We have been reset multiple times, and there is no indication or any objective indication that we will go to trial anytime in the near future. That is 6 years, and we're falling behind because of not because of judges that can't do their job, but just because of the docket of these cases. So I would encourage the passage of this bill, and I'd be happy to answer any questions.
Thank you. Members, any questions? Chairman Murr.
I just want to follow up. Could you flesh out a little bit more just on the case you speak of about being reset so many times?
Yes.
Do you have specific reasons that you could provide for why it was reset? I mean, sometimes the parties do that because that's a need, but is it being reset because of the court's time constraints or other reasons?
Yeah, so this particular case to which I refer has been reset multiple times. Initially, the first time or two was at the discretion of the parties or at the request of the parties, as you just mentioned. But since then, as I think most folks know, in these dockets, it's a 2-week docket. There's usually a large number of cases on the docket. And as a result of that, cases that are going to take a while to try tend sometimes to get pushed down so that other cases can go forward, or some cases need to be prioritized based on certain requirements. And so that's happened. The one thing that I will say, and I'll echo a point that's made, is the problem with that is that oftentimes the parties who are on that docket don't have clear picture as to whether they're going to go or not. So they have to get ready for trial. And in these big commercial cases, getting ready for trial means, prepping your witnesses and getting your exhibits ready to go and getting everything logistically ready to go when you don't know if you're going to go to trial. And that costs a lot of money every time you think you may go to trial. And so as you get reset multiple times, that leads to a situation where there's a lot of expense in the system that didn't need to be there if the cases could be handled more efficiently and more effectively by themselves.
Thank you.
Representative Flores.
Consistency and uniformity, or maybe I'm saying the wrong word, but I mean, I can understand wanting to have the law applied consistently but however, wouldn't you say that because the facts of different cases vary, that the outcomes can be very different?
Sure, facts always will sometimes drive a case, but what I'm referring to is the way the laws are interpreted and what the laws mean and what the rules are. Obviously, when you have a set of rules, if you have a set of rules and you apply different facts to them, you may get different outcomes. But what's important is everybody knows what the rules are and how they're going to be interpreted, because then two parties who are consensually entering into a business relationship can understand, okay, if something happens, this is how this provision will work, this is how this rule will work, and therefore we can make rational business judgments about that. But in the situation that we've got, where a dispute could be sent to any of many different district courts who have very different levels of experience handling these matters, you may not get uniform application of the rules, and that becomes a problem with predictability. And so that's really the point that I was trying to make.
But you would agree that there isn't a real degree of predictability in trying cases.
In trying cases?
I mean, in the outcomes of cases.
I think it depends on what kind of case you're talking about. Obviously, the old saying goes for trial lawyers, and I was one for many years. Once you get 12 people in a box, it can be unpredictable. But that's not really what I'm referring to. There is a certain inherent unpredictability in trial, wherever you go. But the laws that govern some of these issues and the laws that govern these principles, if we have a clear view of what those laws are, like we do in some other states that have business courts, it allows the parties to order their conduct much more effectively. We'll never take all the risk or all the unpredictability out of a case for sure, but we can make it more predictable, and that's better for business.
Representative Davis.
Thank you, Madam Chair. Let me ask, I had a question relative to that because it sounded like you were identifying a certain kind of person that has a certain kind of look, that has a certain education from a certain school, then you would get some predictability. And I'm just curious, you didn't mean to kind of imply that you thought that if this business court was created, that the judges that would be appointed would all think alike?
Oh, no, ma'am. And if I said that, I may have had a slip, but I didn't mean to say that. I'm not talking about judges of a particular whatever. What I'm talking about is the fact that we've got so many different judges who handle these cases in differing degrees. For example, if you have a judge that's in a rural county, that judge they may be a phenomenal judge, but they're probably not going to handle very many M&A cases. They're probably not going to handle very many corporate governance cases, whereas other judges might handle more of them. And so those are both fantastic judges, but the degree of experience between those may mean that they come to different points and interpretations of the rules, and that creates the unpredictability. So it's not about the characteristics, although I think it's important that we have people who have a certain level of business experience or experience with those laws. That's the point. But in terms of any other characteristics, that's not the point. The point is if you have a defined number of judges who focus on these cases, that will lead to the predictability that I think is important.
So back to predictability. We're talking about having judges appointed by a governor. So is the predictability a party? I'm trying to understand why it is wrong for us to think that the district judges who are duly elected, who've gone through school, would not be able to be prepared for a case presented in their court.
Well, I think the answer is predictability of party. I think the point is you've got a certain court that will develop a body of jurisprudence. And under certain rules like stare decisis and other things that are important components of judicial review, that leads to a ferment and to a consistency in the law regardless of which party is appointing those judges, kind of like you see sometimes in other federal courts where the parties are appointed. And so my point is that I think I guess to answer your question, I don't see the fact that the appointment is going to be made as affecting necessarily the predictability, because there's going to be a body of case law, regardless of whether that's one party or another or a third party who's appointing the judges. You've got a defined body of case law that all of those judges are feeding into.
So in actuality, we have that appointment process through the electoral process, right? Right now. Currently, the electoral process gets to evaluate that through elections. Is that correct? So are you suggesting that in order to get to a predictability or some certainty of what the outcomes of courts will be, they need to be appointed? Under your scenario, would elected bodies not be able to do what you're talking about?
I think there are many ways that you could select these judges, I think, as other witnesses have said. And so I'm...
But I mean, do you believe that you could elect judges who are able to get ready for a case before them and be able to define the merits of the case?
I think you could do it by election or by appointment. Okay. But I think if you have a business court that has a defined jurisdiction and has a defined set of judges who are responsible for it, the point there is because you've now assigned it to a particular specialized court, you get more predictability that way. That point doesn't necessarily depend, I guess is the answer to your question, on whether the judges are elected or appointed.
Because you could set that criteria for an elected body as well, is that correct?
I think you could, and that would be a decision for others to make.
So let me ask you something as it relates to appointed judges. Have you ever seen an appointed body be nonpartisan? Have you ever seen an elected body that's nonpartisan? Has no alliance with appointee, with the party of the appointee?
I would like to think, the answer is I don't know that I could cite examples to you right now of different appointed bodies. I've seen some appointed bodies work better than others. I've seen some elected bodies work better than others. I think there's always going to be, probably no matter how you did, like our current system, there are people who oppose our current system of electing judges, and there are people who are for it. And there's always going to be differing views on that. The point that I'm trying to make is not so much on the selection of judges, but on the idea of this court and the merits of this court, and what this court, however it's appointed or however it's elected, the reason it would be a benefit to Texas jurisprudence and to the business environment.
And so then one of the questions I have in the past, my understanding is when we've run in Dallas County, when we get a certain caseload, we petition the state for additional courts. Why isn't that option still viable?
Well, it certainly is an option. It just doesn't answer the concern that I've got, because the concern that I've got is that.
And you could make it a business court, but why wouldn't the county, if this business court there's this great need for business court or specialty court, why wouldn't the county be able to petition for that specialty court through the process that we currently use? What happens if that wouldn't work?
Yeah, if we're talking about the appointment of a business court within the county.
That's correct.
I think in that circumstance, you get closer to answering some of the questions and some of the concerns that I've talked about. I think, like I said, there's different ways to get to the business court, and I guess I'll borrow the words of Justice Massagill. I'm agnostic in many ways about how that comes about. Yeah. What I do think is important is the idea of the business court handling these cases for the reasons that I've said, because it leads to predictability and efficiency and helps businesses.
And my last question regarding that is, are we creating a system, or unintentionally, maybe intentionally, are we creating a court system, an elite court system to leave people out? Are we attempting to do that by having this appointed elite new body of judges that only a few are able to handle the cases? There's this need for this great education. Our judges are not really ready, and they're overwhelmed, and all that stuff that's kind of part of the second tier of all of the testimony. Are we, at the expense of the Constitution and the people in our communities, are we creating an elite group only?
The answer that I would give you is no. I don't think we're doing anything at the expense of the Constitution. There's a case that is on this point, Jordan versus Crudgington from 1950, that speaks about the constitutionality of this. But setting that aside, I don't think this is different rules for different people. I don't think it has to do with the fact that there's quote unquote better judges in the sense of the quality of the judge themselves. It has to do with specialization, which is different than whether a judge is a good judge or not. And so that's really the point that I was trying to get.
And I appreciate that, because there's a distinction, because from my perspective, I keep hearing people thinking that this bill has to do with appointed judges. And I want to be clear that the testimony is that they don't have to be appointed, that we could have a business court in our different jurisdictions. And we could even set some criteria, but you would leave it where the people would elect that judge versus appointment. That, to me, is kind of where I want to make sure we don't get aligned with thinking this is the only way we can have business courts. And so that's what I'm trying to make sure of.
I think there probably are a number of ways to get there. I support this way, but I do agree that there's probably a number of ways to get there.
That was what I was trying to get
Sure.
your expertise on. Thank you.
Thank you, members. Any other questions? Thank you. Okay, Chair calls John Ale, and you are here for the Texas Business Law Foundation against, let me start over. John Ale, you are here for the Texas Business Law Foundation in support of the bill. Is that correct?
That's correct, as well as myself, if that's appropriate to say.
Okay, I will add that to your record. So
It looked like it was a multiple choice where I only had two
it's
choices.
confusing out there, but we want to make sure to get it right. So just to confirm, you're here on behalf of yourself as well as the Texas Business Law Foundation in support of the bill.
Yes, Madam Vice Chair.
Please proceed. Thank you.
Thank you, Madam Vice Chair and members of the committee. Pleased to be here today. I'm a 40-plus year Texas lawyer after judicial clerkships. I spent most of my career in private practice at 2 large law firms, but I've also spent 11 years as general counsel of 3 different publicly traded companies listed on the New York Stock Exchange. I'm currently retired from the last of those positions and am serving as an outside director of an S&P 500 company headquartered in Texas. I'm also a former chair of the 4,000 plus member business law section of the Texas Bar. In my career, I've seen all kinds of deals, all kinds of securities offerings, all kinds of transactions out there. And I've seen them dissected, months or years later, many years later, as the prior speaker said sometimes, in courts across this state and across the country. Many times, those could be rural courts, those could be urban courts. And I've seen cases of great complexity arising under federal securities laws or the Delaware Uniform Limited Partnership Act governance provisions be presented to a trial judge who is probably excellent at the criminal cases, the family law cases, the civil cases that otherwise come in front of that judge. But this is the first time she or he is seeing anything like this. Just the same way as I get a bit older, if something is going wrong with me, I want to see a specialist. I think if I'm a litigator, I want to see a specialist, or a person in litigation, I want to see a specialist. I want to see a specialist if I have a tort problem, because I want to go in front of a civil judge who understands those, as opposed to someone who understands only criminal cases. If I have a family law issue, I want to do that. Same thing here. All we're talking about is specialization. That's the reason I'm in favor of this bill. There may be comments that are made about quality of judges or how certain lawyers like it because they're used to this system. And we may not have every little piece of data on this in the state of Texas, but we have data from a lot of other states. And we have a lot of anecdotal evidence, the way this legislature legislates on many topics, about how it works when you go into one of these states that has a business court and you have a judge who immediately recognizes when something is right, something is wrong, or something needs to be tried. You need answers to those questions. That's it, Madam Chairman.
Thank you. Members, any questions? Chairman Moore.
Thank you for being here today. So you talked about specialization, and you said there's essentially we have anecdotal evidence that the legislature has prioritized that. I guess from your experience, we've seen this specialization throughout the courts, both from probate, child welfare, veterans, drug courts, and I think we talked about that earlier today. Is that really what you meant by the specialization?
That's what I mean by specialization. We see that here, but we've also seen the business specialization in other states. It's functioning well in Delaware. It's functioning well in New York. It's functioning in Georgia. Run down the list of the other 24 states that have specialty business courts. The state of Massachusetts has a specialty land court that covers real estate disputes. There are many places where this could come in as a handy device. I think business is one of the leading places because we've seen it work so well across the country. When you have, I'll give you an example of the company where I later served as general counsel, had a federal securities act brought against it where jurisdiction lies also in state courts. It came in front of a district judge who is impaneling a jury that day on a car accident case, is handling many other things. You talk about the requirements of the PSLRA or whatever it is under federal law that a federal judge or the federal judge's law clerk, because our trial judges don't always have law clerks in this state, they're able to answer those questions quickly because they've seen them and clear the docket out of the silly cases, or set the ones for trial that need to be set for trial. And that's the same kind of thing goes on in criminal courts, in probate courts, and family courts.
Thank you.
Representative Flores.
But you would agree that you can have a specialty court created that falls within the Texas Constitution in both the election of judges and also the, geographic district components. I mean, wouldn't you say you can do that and accomplish the same?
In my view, first of all, let's be sure we're talking on the same level, Representative Flores. I believe this bill is constitutional because of the Jordan v. Crutchington case that the Supreme Court decided in 1950. But if you want to go the conventional route, let's call it for lack of a better term, yes, that could be done that way.
I'd rather
That's a
call it
choice.
the constitutional term, but yes.
Members, any other questions? Thank you for your testimony. Chair calls Laura Tamez.
Yes,
And you're here on behalf of the Texas Trial Lawyers Association against the bill, is that correct?
yes, Madam Chair. And thank you and members of the committee. And although TTLA is against the bill, with that said, we are grateful and thank Chairman Murr for inviting TTLA and other stakeholders to be part of the process to address our concerns, with the understanding and full disclosure that TTLA can never be for a bill that infringes upon the freedom of Texans to elect their judges. As we have gone through this process and even during the interim hearings, we have questioned the workaround to this appointment being constitutional. And I heard today that officers of the state can be appointed 2 years in a row. I'm happy to continue the conversation because when I read TLR's foundation manual about judicial selection in Texas, they admit that all Texas judges ultimately stand for election. So I look forward to continuing that. The other aspect of our concerns that we have expressed to Chairman Murr has to do with the broad jurisdiction of the bill. And if the intent and the purpose is to truly create a business court, TTLA is willing to work with the committee to narrowly tailor that because the jurisdiction, again, is pretty broad. Some of the issues and concerns that we brought up have to do with, for example, a governmental entity, let's say a state agency, can unilaterally do a power sweep and invoke jurisdiction without consent of the opposing party. And that lives in section 003. The motion to remove or a business being allowed to just from the outset file a case in business court. If we're going to talk about unpredictability, if we're going to talk about increasing costs, every motion to remove could potentially have a motion to remand, which could potentially lead to appeals if this bill is not narrowly tailored to capture truly business court issues. For example, UIM claims involve declaratory judgments many times, and DEC actions are within the jurisdiction of a business court. And so uninsured motorist cases are also a part of, could be a personal injury case. And if they end up, not all lawyers are going to read this statute the same if it becomes one. Not all judges are going to interpret it. And so cases could be removed, and even with the threat of sanctions, again, that's inviting more litigation. That is increasing the costs to keep cases out of the business court that truly do not belong there. So unless we specifically exclude cases like UIM, like Insurance Code 541 and 542, which we have talked about, then I see that judicial efficiency and judicial economy would not be met moving forward. So I see that my time is up. I do have some other concerns, but I'm willing to continue working with Chairman Murr and the committee to allow Texans to either have the option or the choice to move into a business court, or at least narrowly tailor it so that many of our cases don't land there.
Chairman Murr.
First, thank you. For all those, my door has always been open to anyone that's interested in talking about the bill, both solo practitioners and stakeholder groups. And so we have met numerous times, and I'm confident that we will continue our dialogue. You said you had a couple of other topics that were of concern to you. I would like to hear them, if you don't mind sharing.
Absolutely. Well, a couple of them are, again, the overbreadth of the jurisdiction. Every contract claim that's $10 million could land in this court. Now I think it's been expanded in the substitute as commercial transactions, which isn't, again, completely defined. And one of the major concerns as well is the section on remote proceedings and remote jury trials. And TTLA has always stated its position that we are opposed to mandatory remote jury trials. We know that the Texas Supreme Court has amended the Texas Rules of Civil Procedure after weigh-in by many stakeholders. And the bill as written does not track the language of 21D. So with 21D, a mandatory remote jury or a remote jury trial could be tried by consent of the parties. This language allows for there to be good cause shown, and a court could order a remote jury trial. So that is just one example of some of the concerns, and I'm happy to continue the conversation once committee is over.
Thank you for sharing those. I appreciate it.
I had a couple questions. I want to kind of walk through and go through, we've talked a lot about the election of judges.
Right.
We've kind of fleshed that out. But I want to talk, kind of spend a little bit more time talking about the jurisdiction of the bill as a whole, and some of the concerns that you raise about that. Because to me, this seems like very broad as well in terms of, especially what we've already highlighted, just an open-ended threshold of monetary damage. But walk through, if you would, some of the other jurisdictional issues that you see with the bill. And I'm curious more about the declaratory judgment aspects of personal injury practice. We frequently have to sue insurance companies for DEC actions. How do you reconcile that inconsistency in this?
Sure. So I want to be, again, full disclosure, there was some language in the bill that stated for similar purposes, which is the big hole that you could drive a truck through, and that was removed. So that was helpful. But then the issues pertaining to insurance code and uninsured motorists, where there could be a case that involves a DEC action that could be in excess of $10 million. And if that is severed, or even if it remains together with a personal injury case, could be removed to the business court. And then at that point, any kind of, for example, unfair settlement practices, which lives in the insurance code, it would be individual versus insurance company, or it could be a business versus their own insurance company, a first-party insurance case for property damage, a construction defect for a commercial business, having their commercial building not constructed to code, for example. All of those could end up living in this business court. So if the purpose was to be a rocket docket, it could end up being clogged docket. And that is one of our main concerns.
Is one of the concerns also just the nature of the parties? A lot of folks have talked about businesses need a place to resolve business disputes. But what happens when one of the parties isn't a business? You're just a single person.
Well, and that's why I think we have discussed talking, at least if we could leave it to business on business versus individual versus business. And I know there's a debate on both sides, but we also had the opportunity to discuss alternatives with Chairman Murr about business on business within the existing court structure. And we're willing to continue visiting on those alternatives.
And what are your thoughts on the removal process? Do you have any opinions on whether or not it would improve the system if it was by consent of both parties versus one party unilaterally being able to access this?
Right, and it does remind me of federal court quite a bit. But again, when we're talking about the governmental entity, that's just a unilateral where they can invoke jurisdiction as a concern. I know that it says the judge shall remand, but again, there has to be some litigation to get there. There is also a new provision within the committee sub that where a judge can, upon its own, his or her own order, move the case. into business court.
And that would be without the consent of either party.
That is correct. And there's not a clear mechanism of, other than a motion to remand back to that trial court judge, how to deal with that aspect of it. So there's a number of concerns, but I'm hopeful that we can work through it. Even if the portion of the elected judges is not fixed, at least TTLA can serve as a resource.
Thank you. Members, any other questions?
Thank you.
Okay. Chair calls Mark Grotfeld.
Close enough.
And you are here on behalf of yourself testifying against the bill. Is that correct?
Yes, thank you, and again, thank you very much
Please proceed.
for allowing me to speak today. My name is Mark Grotefeld, or maybe move that a little bit. My name is Mark Grotefeld. I'm a practicing attorney. I've practiced over 40 years. My specialization, if you will, is mainly involved with catastrophic loss scenarios, where I've represented and continue to represent individuals, businesses, and insurance companies in those matters. So for purposes of my being here today, it is not to talk about the theoretical, it's to talk about the practical aspect of the language of this bill, and what I see are conundrums contained within this language that make it really an inefficient and inappropriate bill to pass at this time. And I'll start from the appellate practice area, because this deals with creating a court of appeals that would deal with government cases involving the government. Question I've posed to the panel is, what happens if the issue is whether or not an entity is a governmental body? Because, and I'll lay out a little hypothetical scenario. Party sues another entity claiming they are not a government entity, that they are basically a business, a 501c3. And the defendant says, no, we're a government entity. There's a Court of Appeals decision on the record saying that entity is not a government entity. But a district court judge would say, okay, I'm going to grant the pleaded jurisdiction for this defendant claiming that they're a governmental entity.
Madam Vice Chair, I don't know that there's a specific Court of Appeal bill that we'll hear later, but I just want to make sure your testimony is about HB 19.
As it would relate to the creation of the court, and in terms of...
Thank you. I didn't interrupt your time.
Yeah, where these matters would be brought. So the question would become, at that trial court level, depending on how that pleaded the jurisdiction is resolved, be it, yes, this is a government entity, or no, it's not, where does that appeal go? And that's not a theoretical case. We're talking about ERCOT and Winter Storm Uri, where there's a Court of Appeals decision on record saying they are not a government entity. There's a pleaded jurisdiction that was recently granted by a trial court judge saying they are a government entity. Where does that appeal go? Under this language now, it's confusing. And so, because we haven't decided whether they are a governmental entity or not. Secondly, I want to talk a bit about a scenario involving clients that I represent from time to time, subrogating insurers, and talk about a catastrophic loss where there is an event that both people are hurt, property is damaged, insurers have paid insureds have uninsured losses. They pursue recovery against a business entity who in turn says that there's another business entity. I'll wrap this up quickly. Another business entity, I think I had a little question in there, so I get a little more time. Another business entity on a contract basis. And now with the language of qualified transaction, which is fuzzy, it's fuzzy. What is a qualified transaction that could potentially pull that contract action out and away from a catastrophic loss case scenario where a local community has been completely devastated by virtue of an event, and potentially an out-of-state business may be able to pull their aspect of the case out of that local trial? I'm not talking about a theoretical case. I'm talking about the Bastrop wildfire, because that's exactly what the scenario there, where Blue Bonnet Electric Cooperative, which was sued by entities, brought in, and others have brought in, Asplin Tree Expert Company, a Pennsylvania entity. Now, there again, we would be splitting a case, as Mr. Harrison talked about before. We could be splitting cases. We would have different testimony, different separate discovery in separate courtrooms and separate trials. None of that, again, with the language of this bill, makes sense.
Thank you. Members, any questions? Just so that you're not completely rushed out of here. So on the Bastrop fire case, what you're saying is that would be a similar scenario as the previous person testified about the West explosions, when you have really complex, comprehensive, catastrophic loss across a broad range of a community. You have a variety of different injuries, a variety of different claims, a variety of different dollar limits. And so part of the claims could be triggered by this bill and part of the claims would not. And that would lead to a disparate judicial outcome possibly.
That's exactly correct. And I've heard, folks with differing opinion than mine saying that all we're talking about wanting is specialization. But there's no specialization in a business court relating to a catastrophic loss scenario where you're talking about all these different parties being involved and it all juxtaposes together. I mean, a subrogating insurer stands in the shoes of its insured. If you would separate out the subrogating insurer from the insured, you're splitting a cause of action, not a claim, a cause of action. You can't do that. You must keep them together to pursue the recovery jointly. You can't split their causes of action. It's not allowed. And,
Right,
and that would create another issue.
We haven't even talked about what happens if you have a responsible third party or contribution or indemnity claim against a non-party defendant or party, right?
Exactly.
Members, any other questions? Thank you. Okay, great panel. We have another panel. Chair calls James Holmes, John Sullivan, Judge Moyer, Paul Freeland. Are we missing one?
I think Mr. Breland.
No,
I'm sorry.
Freeland's on this end.
Boyer.
Hey, who are you?
Sullivan.
So we're missing Mr. Holmes.
Sorry.
Is James Holmes available? Okay. Shall we register him as not testifying? Okay. Okay, Chair is, Mr. Holmes. You're back.
Apologies.
Okay. Chair calls James Holmes, and just for the record, you are testifying on behalf of yourself in support of the bill. Is that correct?
Yes, Vice Chair.
Please
Thank you. Thank you all for allowing me to come express my views about this important legislation today. My name is James Holmes. I'm a businessman and attorney in Dallas, Texas. I was born and raised in this state and have built my entire life in this state. I went to UT Law School, after which I clerked for the Texas Supreme Court in the mid-90s as a judicial clerk. My practice has always been in smaller firms. Therefore, I've done a mixture of trial and appellate work. So in my cases, I'm the trial lawyer and the appellate lawyer, one-stop shopping. I do a mixture of transactional work and courtroom work. I represent big and small businesses and business people, and I've done a variety of commercial litigation as well as injury and death cases, defending and bringing as a plaintiff or defense lawyer. Only because it has kind of come up somewhat in the background of some of the questions I have in the past voted for and raised money for, and will continue to vote for and raise money for judges of both parties at the trial and appellate level. With that background, my 30-year career convinces me that Texas badly needs a business court because too often in commercial litigation, actually, in the vast majority of commercial cases, a simple contract dispute over a relatively small sum becomes the false basis for extra contractual theories and claims which carry punitive damages. This takes a contract case and turns it into a protracted legal dispute over tens of millions of dollars. Usually after 6 to 10 years of costly trial and appellate litigation, most of the extra contractual theories and claims fail under legal analysis and are therefore dismissed, but at what a cost and delay. This very pattern I've described has caused the following cases to become more protracted and expensive for litigants and for state resources than each case ever should have been. Energy Transfer Partners v. Enterprise Products, 593 Southwest 3rd, 732. Stevens v. Three Finger Black Shell Partnership, 580 Southwest 3rd, 687. Allen v. Devon Energy, 367 Southwest 3rd, 355. By way of several different jurisdictional hooks or grants that are in the bill, each of these cases would have been in a business court for the benefit of the litigants, state resources, and business communities of Texas. One final point, having done my fair share of litigation where there's an insurance policy involved and one of the defendants is insured and has insurance defense counsel involved, that's typically the scenario with a death or injury case. And then cases like these commercial cases that hopefully are going to be in a business court, which are self-insured. One litigant is trying to dig out of another litigant's bank account hard-earned money, life savings in some cases. There is no more contentious litigation than commercial litigation. I'm flabbergasted, having done this for 30 years, the extremes to which the parties will go to fight hard on these cases. And they always part on bitter terms with nothing but bad feelings. If there is any way to shorten the life of these cases so that they're not 6 or 10 years, they're 2 or 3, are there any way to give more certainty to the litigants about how these cases will turn out, please do it. Thank you for your time.
Thank you. Members, any questions? All right, thank you, sir. Chair calls John Sullivan. We show that you are registering on behalf of yourself in favor of the bill. Is that correct?
That's correct.
Please proceed.
Thank you, Madam Chair, Vice Chair. My name's John Sullivan. I've been a lawyer for about 40 years practicing civil litigation in the states of Colorado, Oklahoma, and Texas, predominantly in Texas. For about 30 years of my career, I was in-house litigation counsel for Texaco and Shell, managed litigation in pretty much all 50 states, foreign countries, a lot of different places. And in a lot of different states, there are business courts, complex litigation courts. Texas is a notable exception of not having that type of court. In the states where I've experienced business courts and complex litigation courts, litigants and people who've been before those courts have generally been pleased or somewhat satisfied with the way the courts conduct business on the cases that come before them. Most of my practice today is in Harris County, and I just looked, I didn't know this before today. There are 24 civil district courts in Harris County, and so far this year there have been 18,500 civil actions filed in Harris County. In any one year, there may be upwards of 100,000 cases filed in Harris County, split between 24 district judges. Commercial disputes are not the majority of the cases that are filed. Most of them are injury cases, mortgage foreclosures, things of that nature. But these giant commercial cases take an inordinate amount of time and require an inordinate amount of judicial resources to decide and to process. These cases can take weeks, if not months, to try and resolve. And that takes the more routine cases, the car wreck cases, the slip and fall cases, the other kind of cases that come before the courts out of the system. And the way it works in Houston is every month there's a 2-week docket, and on that docket there can be up to 150 cases. If you look at the docket, at least 85 to 90% of those are going to be injury cases. So if you have a giant commercial dispute that's on the docket that goes to trial, every one of those cases has to be kicked over 6 months or a year. And individuals who are injured due to the fault of another, no fault of their own, their cases can take years to be brought to trial. And so it's a question in my mind of resource allocation. These big commercial disputes being put into a separate court really doesn't penalize the average citizen. If anything, it benefits the average citizen because it allows their injury case or whatever their matter may be to come to trial sooner and to be resolved more quickly and at less cost. And with that, that concludes my comments. I ask that the bill be passed. Thank you.
Thank you. Members, any questions? Okay. Chair calls Judge Eric Moyer, and we're showing that you're here on behalf of yourself and testifying against the bill. Is that correct, sir?
That's correct, Madam Chair.
Please proceed.
Thank you very much. Good afternoon, ladies and gentlemen. My name is Eric Moyer. I'm the presiding judge of the 14th Judicial District Court of Texas, sitting in Dallas. I've been practicing commercial litigation, business disputes, and being a judge for 44 years. I'm opposed to this bill. This bill flies in the face of two of the most basic tenets of the Texas Constitution, which we have all sworn to uphold. Section 1, Article 1, speaks to the preservation of the right of local government. This bill eviscerates that right as far as the judiciary is concerned. Article 1, Section 2 reaffirms the notion that political power is inherently placed in the people of the state. And this bill shifts that power to choose judges from the people to a single individual, the governor. This bill is anti-democratic. The practical effect of this bill is to strip from Texas citizens the fundamental right to vote for the elected officials with whom most citizens interact the most. Not legislators, certainly not the governor, but judges. Texas has a long and honorable history of jealously guarding the right of people to participate in representative government. This includes, of course, choosing for themselves representatives every 4 years, the individuals who will preside over the courts of each of the counties of Texas. This bill violates, I believe, Section 5, Article 8 of the Texas Constitution, which grants to the district court judges the right, the jurisdiction over the cases that they hear, taking any category of these cases from these judges and placing them in the hands of judges selected by the governor, I believe is unconstitutional. Significantly, business court creation removes and insulates the judges from the citizens in the counties in which they serve. Currently, any entity doing business in any of the far-flung counties of the state are required on occasion to defend themselves or to prosecute their cases there. Significantly, this also includes the rights of citizens in the state of Texas to serve as juries in these places. One of the troubling aspects of this bill is the provision that permits the parties and the judge to move a case from one place to another case. Citizens serving as jurors lose their fundamental right to make decisions for their communities. The legislation can also be construed as an attempt to prevent and regress from a diverse judiciary in the state. Most significantly for legislators, separation of powers is severely impacted. We are moving from 3 co-equal branches of government to a system where one individual controls one branch and selects significant members of the third branch. A friend of mine sitting on the other side of this building said that optics matter. What you do not only needs to be right, it needs to look right. It looks from this bill like you are taking the rights of citizens from some parts of the state away. I encourage you to reject this bill.
Thank you. I'm just going to have a little personal privilege. Since I practiced before Judge Moyer, I want to make sure that you have plenty of time, sir.
Well, in that case, let me say a few more words.
I would hate to be cut off next time I'm in front of you, sir.
Never, never.
But I do want to go back and because you brought up some different aspects of some of the constitutional challenges that we haven't really explored this today. And I wanted to have you elaborate on those, if you would. The separation of powers, that's an argument that has not been brought up. Can you just talk a little bit more about that, please?
Sure. The state, as I understand, the government works with three separate, distinct, and equal bodies. The executive branch, driven by the governor, the legislative branch by you, ladies and gentlemen, and the judiciary. Each acts as a check on the other two branches, and each is checked concomitantly by the other two branches. If you have the governor himself or herself choosing members of the judiciary, it's a little bit of what we used to say in my own neighborhood was a thumb on the scale. You've got the governor dominating the executive branch. You have a trend developing with the governor influencing improperly, in my opinion, and ultimately perhaps dominating the executive branch. The judicial branch, which means at the end of the day that only you will be standing against an executive with power over two of the three ostensibly co-equal branches of government. If I were a legislator, that would be something that would concern me greatly.
And then how does that work if the state's a party?
I'm sorry?
How does that work if the executive branch is a party to the case?
I would not want to be in a case where the governor had chosen the judge, just as I'm sure no litigant would want to be in a case where the boss of my household, my wife, who was a lawyer, were trying the case in my court. The optics of that look bad. Now, fortunately for the judiciary, our Code of Judicial Conduct prohibits us from being in that position. But it would be difficult for me to see any elected judge, any appointed judge, a judge appointed by the governor who served at the pleasure of the governor in 2-year increments, to do anything that the governor might find some dissatisfaction. And someone spoke earlier today about the length of cases and how long cases would move. I promise you, if we layer on the issue of whether or not a case is properly in my court or in a business court, and that case, one judge makes a decision that is appealed, that may be appealed to the Supreme Court, that's going to add another year to 18 months of litigation in cases where I would suggest it's not necessary. So the notion of making cases move more quickly, I think in theory is fine, but as practicality would not be the case. That great philosopher Yogi Berra said, in theory, there's no difference between theory and practice. In practice, there's a huge difference between theory and practice.
How long have you been on the bench, sir?
I was first appointed by Governor Richards in 1992 to fill an unexpired term, which ended in 1995. I ran for the 14th District Court in 2008 and have served consistently since then.
And so this bill contemplates that you're not qualified or able to appropriately hear complex business disputes, doesn't it?
If that is indeed the case, I think the citizens of the county in which I'm elected should be the ones to make that determination.
Right. I was also very intrigued in an aspect of your testimony about the constitutional rights of judges to do their role, as well as the constitutional rights of juries to do their role. Can you please expand on that?
Sure. If a case is filed in Dallas County citizens should be the ones to try that case. If that case is removed to a business court and the parties or the court or a combination thereof decide we'd rather try this case in Harris County or in El Paso County or Bexar County or any of the other 256 counties, 54 counties in the state, the citizens of Dallas County lose their right to make determinations about an issue which in terms of venue, properly should be decided in Dallas County.
Can you, this is something we haven't really discussed much, but, you know, one of the aspects of this bill, though, this would contemplate appointing judges to a business court who've never been a judge before. Isn't that right?
I didn't see anything in the legislation, and I stand to be corrected, that said that the governor had to appoint people who had served as judges for X period of time.
Can you just give the committee a little bit of understanding of the training that judges go through?
Sure. Immediately post-election, judges are required to go to the College of New Judges, where I have served on the faculty myself, put on by the Texas Center for the Judiciary. They do a very intensive 4 days of how to be a judge. Fortunately, in Dallas, myself and 2 other judges do a similar course immediately after judges are elected in order to prepare them for what they do. And a good number of us spent a lot of time mentoring people who are newly elected to the bench. I have personally had at least 7 or 8 of the 13 sitting district judges actually sit with me after their election prior to their taking office and actually try cases, seeing how we do what we do.
Thank you. Members, any other questions? Representative Davis.
Thank you. Thanks again, Judge Moyer, for being here. I had a couple of questions as it relates to what goes on in our courts. One of the earlier testifiers indicated that things come before you and they don't feel like they get adequate consideration because of experience. But what the concern I had is if we were to bring in a business court in Dallas County, do you see a problem with us doing it the traditional way with regard to requesting a new court with this specialty being the court's jurisdiction and having it elected like we do a lot of other judges?
I don't see any problem with doing that. I think you would then get judges. Some judges really do enjoy doing torts, large torts, mass torts, or smaller cases. Some judges really enjoy doing business litigation. Some judges enjoy criminal work, and for all of the courts that we've got, it would give judges an opportunity to self-select and to put their qualifications out and say, I'm really qualified to try these particular kinds of cases, and I think I would like to do that. We certainly could do that in Dallas County.
So one of the other things that came up earlier having to do with the district courts is there was this discussion relative to your ability to move these cases through. And I'm just wondering, is that something that you're having problems with, or our courts are having problems with processing?
Certainly in my court, as you know, that is nowhere near a problem. We're trying 2020 and 2021 cases that are 2 years old. In any entity where you've got 15 or 20 individuals, there's some who are going to be faster and there's some who are going to be slower. So assuming that this bill passes and there are 7 business court judges, there will be some that move like greased lightning. And there will be others that move like tortoises. That is just the nature of human beings. And there's nothing that I can think of that we can do to legislate against that. Judges will move at their own pace.
Okay, and my last question as it relates to just from a practical standpoint, when we talk about these kinds of initiatives, wouldn't it make sense for your body of judges to determine whether or not there is a problem that you need to resolve versus someone from the outside not intimately involved in this?
I would think that it would be critical to engage the judiciary to find out how many more number one, do we need more judges? Number two, do we need a subspecialty for civil rights violations? Do we need a subspecialty for landlord-tenant cases? Inquiry and input of the judiciary, I think, is something that all of y'all would benefit from.
That troubled me when he said he hadn't talked to any of the district judges, but he talked to the governor's office. So I was kind of concerned about where the weight was coming from with regard to need and necessity and respect for citizens. So I appreciate your comments. Thank you so much for being here.
Thank you.
Members, any other questions? Thank you very much, sir.
Thank you.
Chair now calls Paul Freeland. And the record shows that you are here to testify on behalf of yourself against the bill. Is that correct?
Yes, thank you, Vice
Please
Chair.
proceed.
Yes, my name is Paul Freeland, and I recently retired from a partnership in Aranda Pools. For 30-plus years, we have constructed hundreds of pools throughout West Texas, and I do have some concerns about how this bill is going to affect small businesses such as ours. Over the years, our projects grew in grandeur and complexity and price range, and that path led us to a $600,000 residential pool, resort caliber pool for residents. Project went smoothly. However, upon presentation of our final draw, we learned that our client wasn't going to pay us our final draw. So after much back and forth, our client filed suit against us, demanding that we pay him over $1 million to remove and replace this pool that in the meanwhile he had been using and enjoying. We did not carry insurance to cover us in such a dispute. That turned out to be a blessing, as I'm confident the insurance company would have simply settled rather than stand up for what was right. We had no choice but to defend ourselves and our reputation, and we paid out of pocket. We tried this complicated construction case in front of a jury for 8 days with the Honorable Rodney Satterwhite, now retired state district judge, presiding over the case. I felt that he astutely handled the legal issues in the case that involved interplay between state and local building codes and whether commercial or residential building codes applied to our case. It was a complicated case. We had engineers involved on both sides. Judge Satterwhite read all the legal briefs, did his own research, and made sound and well-reasoned decisions, not only on the construction codes, but also in how to try what became a complicated case. Judge Satterwhite did not always rule in our favor, but both sides got a fair trial. Since spending 2 long weeks of my life in the courtroom with everything on the line, I have become a strong supporter of our court system, and in particular the jury system, a local jury system, and a local judge to decide local disputes. Despite our clients' popularity, wealth, and power, we got a trial with a fair, experienced, and seasoned trial judge from our community. I've heard things today that make me concerned. I know that there's a $10 million threshold, but I've already heard language that makes it sound like cases such as ours could be fallen into that case and taken into such a court. And I think that would have been devastating for our business. We had 20 employees that depended on our business, had worked with us, many of them for 30 years. And I'm afraid if we'd ended up in a court such as this, that we might not have gotten the fair shake we got locally. And for that reason, I oppose House Bill 19.
Thank you, sir. Members, any questions? All right, thank you. Okay, we have our next panel of Richard Faulkner, Lynn Hammer, Tim Newsom, and Jennifer Doan. Thank you. Okay. Chair calls Richard Faulkner, and for the record, you are here to testify on behalf of yourself in favor of the bill. Is that correct, sir?
That is correct, Your Honor. Madam Chairman.
If you must.
I've screwed up and said your lordship on a few times, too. By way of background, I'm an attorney. I've been practicing for over 45 years. My practice is concentrated in the area of international and domestic arbitration. I've taught it as a professor of law. I have done cases all over the world. I have arbitrated hundreds of cases in the United States and abroad, and I've also been counsel in several hundred more. I am supporting this bill and urge you to look at supporting this bill because, quite frankly, much of the controversies that you've been hearing are posed as to other parts of the Texas judicial system, whereas in many controversies of $10 million or more, these cases go to arbitration. There is no jury. There are no Texas judges. As my Oxford professor Menges used to say, an arbitrator can be wrong on the law, the award will be upheld. They can be wrong on the evidence, the award will be upheld. They can be wrong on the law and the evidence, the award will be upheld. And unfortunately, all too often, Texas businesses are sent to London. They aren't worried about going to Amarillo. They're going to London or Tokyo or Geneva or Paris. And if you think Amarillo's expensive, try trying a case in London. And that happens particularly in areas such as some of what you've heard relating to insurance. We all have been hearing of the various and sundry things that are problems with trying lawsuits. Quite frankly, I enjoy trying lawsuits. Used to. I'm a little old for that now. But this bill could at least advance and get Texas businesses out of the arbitration trap where they spend their entire year's profits just paying for a single arbitration. Much of my practice is devoted to salvaging the unsalvageable. And I cannot tell you how many times I've come in to try to save a Texas business that went into an arbitration and it went sideways, be it against ZTE, the telecom, that's nothing but a front for Chinese military intelligence and part of the Chinese government, or other large companies. And they get sent to these arbitrations. There are no juries. If you want to fix juries, please give us a jury trial on whether or not to go to arbitration, whether or not there's an agreement to arbitrate like the FAA does. But there are no juries. There are no requirements for a judge. The Federal Arbitration Act only requires you not have a felony conviction to serve as an arbitrator. That is not a good qualification. Most of us are, in fact, former judges and have a lot of experience. But unfortunately, we don't have necessarily in these larger cases the abilities to address them as rapidly as one would hope. This legislation is a start in the right direction. When you look at what happens all too often with arbitrations that go sideways, or they have arbitrators who do not give a damn about Texas law, at least our courts follow Texas law. I see the button, and I've spent enough time in the federal courts of appeal. I'm happy to entertain questions.
Thank you, sir. Members, any questions?
Just a comment.
Sure.
Sounds like maybe we ought to just get rid of arbitration clauses, and that, it sounds like you're trying to advocate for that, not for these courts.
You know, Your Honor, the federal government is not going to do that. The Congress has tried, and at least we stopped the arbitration of sexual assault cases, but even so, they still continue. And, you know, it has some merit in certain areas, but how many of you all know any single arbitration decision that I've made? I think you do, because you know I chaired the Lance Armstrong cases. That's the only one. It's all in secret, y'all. The courts are public. This court, any other Texas court, but particularly these courts, will be public. You will have reported decisions, and you're going to finally give trial judges the resources to do their jobs well. And if by any chance Judge Moyer can't sit on this court, change that, for God's sake, because he certainly knows how to try a business case.
Yeah, thank you. Members, any other questions? Thank you, sir. Chair calls Glenn Hammer. And for the record, you are here on behalf of the Texas Association of Business in support of the bill. Is that correct?
Correct, Chairwoman.
Thank you. Please proceed.
Thank you, Chairwoman and members of the committee. The Texas Association of Business strongly supports HB 19 for a variety of reasons. And I want to first thank the committee and the others who have testified. I believe you've had a robust conversation, so I don't want to repeat any of the good arguments that came before. But the way we look at things is Texas is now the headquarters of headquarters. We have more Fortune 500 companies in the state of Texas than any other state, and that is something that's accelerating in all parts of the great state of Texas. One of the attractive, and we've heard from great judges and justices who are doing a great job on behalf of all of our citizens and businesses, but it's the specialization that we believe would be very valuable. And from some of the testimony that we heard before, the predictability and the case law that could come with increased expertise on the commercial side, we believe could be very, very valuable. And you know, we believe that a business court in Texas would accomplish these goals within the court system and allow businesses more flexibility to focus on continuing job creation, paying their employers, and serving their customers instead of getting tied up in costly and time-consuming court battles, and sometimes outside of the state of Texas. Specialty business courts will continue to promote the growth of our economy by giving businesses confidence, knowing there are judges with the expertise necessary to deal with complex disputes among business parties. And we heard a number of people testify that a number of these cases are extremely complex and take a lot of time. And the fact is, we've seen many other states utilize specialty business courts to deal with legal issues among companies, and that has created a predictable, efficient, and fair process for how conflicts are resolved, ultimately saving employers time and money, and I would argue taking some burdens off of the system so that the system could work even more efficiently than for all Texas citizens. We thank Chairman Leach, Chairman Murr, and members of the committee for the opportunity to testify in behalf of HB 19 today. Thank you.
Thank you, sir. Members, any questions? Okay. Chair calls Tim Newsom. I show here that you are testifying on behalf of Tex Abota against the bill. Is that correct?
That is correct. And
please proceed.
To the extent we need to consider these my individual comments as well, then please do so.
Okay. Well,
certainly what I say on behalf of Tex Abota will be my personal.
Okay, just a second. We're going to correct the record here. Okay, so just to be clear, you're testifying on behalf of yourself as well as Tex Abota against the bill. Is that correct?
That is correct.
Okay, please proceed.
My name's Tim Newsom. I'm president of Tex Abota. Tex Abota is comprised of the local chapters in the state of Texas of the American Board of Trial Advocates. The American Board of Trial Advocates is an invitation-only organization of trial lawyers from both sides of the docket. You have to have trial experience, go through peer review, and be invited and then voted upon to be a member of our organization. And the reason I say all that is to give some background as to what Tex Abota is through the American Board of Trial Advocates. I come today, and the committee knows because you've received our letter, that Tex Abota, the Texas Trial Lawyers Association, and the Texas Association of Defense Counsel all signed a letter on the 17th of this month in opposition to House Bill 19. That means we have in our organizations 4,000 civil trial lawyers that represent individuals, small and large businesses, and business interests, and we have come forth as active practicing attorneys against House Bill 19. I don't think anyone else has made that comment yet. Here are some of the reasons that we have come forth to oppose House Bill 19 in the limited time that I've had. Number one, there's not been a true show or true evidence of a need for this court. Back in December, this committee issued an interim report, and in that report stated that additional study needed to be done, a pilot program. That was December. Now here we are in mid to late, now March. There's been no study. There's been no pilot program. So there's not been any data or empirical data that has been presented to this committee or through the committee to justify this sea change in creating this business court that we've been talking about here at this committee meeting today. And in fact, as the OCA, Office of Court Administration, the way that their data is assimilated, you can't tell from their data, nor has any other data been presented, that would show the number of cases that might be presented to this business court. I will talk quickly because I know I'm running out of time. My next topic was the constitutional challenges. Nobody in this room could have articulated the constitutional challenges better than Judge Eric Moyer just did, sitting in this very chair a moment ago. And on top of that, Professor Vladek, who might need to watch out for his job in case Judge Moyer wants to teach con law at UT. For these reasons and others that we articulated in our March 17, 2023 letter, Tech Sabota asks the committee to vote against House Bill 19. Thank you very much.
Thank you. Members, any questions? I just had a question. I have your letter that you submitted to the committee. And something that hasn't really, well, I want to just highlight the fact that the trifecta of Tech Sabota, Texas Trial Lawyers, and Texas Association of Defense Counsel has come together in a unified voice. That just rarely happens. And so,
Thank you, Madam Chair. And it was a collaborative effort between all three organizations, and where we got together and we discussed this bill and discussed the opposition to it. And we're all three organizations are very proud we're able to come and submit that letter to you.
thank you. I know our next witness is from Tech Sabota. Any other questions, members? All right, thank you so much.
Thank you.
Okay, Chair now calls Jennifer Doan. The record shows that you are here to testify on behalf of yourself as well as Tech Sabota in opposition to the bill. Is that correct?
Yes, Madam Chairman.
All right, please proceed.
Thank you so much. I'm Jennifer Doan. I think I testified before this committee last fall when we were hearing the comments about this proposed bill at the time. I think it was not been drafted yet by you, Chairman Murray, yet. But we are opposed to this bill. I want to tell you a little bit about myself. Not only am I past president of Tech Sabota, I'm also past chair of the section of litigation of the state. I'm also current vice president of National Sabota. So I also see people, and I try cases inside and outside the state. I also represent people that are coming into the state to try cases. We are against this bill for a number of reasons, and I think we've all articulated them in the letter that we presented to this committee. I am a member of TADC and Tech Sabota. Tim is a member of TTLA and Tech Sabota. We both represent businesses. We both represent businesses in the plaintiff standpoint and in the defense standpoint. I mainly do defense work, but we do handle in business litigation both sides. I wanted to draw this attention to this committee to something slightly different, but that Judge Moyer mentioned earlier. Optics matter. And I've presented this paper that's been written by Justice Patricia Alvarez on the Fourth Court of Appeals. I believe she's still in the courtroom. It's her thesis from Duke. And the thesis title is the legislature silencing the Texas judiciary? A comparative analysis between proposed legislative changes to the Texas judicial system and changes made to the Hungarian and Polish judicial systems that eroded their democracy. This committee, this paper that has been approved by Duke for publication is addressed to this committee. It's addressed to this Texas legislature. I've given Caden copies for everyone. It's only 49 pages. Before you vote, if there's some attachments that make it longer than 49, but before you vote on this bill and vote it out of committee, the citizens of our state deserve for you to read this. What you're proposing here is that the government set up a separate trial court for businesses only. And Representative Murr, you have drafted a bill that is very broad, and I appreciate you so much being willing to work on the scope of the bill. It's very broad as it's currently drafted. But the government sets up this trial court, it appoints all the judges, then all the appeals from that trial court are going to go, as drafted, go to the 15th Court of Appeals. which judges are also going to be selected for. And those are the type of things, if you read through history, what happened to Germany with what they appointed right before World War II. It's what drove down the democracies in Hungary and in Poland. And I encourage each of you to read this paper before you vote. I have some other comments if I could continue.
Okay, well, your time is up, but.
What are those other comments?
Let me, Chair recognizes Representative Flores.
As a 30-year practicing trial lawyer in business cases, I totally hear the comments of some of the people that have proposed and supported this legislation. And it's especially with respect to efficiency. Unfortunately, there's nothing in this bill that directs the court to be efficient or to have certain deadlines. And some of the best judges in the world can be more efficient than other judges. I just don't think this bill as drafted, that's one of the concerns of this bill, nor is it going to drive towards efficiency. With respect to the rule of law, which is what ABOTA stands for, is the rule of law, the right to trial by jury, and independence of judiciary. With respect to the rule of law, as a practicing business trial lawyer who actively tries cases, when we say that the judges on this new court will be able to write their opinions and therefore will have a body of law, we have a body of law in Texas. We have a common law here. We also have some codification with respect to the Business Act, but we have a body of law here. The judges that we're in front of do use that body of law when they are drafting jury instructions, when they're drafting verdict forms, or when they're making opinions on summary judgment, whether to rule in favor or not. I'm assuming, the same body of law that would be applicable to the business courts, although that's not clear. But for a judge to write an opinion on a case that a jury just gave the verdict is questionable whether that is appropriate and whether that would not be, again, the judge setting the facts of the law and what the constitutionality of that. I think that the constitutionality has already been addressed with respect to the judges not being elected, nor they be in the counties. I know we have been willing to work on the drafting of this bill with respect to Texas ABOTA. I do think the constitutionality could be, and when I've talked extensively to Mike Tankersley, could be taken care of if we had elected business court judges by county. Of the 254 counties we have here, maybe only 240 would need business courts. I'm trying a business court case in April with Bill Miller, whom several of you may know. He's former past president of TYLA. He's also the former chair of the technology for the state bar. He's a business court, he's a judge in Bowie County and in Cass County. He sits in the 5th Judicial District. He's an excellent judge for this matter. He would not be a judge if we have a separate business courts. And to think about the strategic gamesmanship that would be played, whether you can remove a case or you can bring a case against someone else across the state and not choose their county of choice, would be, I don't want that to be underestimated. I do encourage you, each of you, to read the paper by Patricia Alvarez. It's points that you definitely need to consider.
Thank you, and you may add Israel and Benjamin Netanyahu to your list.
Yes, yes. Thank
Members,
you.
any other questions? Thank you very much. Okay, we have our final panel. If there's anyone else wishing to testify on, for, or against the bill, please make sure you've registered. Our final panel is Amy Beffield, Megan Lavoie, and Denise Garcia. Is Megan here? Or is she on her way? Do you know? We'll go ahead and proceed, and hopefully Megan will join us. Okay. Chair calls Amy Beffield. You are here on behalf of Texans for Lawsuit Reform in support of the bill. Is that correct?
Yes, Madam Chair, that is correct.
Please proceed.
Okay, thank you. I don't want to take up too much of the committee's time. It has been a very long day so far, but I think we've heard some great testimony. And so I did just want to very quickly point to the fact that we have provided the committee with 75 letters from businesses across the state who are in support of the bill. I know you all are very busy, but if you do have time to peruse some of those letters, I think they're very impactful. We heard Chairman Leach in this committee hearing over the interim say we need to hear from businesses for the necessity of this bill. And I know Representative Moody, you mentioned, we need data. And I don't disagree with you, but the fact of the matter is we don't currently collect case level data right now at that granular level. And so by reaching out to businesses across the state, we hope that we are kind of providing some anecdata and showing that there is a requested need for such a business court in the state. So I do want to touch a little bit on the constitutionality. I have looked a little bit into this, done some research on the history of Article 5 of the Constitution and of the relevant case law. So not to bore you all to tears, but beginning in 1876 in our original Constitution, Article 5, Section 1 vested judicial power in one Supreme Court, in one Court of Appeals at the time, in district courts, county courts, commissioners' courts, JB courts, and in such other courts as may be provided by law. Then courts began to construe Article 5, Section 1 of the Constitution. And we then received some opinions saying, yes, the legislature can create new courts as it sees fit, but can it conform the jurisdiction of the constitutional courts to those new statutory courts? So the people of Texas, in their wisdom, and the legislature did pass a amendment to Article 5, Section 1 to make it abundantly clear that the legislature has very broad authority to add new courts as it sees fit. And so the text as it is now to this day that was amended in 1891 states that the legislature may establish such other courts as it may deem necessary and prescribe the jurisdiction and organization thereof, and may conform the jurisdiction of the district and other inferior courts thereto. I believe I did hear more than one witness today say that the legislature cannot transfer jurisdiction from a constitutional court to a statutory court. And actually, when this amended section did get in front of the Texas Supreme Court, they did analyze that. And we do have case law from them saying that not only can the legislature create new courts with concurrent jurisdiction with constitutional courts, they actually can, and I'm quoting directly, they can be empowered to exercise the judicial functions by the Constitution or conferred upon the district or other inferior courts within given territory to the exclusion of the constitutional courts. In other words, the effect of the language is to place the subject at the complete disposal of the legislature so far as inferior courts are concerned. Then, I think my time is up.
Go ahead, finish.
Okay, and so then shortly following after that, we had Jordan versus Crushington, which was decided in 1950, and this is the seminal case on the topic, and I believe it is very on point to the situation at hand in the legislation that we are currently looking at today, HB 19. So this case was decided in 1950, and the facts behind the case were that the legislature sought to create a Court of Domestic Relations in Potter County. This was, for all intents and purposes, a specialty court. It had specific jurisdiction. And in a way, it did take authority away from a constitutionally created court, a district court. And then the legislature further in this bill did create a board, which then appointed a judge to this court. And the Texas Supreme Court in this case, Jordan versus Crushington, first upheld the creation of the court. Second, upheld the grant of jurisdiction. Third, upheld the right of the legislature to conform the jurisdiction of the constitutional courts to this new court. And fourth, emphatically upheld the legislature's ability to appoint the judge in this instance. And again, just to quote, because I think it is very impactful, the authority given to the legislature to prescribe the organization of courts created by it certainly is authority to provide it with a judge. There is an express provision for the mode of selecting judges of every other court mentioned in the Constitution, except such other courts as it may deem necessary. There's no provision as to the mode of selecting judges for courts of that nature. The absence of any such provision evidences an intent to leave the power of appointment within the discretion of the legislature. And I feel that the Texas Supreme Court has been very emphatic on this point.
Members, any questions? Chairman Murr.
Thank you. Yeah, I was actually going to, because you mentioned constitutionality at the beginning of your testimony, I was going to ask you about the Jordan case, and you've elaborated on that, and that was in 1950. So now here we are 70 plus years later. In your review of case law and the Constitution out there, has there really been any additional cases since then?
No, Jordan is still good law and has not been challenged.
Okay, so really for most of the lifetimes, or at least every witness that said, I've been practicing law for 40 years, this has been on the books the entire time.
That's correct.
Okay. And then finally, I think you also mentioned hearing some testimony today about the question of whether matters could be handed off from a constitutional court to a statutory court. But we've been doing that for decades with everything from our statutory probate courts, which take jurisdiction away from constitutional county courts, or statutorily created county courts at law. And that's ongoing. That is something that the legislature by design has done.
That's correct. I think the 1891 constitutional amendment that was passed by the people of Texas really does show that there was an intent to give the legislature very broad ability to create these types of statutory courts that are not constitutional courts, and to conform the jurisdiction of the constitutional courts there too.
And then one other question, and when we talk about the Constitution, they use Roman numerals. I'm an Aggie, so I have to count real slow. But I believe it's Article 16 has some language that's relevant to the discussion about the terms of the judges. Could you elaborate ever so briefly on that?
Yes, and I believe Representative Moody did ask that question, and the site to that constitutional provision is Article 16, Section 30, and it does specify that if the office is not created by the Constitution, then the maximum term limit is 2 years.
And so I'm trying to address the question that you asked at the beginning, where that comes from. So the Constitution appears very clear that any office that's created shall be 2 years unless you find it somewhere else in the Constitution. So.
That's correct. And also, I think there has been some mention about the possibility of creating a new district court, giving it specialization, jurisdiction over business court cases. The issue with that is there have been a line of cases that specify that you cannot impose new qualifications on a district court judge without a constitutional amendment, and that's Dixon versus Strickland, Burroughs versus Lyles, and Ex parte LaFors.
So going down that road real quick, I know Representative Davis had theorized that if Dallas County wanted to come to the legislature and say, hey, we've done some studying and we believe that we could create a district court and have a specialization here. You just said there's a line of case law that says that we probably couldn't do that. That would, then maybe by rule or local agreement of the judges, but we couldn't impose that requirement on that judge.
Yes, there could be no new qualifications imposed upon a district court judge without a constitutional.
I really appreciate you taking the time to get into the weeds on that.
Of course, and also I do have this written in a memo format, and if anyone would like it, I'm happy to provide it to anyone that would like.
Members, any other questions? Judge Moody.
That's my
Representative Moody.
No, I've talked to my dad about this bill, but he was actually here yesterday. Just to follow up, and I appreciate collecting that information from some business folks. I think anecdotal, man, when we don't have case level data, it's something that we can look to. And in fact, we've encountered that problem, Chairman Murr, in a lot of different arenas that we're doing a good job. I don't want to say anything bad about OCA. I think they do an amazing job, but we know we can do better in gathering data, particularly when we're making shifts and changes in broad policy. And so it's something that I would encourage. It also kind of leans into one of the recommendations, that I think it was talked about earlier, that the Texas Judicial Council's folks came up with is piloting something like this, because that does then allow us to, we've got anecdotal stuff, we've got things that we can hear about, but then you start to see what it looks like when the rubber hits the road. And so what, if you could speak to, and I don't know because I haven't looked at other jurisdictions, but it's been told to me that other jurisdictions have started that way with a pilot and then moved further into having I guess, a statewide effort. What are the pros and cons of doing it that way, and wouldn't that allow us to really kind of understand and kind of flesh out those anecdotes in a more concrete manner?
Sure, and I actually, I happen to have, the TLR Foundation did write a paper in the interim on the need for specialized business courts in Texas, and it has an appendix detailing every other state's business court or complex litigation court, and I have it in Excel format here, so I'm happy to give it to you, and I certainly don't want to waste the committee's time and go through each of them, but yes, they of course, and they do vary, they do vary, widely in terms of, I will say there are no states that have a business court in which judges are elected directly to the business court. But there's, a variety. There's appointments, there's assignments of already elected judges. It's kind of a mix. But in terms of doing a pilot court, I certainly understand the desire to, take slow steps here. But I think in terms of the Supreme Court's current ability to move judges around, the Chief Justice of the Supreme Court, and if Megan Lavoie is here, she might want to correct anything I misstate, but the Chief Justice of the Supreme Court does have limited authority to assign active and former judges to serve on certain existing courts, or MDL panels, of course, would be the notable example. But the court does not have the authority to create new courts or new judges from whole cloth. And so assigning an active judge or panel to hear a time-consuming case will take that existing judge away from their current docket. And instead of having a pressure release valve with new judges, then you're kind of almost exacerbating existing case backlogs, as we know they're working really hard to get through the COVID backlog. So we ultimately feel that the power to address the functioning of the judicial system as a whole belongs to this body, and to create new courts, of course, under Article 5. And furthermore, in the absence of clear legislative direction, the Supreme Court lacks authority to unilaterally direct one Texas district court to hear only business cases, because as has been mentioned, the Texas Government Code specifies that certain cases do have to be given both primary or secondary priority. And so if they were to move them ahead of other cases without statutory priority given by the legislature, that might create an issue there.
No, and I guess that's what my point is that we have the ability to allow for that piloting in that way if we wanted to. And I guess my question is, do you think it's wise to start that way, since we don't really have, I think we should always be data-driven in what we do. And so if we don't have that data, isn't that a good way to help us gather it and build forward? I mean, what happened in Delaware didn't happen overnight. I mean, they've had stuff in play, I don't know, for hundreds of years. I mean, that system is developed over a long, long period of time. And so I guess that's what I want to drive at is there a way to understand what this would look like? Legislatively, we can authorize that. We can give the clearance to do that in a piloted way, and then we can understand what the caseload might look like if we kind of extrapolate that data. We're going to look at what the fees are when they come in, because that's how we're going to pay for the court as it goes. So it allows us to stair step into it rather than starting kind of from whole cloth. And this is one of the recommendations that I saw. And to me, when we have that lack of information, maybe that's a good way to start to address it, because we do have stories like you've shared with us where this is an issue. So let's try to see if there's a way to figure that out. I see that our chairman is back, so I bet you had a great time over there. Huh? I've been waiting to say that for hours. I'm sorry. Thank you.
We good. Thank you, members. Any other questions? All right. The chair now calls Denise Garcia.
It is.
Denise, I show you here as justice, here on behalf of yourself, and you're against the bill. Is that correct?
That's correct.
Okay, you can go ahead.
I'd like to start by thanking you all for being here as public servants. I know you sacrifice a great deal to come and represent your constituents. As an elected official, I understand that that obligation that you have and that sacrifice that you make. I'm going to address briefly the Jordan case. I haven't read it completely through. It would be irresponsible for me to try and interpret it for you. I'm just going to leave it at paraphrasing Andre the Giant at, I don't think that case means what you think it means. I would focus on looking at the Constitution. Our Constitution provides for the creation of 2 statewide courts. And it does so very specifically by saying its jurisdiction is limited to the limits of the state. With regard to the courts of appeal and the trial courts, it says their limits, jurisdictional limits, are within their districts. The framers of the Constitution knew how to make statewide courts. And if they wanted to make statewide intermediate and trial courts, they would have included the phrase, the jurisdictions extend to the limits of the state. They did not. So that's something that you keep in mind when you talk about jurisdiction. I've also heard that you cannot impose requirements on a particular district judge, district court. You do say what the jurisdiction of a court can be. And so, for example, in Dallas County, we have a number of criminal courts whose jurisdiction is simply criminal cases. And those criminal court judges cannot hear, even though the district judges cannot hear civil cases, cannot hear family law cases. There's also the way to work around and say it's a court of general jurisdiction. By agreement of the county, they will hear a particular specified court. The last thing I want to address has to deal with the idea of a split of authority in the state of Texas between courts of appeals being a problem. And I would submit to the committee that it's not a bug, it's a feature of the system. You talk about how long we have had Jordan. For as long as we've had more than one court of appeal, there's been a split in authority. And those splits of authority act to make the law flexible for the communities it serves. The law is not a straitjacket that has only one answer per dispute, or per one answer for all of the disputes. The voters in Kerrville have a different need than the voters in Houston, than the voters in Austin, than the voters in Dallas. Our Constitution set up a system whereby local voters can impose local authority and local accountability. And as courts of appeals, we have to hear every single case that comes before us. The Supreme Court, on the other hand, while it has superior jurisdiction over the courts of appeals and over the trial courts, is limited in the number of courts it can take. It cannot take all the cases. That forces the Supreme Court to take on the cases that are the utmost importance to the state, to the entirety of the state. By starting a court like this at the trial level, and let's say the 15th Court of Appeals, what you are doing is you are overriding that built-in accountability that occurs in the Constitution. Thank you so much. Again, I really appreciate all the work that you do and being willing to listen today.
Thank you, Justice. Members, questions? Yes, Chairman Mark.
Justice Garcia, just one question.
Yes, sir.
At the beginning there, you mentioned in your testimony about constitutionality, and then you stated that the Constitution only provides for 2 statewide courts, and you said because it's statewide, that is the issue that you see. Is that?
But if you look specifically at Article 5, and I think it's the sections that create the Supreme Court and the Court of Criminal Appeals. And if you look at I have the language back there. I'm sorry I didn't bring it up. I wanted to limit it, but the jurisdiction of the Supreme Court extends to the limits of the state. The courts of appeals and the trial courts do not extend the limits of the state. If they intended those courts to be statewide, they could have easily added that phrase, or may extend to the limits of the state. They did not. We have 2 statewide courts, and those are specifically created in the Constitution.
Okay. Thank you. I really appreciate you spending the time.
Thank you so much.
Yes, Representative Massoud.
Article 5, Section 7, Section 3, Section 4, all these provisions that deal with divisions of courts and the statewide jurisdiction you're referring to have not been substantively amended since, I believe, 1891. And yet the voters in 1891 amended Section 1 to say, the legislature may establish such other courts as it may deem necessary and prescribe the jurisdiction and organization thereof. But there's no qualifier in that language that says that, other courts of limited geographic scope.
It says within its district. The jurisdiction is limited within its district.
May establish such other courts as it may deem necessary and prescribe the jurisdiction and organization thereof, and may conform the jurisdiction of the district and other inferior courts, not within and of themselves, but thereto. So there's no geographic qualifier, but if your objection is to the geographic qualifier, if we removed Loving County, would the bill be constitutional?
Well, I think Loving County might be offended by that.
I would wonder that. And so
yeah.
isn't it important then that we be able to establish other courts for Loving County and the entire state? I just don't see a constitutional provision that limits the authority of the legislature to establish such other courts for the entirety of the state. I wonder, because you interpret constitutional provisions in order of adoption of amendments because you're amending the same document. And since Section 7 and 3 and 4 have not been substantively amended in those regards since 91, don't we read the amendment in 1891 to Section 1 to allow it?
I'm not going to interpret at this point. I mean, at this point, we're getting into dangerous territory for me to say much more to you. I do know that the two statewide courts that exist have authority in the Constitution, and they are very specifically named, and they are very specifically formed in terms of their jurisdiction. That does not exist for any other court that's stated in the Constitution.
I think where I struggle, and I waited till the very end here, because it's been interesting. To be honest with you, I love the Texas Constitution, and diving into it, I've never really had these arguments fleshed out before. But, when some argue that it's unconstitutional, I'm sympathetic to not passing something that's unconstitutional, but where is the authority for that argument? And I just haven't seen any. Whereas, on the other hand, the case is square on, and as I read the legislative provision in Section 1, it seems like we have authority to do this. So I don't know, are you aware of any other case on point that would interpret that, elucidate this academic discussion in my mind?
Understand, I didn't say anything was unconstitutional.
Right.
What I said is that the Constitution instructs us about how to create a statewide court. It very specifically creates a statewide court, and I'm telling you there are only two places in the Constitution where it does that.
Got it. Thank you very much.
Members, other questions? Okay, thank you. Thank you both.
Thank you very much.
Thank you, Justice. We've got a couple other witnesses who've registered to testify. Megan Lavoie with the Office of Court Administration, Jason Villalba, Representative Villalba, and Gloria Leal. If anyone else wishes to testify on, for, or against this bill, please make your way to the kiosk now. This is our final panel of witnesses. I do want to thank Vice Chair Johnson for ably leading the committee in my absence. Thank you each for being here. Representative Villalba, great to see you. My classmate and friend. It's been a while, but great to see you. I've got you here registered. Jason Villalba here on behalf of yourself, testifying for the bill. Is that correct?
That is correct.
Okay.
Thank you, sir.
Go ahead.
Well, thank you first for allowing me this opportunity. And I want to start by saying thank you to each of you for your service. I know how difficult this time of the year can be. I know how much time you have spent on other matters, but I'm just so thankful that you're here listening to the work of the people. And thank you for allowing us today to come before you to talk about an issue that we've been working on for a long time. This bill, the creation of the Texas Business Courts Bill, is important to Texas for a number of reasons, but it's an idea whose time has come. We've heard the arguments today from both sides, and both of them, many of them are compelling. I will tell you why, what the genesis of this bill was when I wrote it back in 2015. I was I was a middle-level lawyer at a law firm that practiced in the corporate M&A space. And I noticed frequently that we were seeing issues that were being moved out of the state because of the fact that we were not the preeminent corporate business state in the country. And after studying it, as we all went to law school and took corporations class for the lawyers that are up here, we know that Delaware was the preeminent state, that New York and California and Nevada and a number of other states had business courts. And I thought, well, why don't we have a business court? There was no intention to exclude people from this process. There was no nefarious idea to limit constitutional rights. My thinking was, let's make Texas better and stronger and more competitive. Let's create an environment and a robust ecosystem for companies to be able to grow and build and reincorporate in Texas, come to Texas, move headquarters to Texas, and be a strong business-friendly state that we already are. Now, Texas is known as the great business miracle, and we are for a number of reasons: lower taxes, lower regulations. But we don't necessarily compete on a nationwide or a global basis on our legal ecosystem for businesses. That was the only intent behind this bill. My hope was that we would find it to be quite simple. I was wrong. Obviously, when I tried to pass this bill the first time, we got through committee, but we never made it past there. We've tried on and on. Chairman Murr and his team have done a fantastic job of incorporating comments and concerns from other constituents. And so let me just say thank you for making this bill better. The constituencies that we've talked to, I know when we started, it was everyone from the Texas Trial Lawyers Association to TLR to the TAB and a number of other groups. We wanted to get it right. We just wanted to have best practices and do something that was good for the people. Corporations are not people, but corporations provide jobs for our families. And I wanted to make sure that corporations had the same rights that we have as individuals. So I want to stop, and if I have any questions, again, just thank you for your time today. I'm honored to be before you this morning, or this afternoon.
Thank you, Representative. Members, any questions? All right, thanks for being here. It's always great to see you. The chair recognizes Gloria Leal. Gloria, I've got you here on behalf of the Mexican-American Bar Association of Texas and yourself testifying against the bill. Is that correct?
Yes, sir, that's correct.
Okay, you can go ahead.
My name is Gloria Leal. I'm an attorney and consultant here in Travis County. I am also National General Counsel for National LULAC, but I'm here representing the Mexican-American Bar Association of Texas, which is a statewide group of lawyers with districts and chapters in most of the major cities in your districts. I'm here to testify against the bill for a couple of reasons. And briefly, I'm not an expert. You all have heard from the experts. You have the author of the bill. But I have heard the testimony since this morning, and what rises to me or is concerned to me is that there doesn't seem to be any data or any data presented that supports or justifies creation of a business court. There's no data that the current district judges are overwhelmed, lack experience and qualifications to adjudicate fairly complex commercial disputes. No data that majority of the business interests are clamoring for transfer of cases to a specialty court. I have not heard any oil and gas clients from Midland, Texas saying they want to get transferred to any statewide court. I just monitored a case where landowners sued a refinery or a gas pipeline in Williamson County, where the judge ruled in favor of the pipeline. There's no one clamoring to transfer that court that would fall under the jurisdiction to any other court. I don't hear any commercial trucking litigants in the urban areas clamoring to be transferred to a business court, or medical mal for that matter. As regard to the expertise issue, as in most complex cases, the plaintiffs, the parties in a lawsuit will bring expert witness testimony, not only to educate the judge, but maybe the jury, and also for preparation on appeal. And the fact of the matter is that most cases now, complex or even smaller, are preparations for appeal. That's just part of the process. I'm also concerned that, except for the testimony of District Judge Moye, who I did not hear, there has been no testimony from any or very few district judges that who stand to be impacted most from this litigation or from this legislation. I have talked to them. On numerous occasions. I will wrap up, sir. And they are not overwhelmed. They're willing to tackle these cases, and they're not willing to have disputes that originate in their jurisdiction be transferred out of their jurisdiction. Finally, of concern to LULAC and the Mexican Bar Association is the potential for dilution of minority voters. The last census said attributed 95% of the growth in Texas to the Hispanic and minority vote, and this presents an opportunity to dilute the voting power of Latinos and minority in Texas by removing their rights to elect a judge of their choice to litigate these type of issues. Thank you, sir. I will be happy to answer any questions.
Members, any questions for the witness? Okay, thank you for your testimony. The chair recognizes Megan Lavoie, Office of Court Administration. Megan, I've got you here on behalf of the Office of Court Administration testifying on the bill as a resource witness.
That's correct.
Okay, go ahead.
Good afternoon, Chairman and members. My name is Megan Lavoie. I'm the Administrative Director for the Office of Court Administration, here as a resource testifying on this bill. I know there's been a lot of questions about data. We are moving towards collecting case-level data. I know this committee has heard a lot about those efforts. There is currently funding in the introduced bill for a new case-level data system for the Office of Court Administration, which we're really excited about. And also there's some discussion about the Texas Judicial Council, which is the policy-making body making recommendations for a pilot business court. They have done that twice in the past, and how the council envisioned that working was having active judges or visiting judges staff those dockets. Happy to answer any questions you have.
Members, any questions? Representative Davis.
Thank you. You mentioned that there'd been pilot programs that had previously been suggested for these courts in your last couple of statements. What happened to those recommendations?
The recommendation was to the Supreme Court to create a pilot business court. There were efforts right before COVID to make that happen. Then obviously the pandemic happened, and creating a specialty court during the pandemic was not the optimal during that time. So
that was the only one, or was there? Did you say there were two? There were two times in which there was a recommendation for this. What's the other one?
Was this past year. So this Judicial Council makes their recommendations usually in the fall, right before the legislative session, and they again made that recommendation this past year.
This is a result of that recommendation, and it's probably not a question for you, but I'm just wondering, is that how this bill came forward?
It is not.
Okay, so this was not a recommendation. You did not do this based on a recommendation. Okay, thank you. Just wanted to understand that.
Chairman Murr.
Just real quick, we've all been here a long time and appreciate that, but I wanted to point out, and I think everyone generally knows, that the Office of Court Administration is sort of the repository for collecting data, and that data typically is driven by the work of our district and county clerks throughout the courts. And so a lot of data gets collected, but the process is typically set out by the legislature. And so some of the topics we've talked about today, we've never requested that folks delve into that level of data. I wanted you to clarify and agree with me that we just don't collect the kind of data that some folks have been interested in hearing more about.
That is true. Right now, the Office of Court Administration doesn't collect any case level data. We only collect aggregate data, and it gets dumped into buckets. So oftentimes, each bucket will have maybe 5 or 6 different case types in it, and there's no way for us to segregate out that information. There are some provisions in statute that require the Judicial Council and OCA to collect data. The Judicial Council also does have the authority to require certain data elements to be collected by the county and district clerks.
And historically, a lot of the data collection that we've gone through has been for criminal offenses, or more recently, guardianships and similar cases, to determine not just case load, but to determine additional needs that the judicial system might need from the legislature. So here we are without all of the information we'd like to have. And I guess I point out that it's through no fault of the OCA to do that. That's important. That's on us, right? So thank you for your time today.
Thank you, Representative.
Members, any other questions? Okay. Thanks to the entire panel. Thank you. Does anyone else wish to testify on, for, or against House Bill 19? Seeing none, the chair recognizes Chairman Murr to close on the bill.
Mr. Chairman, I think the term that we would use today is robust conversation. There's been a lot of interested parties that have offered years of experience, both for and against. My door remains open for those that want to talk further, and I appreciate the opportunity to visit about the detailed committee substitute that we had before us today.
All right, thank you, Chairman. Are members any questions for the bill author? Okay, seeing none, the chair will withdraw the committee substitute to House Bill 19 and leave House Bill 19 pending at this time. Members, for your planning purposes and for the benefit of our witnesses as well, the plan is to right now take up very quickly Chairman Canales' House Bill 2310. Chairman, if you want to come down, and then after that to go back to Chairman Murr with his House Bill 3166. This bill only right now has 3 witnesses, and then Chairman Murr's House Bill 3166 currently has 17 witnesses. Of course, we've got a heavy agenda today. After that bill, each bill only has a couple, 2 to 4 witnesses per piece. So that's the current plan for your planning purposes. The chair now lays out House Bill 2310 and recognizes Chairman Canales to explain the bill.
Thank you, Chairman Leach, and I appreciate your busy agenda that you've got. So I've got all sorts of talking points. I'm just going to kind of lay it out the way it really is. So my personal life, I'm a trial lawyer. I was from early 2000s, I'm a member of the Texas Trial Lawyers. I love the law. I love being able to redress grievances in court and do so in a civilized manner, and I think that's the way the judicial system works. My bill is brought because of what is transpiring in South Texas, and I believe is proliferating throughout Texas, and it's really hurting a lot of small business owners and a lot of and construction in general. The situation is this. People sue for a construction defect, a lawyer sues for a construction defect, and they name every single subcontractor that was there. So if the problem has to do with the roof, the guy that installed the sidewalk gets sued too. If the problem has to do with the sidewalk, the guy that installed the window got sued. And so the reality is this, those subcontractors are the little guys, and they're having to pay the premiums and advise their insurance carriers, and their rates are going up. And we've got to a point in South Texas where I'm at where it's hard to even get some people to bid on schools because they can't get bonded. And so what my bill seeks to do is tell lawyers, sue who you're supposed to sue. Sue who the person that screwed it up. Sue the right person. And so it has a lot of parts to it. I'm the one this is my idea. I've seen it. It's going on. And the effort is to put a stop to it. I've worked with members of the trial lawyers. I've worked with TLR. I've worked with engineers. I've spoken. And this bill, I believe, is in good form. But I'm not opposed to working with everybody to try to get to the problem, which is we don't need to be suing people and putting small businesses either out of business or in jeopardy of losing their business when they had nothing to do with the problem to begin with. And so this is an effort to clean up every industry has what I call bad apples. And I'm not saying that there's a lot of lawyers doing this, but there's some that have made a cottage industry out of doing this, and it's really hurting communities, and it's really hurting the state of Texas. It's really hurting us all. And so I'm willing to work with anybody to make this endeavor happen, because it's high time that we quit dragging people into court that don't need to be there.
Thank you. Thank you, Chairman. Members, any questions? Okay, thank you, and you've reserved your right to close, I assume. There's 3 witnesses who've registered to testify on this bill. I'm going to call 3 of you at the same time. The chair recognizes Lee Parsley, or the chair calls Lee Parsley, Craig Island, and Jennifer Fagan. Is Jennifer here? I know she's on her way. And so, Jennifer, if you're listening, hurry. Lee, let's start with you. Lee, I've got you registered as here on behalf of Texans for Lawsuit Reform, testifying for the bill. Is that correct?
That's correct.
Okay, you can start your testimony.
Good afternoon. Lee Parsley for Texans for Lawsuit Reform. We are in favor of the bill. Chairman Canales outlined the problem as we see it, which is often in construction cases, every subcontractor, the architect, the engineer, all get brought into it with the idea that we'll just sort them all out later in some giant mediation process. The bill itself does really 4 things. It requires that anyone pleading in a construction defect case, a claim, has to do so with specificity. It then says that if you are named as a defendant and the pleading is not specific as to you, how you could be involved, you can move to dismiss the claim at that point. If you're a defendant and it does tell you, it does plead with specificity, and you can then present evidence that says, I could not possibly have been the person who caused this defect, you can move to dismiss on those grounds. And there's a sanctions element to it if you move to dismiss when you shouldn't. And so I think it's a very balanced bill in the way it's crafted. I don't think any of those elements are new in any sense. Right now, you could file a special exception, but we don't require specific pleadings, so the special exception practice doesn't work very well for this. You could file a motion for summary judgment, but the motion for summary judgment practice comes at the very end of a long discovery process, and the idea of this bill is you can file either one of these motions to dismiss really early in the case and try to be done with this litigation. And we think it's just a procedure that deserves, for our courts to try it, and it does not require anything to happen beyond the specific pleading in the outset. After that, the motions to dismiss are optional. You can just rely on existing procedures if you want to. So again, we fully support the bill. I think it's a great idea.
So, okay, members, any questions? Yes, Vice Chair Johnson.
Oh, good Lord. So you're completely changing the notice-based pleadings that we've have in Texas under this bill?
It would change notice-based pleadings in construction defect cases, correct?
And then okay, so you're a homeowner and your roof falls in, and you don't know if it's the roofer, if it's the framer, if it's a plumber who has a leak, if it's the contractor, and you're not giving them any time to do any discovery to figure out what happened and before their claims get.
Just to clarify, this does not include residential construction, correct?
I believe this is commercial.
This is only commercial. Residential construction will be covered under rec law.
Okay, well, let's say you have a commercial building and you own a building.
I just wanted to clarify. The point remains, but I wanted to clarify that this does not apply to residential.
I'm going to become a real estate mogul, and I'm going to go buy a building, and the thing falls apart somehow. And I am not a construction expert. I just own the property, and how am I supposed to know? I just know my roof fell in when it's not supposed to fall in. And, actually, I had a case one time where an apartment balcony fell off, and a man fell down. And I don't know why the balcony fell off. I just know it's not supposed to fall off. And so how are you supposed to plead with specificity when you haven't had a chance to conduct any discovery?
Well, my answer to you would be that discovery is not how you figure out what your construction defect is. I am a commercial property owner. Many people are. If the roof falls in on my apartment complex, I have to hire people to go out and fix it. And by the end of that process, I've got a pretty darn good idea why the roof fell in, and I know who to sue. I mean, the answer is very few commercial property owners, I think, are so ill-advised about their property that they don't know what it is that's caused the problem. And even if they are, in order to fix the problem, in order to get your tenants back in, you're fixing the roof and you're figuring out what's wrong with it. So discovery can help you discover things at the end of the process, certainly. But in the construction litigation business and for commercial property owners, I don't see these people as being so ill-advised about their own property that they can't, by the time they file a lawsuit, state with some specificity what it is that happened and who it is that owes them money. The games players are the problem in this business, and that's who I think Chairman Canales is after. It's those people who intentionally go out and conduct some investigation, they call it, of a piece of property, and then they just sue everybody they can find because they are trying to create litigation. They are trying to create a mass litigation. And those are the people this bill is going to address. But the legitimate property owners who go out and fix their roof and have a contractor do it, I think are perfectly capable of pleading their case at the outset. And I think they do today. I don't think this injures them at all.
But you would agree with me that this wholesale changes dispositive motions the timing of dispositive motions through the discovery period in a lawsuit.
Yes, if the defendant elects to use it, it changes the process. That's correct.
And, I mean, I agree with this concept that frivolous lawsuits benefit no one.
Right.
And that we should have reasonable mechanisms to dispose of abuses like that. But we do have those. You have dispositive motions. I mean, rather than, because basically, under this bill, somebody would have no opportunity to conduct any reasonable discovery before essentially dispositive motions are filed on their case, and which would wholesale upend the normal flow of civil litigation as we have it in this state. I mean, why not create some sort of a dispositive vehicle, you know, not necessarily 30 days before trial or 60 days when you have summary judgment deadlines, but after a reasonable discovery period and or something like that, but just wholesale preventing parties from conducting discovery before their case is dismissed seems really out of line with the way our current system is set up.
Well, I view Chairman Canales' bill as saying this, that a defendant could move to dismiss based on the fact that the pleading is completely insufficient as to that person. You've been named in the case, but it is just so broad that you don't.
Let's be clear. Every defendant is going to file a motion to dismiss.
But
it would almost be legal malpractice not to. Every single one in this case.
And there's a mandatory sanction provision in there to address that. So the mandatory sanction provision, I think, offsets that. And that motion to dismiss is not on the merits. It is just a procedural motion. So the the plaintiff figures out later that this person should, in fact, be in the case. They can rejoin them in the case. So it is essentially just a special exception practice. The difference is that it's based on a pleading that's actually supposed to give you notice now. So I don't have any objection to what you're suggesting Chairman Canales' bill should do, I guess. I just think that's up to Chairman Canales about whether you and he agree on a different procedure. I just think this procedure works.
Does the bill contemplate the court having discretion to continue to allow discovery for pleadings before dispositive motions on this? Does this give the judge discretion to let the parties conduct discovery?
It does not. But on the other hand, it does something that's unusual, which is it says if that defendant gets out on the second motion to dismiss, that the plaintiff can bring that defendant back in the case. Got a year period. So conducting discovery and you realize, oh my gosh, that person shouldn't be out, you can bring them back in the case. So no, it does speed up the timeline, but it's not a speeding up of the timeline as I read it that is unilateral. It's not just one-sided. Chairman Canales has said you can get out pretty quick, but you may get brought back in if you sort of lied about it. If you presented documents and said this was not me, and it turns out it was because discovery turns that up, you can be brought back in the case. So it's not a unilateral motion to dismiss, and which seems to me has some fairness to it, that you're opening yourself, if you choose to use this, you're opening yourself up to a one-year period that you can be brought back into the case. So my feeling is that won't be used that much when people just know they're going to get brought back into the case sometime. That's not very helpful. So maybe I'm wrong about that, but that's the way I view it, is that Chairman Canales has done a pretty good job of balancing some rights here that try to get subcontractors out of cases pretty early.
Okay. Members, any other questions? Thank you, Lee. The chair recognizes Craig Island. Craig, I've got you here testifying on behalf of yourself and the Texas Trial Lawyers Association against House Bill 2310.
That is correct, Mr. Chairman.
Okay, you can start your testimony.
Thank you, and I've let my former colleague know that we will work with him to try to come up with any language if it can be, if this is going to be implemented, because what we don't want is to have trying to smash a gnat with a big hammer, where we have a few people that Mr. Canales is aware of that is maybe abusing the system, and then make it impractical for the rest of the lawyers across the state and all of their clients, because this applies to any pleading, right? So a responsive pleading by a defendant for counterclaims, cross claims, third-party claims, the same pleading requirements, which would be not notice pleading requirements, as you stated. But my biggest concern is that before there's any discovery and any disclosures, you're going to face 2 motions to dismiss without any discovery and without any disclosures. And every case will have an answer that includes a motion to dismiss, the first one. And then if that is denied, then there'll be another motion to dismiss based upon the affidavit of the defendant. And the thing that the plaintiff is supposed to do, they can have anything that is used in a summary judgment response. What do you use in summary judgment response? Documents that you get in discovery and deposition testimony, and then affidavits from experts and things like that. You won't have any of that. You could go maybe get an affidavit from somebody that's not based on any discovery. So if anything like this is going to be done to address this problem, the only thing that I can think of is 2 things. One, in a commercial construction defect case, if you sue the general contractor only, then the statute of limitations against all subs is told for a year, so that you could get discovery through the general contractor on everybody else. And then second is a relaxed Rule 202 requirements to take a pre-lawsuit deposition and discovery, relax that for commercial construction defect cases so that you can get some backup to see, because you know you're going to face 2 motions to dismiss. Go get your evidence before you name them so you can be specific. If this is the route that y'all want to go, those are the 2 things that I thought that might help, but not destroy the practice for everybody on every instance.
So Craig, under your first idea relating to the general contractor, if I'm a commercial building owner and there's a defect, I go under what you were posing, I would go sue the general contractor and then let the general contractor who contracted with the subs go find out who's responsible.
Well, I can do discovery through the general contractor, right? He'll have to have disclosures, and I'll send him interrogatories, request productions, take depositions, and then I'll know who did what, who is responsible for what. And then if I decide to bring somebody in, or the general contractor decides to bring them in, we've got a year with the statute of limitations told. If I don't bring the subcontractors in within a year, then I never can. But at least I've got a motion to dismiss, because under this bill as it is, when you file a lawsuit and you get no discovery, it does not stop the tolling of the statute of limitations. So that's another concern of mine. So my suggestion is relax Rule 202 for commercial constructions, relax it so it's much easier to do. And if you sue only the general contractor, right, toll everybody else for a year so you can get your discovery, so that once you bring in any subcontractor, you're going to face a motion to dismiss, or 2 of them, you'll be ready for it.
But if you're the owner and you're filing a lawsuit against the general contractor, you're filing breach of contract.
Construction defect.
So why wouldn't you then just focus just on the general contractor? Let the general contractor go bring in any third parties that the GC would deem necessary.
Right. That's what
I wouldn't have to go perform independent discovery. Let the general contractor go do that.
But I may want to bring in specific subs.
Why?
Responsible third parties.
No, I
because
understand,
the
but
general
you
contractor
still preserve your claim. You don't have your claim is against the general contractor.
Correct. And that's why I bring them in first. But the general contractor may not have enough assets or insurance to satisfy the claim, and the general contractor, because of business relationships, may not want to bring in their subs. And so I'm just give me the right, preserve my right to name the subs. Just let me do discovery first so I don't name the improper subs. If the goal here is to make sure that the proper subs are brought in, give me discovery at some point before I have to name them, so that if I name them, I've got this new pleading standard I've got to meet. Give me a shot.
I don't want to speak for Chairman Canales here, but I think that the problem that we're seeing here and what the bill is going at is the situation where you've got a roof leak on a commercial building, and the owner is going out and suing everybody, including the landscape architect. anyone that stepped foot on the project, anyone at all that was paid for the project, anyone at all, those lawsuits are being filed against everybody. And they've got to go incur the cost, the fees, the attorney fees, and they've got to go out and file a motion to dismiss or figure out a way to get out of it. And some courts, I know this for a fact, some courts are not letting anyone out in those situations. Is that? Members, any other questions? Representative Vasu.
I've been the defense counsel in those types of cases. Yeah, we get stuck, and you may represent one of the subs, and I'll go to all these depositions, and I'll be there with 40 other lawyers, and I'll wait till the very end. Are you aware of any actions or omissions taken by ex-defendant that caused or contributed to causing this defect? No, thank you. And we do that 30 times. Then you go try to do a summary judgment motion and try to get out. So, interesting bill. I've never thought of it approaching it this way, but I do affirm to the chairman and to the chairman that, yeah, this is an issue, and I've been in it.
Yeah, so have I. Members, any other questions? Good thoughts, though. All right, the chair recognizes Jennifer Fagan. Jennifer, I have you here registered on behalf of the Texas Construction Association for House Bill 2310. Is that correct?
Yes, that's
Okay,
correct.
Start your testimony.
Thank you, Mr. Chairman and members. Thank you for having me. Again, Jennifer Fagan. I'm with the Texas Construction Association. TCA represents subcontractors in construction, and we represent about 3,000 construction contractors in the state of Texas. We all appreciate Representative Chairman Canales' bill. We think this is a great step towards addressing the issue that, again, Chairman Leach hit right the nail on the head. I would note in response to Mr. Island's statements, the first motion is a motion to dismiss for failure to plead with specificity. So what you're really looking at is trying to get that original lawsuit, that original petition that's filed by the plaintiff to be specific enough to know who might possibly be responsible. If the judge grants that motion, before they even hear it, the plaintiff has an opportunity 7 days before the hearing to amend that petition. So once you file your motion to dismiss, they have an opportunity to amend their petition and make it more specific if they think they might lose that motion to dismiss. And then finally, if the judge grants that motion to dismiss, it's granted without prejudice. So it gives the opportunity for that plaintiff to go back and maybe do discovery and figure out who's actually responsible. So that motion is not a motion to dismiss like you're going to find in regular civil litigation. It's not, doesn't require quite as much meat to it. And it's my understanding from talking to our attorneys, and I don't practice and never have practiced in federal court, but the specificity of pleading is not uncommon in federal court. It's similar to a requirement, and I believe in federal court that's already. I'll defer to Lee on that. So,
Vice Chair Johnson.
So on the motion to dismiss, but does it also toll the statute of limitations to bring it back in? That's the problem.
There is, and subject to correction, there is a tolling piece in the bill, but I can't remember if it's on the first one or the second one. So
Craig is shaking his head no. So, if you brought a defendant that you think should be there, but you just don't have enough information at the time, and you have, because we're under notice pleading in this state, not specific pleading, and your case gets dismissed against whatever, but then in the discovery process that you were not allowed to conduct, it determines that the plumber did in fact have a roof leak that caused your roof to fall in or whatnot, but he's been dismissed. If your statute's run, you're screwed. You can't bring him back in. So there needs to be some exception to the statute of limitations on that, I think. Because
I can see your point. The problem that we're facing now is there's a roof leak, and they're bringing in the guy who did the demo. So that's a little bit more specificity of pleading. The standard, and I'm sorry, the bill, I was rushing in, the bill is in my briefcase, but the standard is that is not particularly high in that initial petition.
I agree that the gunshot approach to pleading is not good. As a plaintiff lawyer, though, I try not to do that because it's expensive to your client. You have service fees to all these defendants. It makes your cost of litigation go up exponentially to go sue a bunch of people that have no business being in your lawsuit.
That's because you're a good plaintiff's lawyer.
Well, thank you. And because it's just not, I mean, because those expenses are ultimately borne by your client. And, you know, there is a decentive to just go sue everybody because you're just wasting a lot of money that you're not, as a plaintiff lawyer, you're not going to get collected for years down the road. But at the end of the day, though, so I get that. The landscape architect should not be sued in the roof defect case. I totally understand that. But it just seems that what I've seen oftentimes in my practice is defendants there's a problem in the Civil Practice and Remedies Code by which the deadline that defendants have to designate responsible third parties can be after the statute of limitations run. And we see a lot of defendants play games with that to say, oh, we're gonna wait and file our designation of responsible third parties. And oh, so sorry, but your statute's run now, even though the case has been on file for 2 years, and now you're screwed by bringing in the responsible party. And this would make that situation even worse because you're not even allowed to conduct any discovery. So there needs to be some kind of a limitations accommodation for this to be able, because that's really the biggest issues. You're worried about limitations and you don't have any mechanism to bring in responsible third parties designated by defendants after the statute's run. And if that problem could get fixed, then a lot of this shotgun approach would get fixed, because that's really the thing, because defendants will hide behind the ball before they designate responsible third parties until after the statute of limitations is run, prohibiting plaintiffs from adding them to the suit. And that is the reason why plaintiffs get paranoid. And to avoid your own malpractice, you have to sue people because you're going to get screwed after the limitations runs on the back end. And if we could address that kind of a situation, then I think a lot of that could be avoided, because it doesn't benefit anyone to have improper defendants added to lawsuits.
I agree. Well said.
Okay.
Well said. Yeah.
My diatribe.
Members, any other questions? Okay. Thank you each. Thanks. Does anyone else wish to testify on for or against House Bill 2310? Seeing none, the chair recognizes Chairman Canales to close on the bill.
Thank you, Chairman. Thank you, members. I appreciate the robust discussion. If you've never heard of it, I will bring you some of the litigation where this is about a roof leak and the guy that installed the gate 200 yards from the building gets sued. And so I'm willing to work with anybody on this, but when you hear commercial construction, you think of these big companies or big GCs, and the reality is these little guys are the ones that are literally almost being put out of business. And so I'm willing to work with anybody on making this a reality, in the sense that we've just got to get the right people named. I don't want to jeopardize somebody's claims, especially a property owner that needs to sue the right people, but the manner in which the culture has taken, especially where I'm from, is we'll sue everybody and let God sort out the dismissals. And the reality is this: it's killing young, small, or businesses, and we need to work on this because it's devastating. We've gotten to the point where people in certain communities, especially my own, normal companies, cannot even get bonded. And so then they can't even participate in the construction because they don't have the insurance. And so we're getting to the point where it's almost impossible to build a school in South Texas because of the way things are happening. And maybe it is a few bad apples, but it's a problem, and I'm here to help solve it. I'm here to work with all parties, and I'm here to try to come up with a solution, but there needs to be a solution. Thank you.
Members, any questions for the bill author? Okay. Thank you, Chairman. The chair will leave House Bill 2310 pending at this time. The chair now lays out House Bill 3166 and recognizes Chairman Murr to explain the bill.
Thank you, Mr. Chairman. I'll try to be expeditious in my comments.
Okay, thank you.
Due to statutory venue requirements, most of the cases involving the state of Texas are currently filed in Travis County and appealed to the Third Court of Appeals in Austin. The third court hears appeals from a 24-county area, but the district's population is anchored in Travis County. Consequently, although the third court hears cases impacting the entire state, its judges are effectively selected by voters from the largest county in that 24-county area. Lawsuits against the state or state agencies typically contain complex and nuanced legal issues and take significant time to resolve. They are often time sensitive, so that the Third Court of Appeals has been given additional resources to handle them. Even so, the data demonstrates that the Third Court of Appeals consistently divests itself of the largest amount of cases year after year, meaning many cases involving the state are often heard in whichever regional intermediate appellate court has bandwidth in which to hear them. This means that judges currently handling these cases have varying levels of experience on such specialized matters. Sometimes it can lead to inconsistent results for the state and other litigants. This bill proposes a 15th Court of Appeals that would consist of a Chief Justice and 4 justices, all of whom would be elected statewide. The court will not hear criminal matters and will have exclusive intermediate appellate jurisdiction over civil cases brought by or against the state or a state agency, or by or against an officer or employee of the state. Would also have jurisdiction over civil cases in which a party to the case files a petition, motion, or other pleading challenging the constitutionality of a state law, in which case the Attorney General is also a party to the case, or any other matter is provided by law. The Texas Supreme Court will be given rulemaking authority to transfer cases and proceedings mistakenly filed in this Court of Appeals to a Court of Appeals having proper jurisdiction, and to transfer cases from another immediate appellate court to the new court. In sum, creating this 15th Court of Appeals with statewide jurisdiction in civil cases brought by or against the state would allow judges to apply a specialized precedent in subject areas that are important to all of us as Texans across the state. We'd have the opportunity to have a uniform body of law, and really and truly, it's not a regional set of issues. Typically, the application of state law is of statewide concern. I'm confident that we have lots of witnesses signed up to testify. I'm anxious to hear about that. And I know that we will have a couple of important resources from the Office of Court Administration and the Office of the Attorney General. So with that, I'm happy to answer any
questions for the chairman. All right, thank you. You've reserved your right to close. The chair is going to actually call our resource witness up first. So Megan Lavoie, then Amy Biffield with Texans for Lawsuit Reform, Patricia Alvarez, and Linda Gray. Megan, I know typically we save you till the end, but I'm going to call on you first this time, just so we can have some data in front of us as we analyze this bill. The chair calls Megan Lavoie. Megan, I have you here testifying as a resource witness on the bill on behalf of the Office of Court Administration. Is that correct?
Yes. Good afternoon, Chairman Leach and members. My name is Megan Lavoie. I'm the Administrative Director for the Office of Court Administration here as a resource on the bill. Happy to answer any questions. We do have data on the caseloads for the 14 courts of appeals that we're happy to share with this committee. Case filings have been down due to the pandemic, but in fiscal year 22, they actually have almost went up to pre-pandemic levels. Happy to answer any questions that you have about specific data.
Okay, members, any questions for Megan? Okay, Vice Chair Johnson.
Can you just kind of summarize the caseloads and kind of where we are? And I remember over the summer or whenever we had our interim hearing, you provided testimony to this committee, basically that, if I recall correctly, I might have it wrong, but basically the courts were not necessarily overwhelmed by their data. But could you just give us a sense of where we are caseload-wise in historical comparison and that kind of thing?
Sure. So I have in front of me caseload data from fiscal year 2017 through fiscal year 2022. And just looking at from fiscal year 21 to fiscal year 22, cases filed in the 14 appellate courts increased by 24%. The number of cases disposed increased by 5%, and the active pending cases was about 7%. So that's just over the past 2 years. There's During the interim hearing, there's a lot of discussion about the transferring of cases. The Supreme Court does have statutory authority to transfer cases between the 14 appellate courts to equalize the dockets. Historically, there has been about 300 to 500 cases transferred between the courts each year to equalize the dockets within 5%. Typically, right now, we're seeing that each justice, so we have 80 justices across the state, typically has a caseload between 120 to 130 cases per fiscal year, and that fluctuates based on filings. We expect that fiscal year 23, that filings in the appellate courts will normalize. We are seeing spikes in specific courts, for example, the Fourth Court of Appeals, specifically for Operation Lone Star cases. And so we do see that a variation from year to year. Also, you know, I know y'all heard testimony in the interim about the difference between a transfer in court and a transfer out court, and it really does depend year to year on whether a court transfer in cases or transfers out cases. And so there's really no a pattern there if you look historically back on the data. Happy to answer any other, if that gives a brief little snapshot of what we're looking at.
Yeah, how does the Austin Court of Appeals reflect in terms of their caseload data in respect to the other courts of appeals?
Yeah, so the Third Court of Appeals, which is based here in Austin, they are a transfer out court. So in the past, since fiscal year 2017, the Third Court of Appeals transferred out 193 cases in fiscal year 17, 158 cases in fiscal year 2018, 115 cases in fiscal year 19, 212 cases in fiscal year 20, 99 in fiscal year 21, and 142 in fiscal year 22.
And how does that compare to other transfer out courts?
I mean, it like I said, it varies from year to year, but they are consistently a court that has to transfer out cases because of their caseload.
So we have a system in place that does an equalization of the appellate court load already in place, and it's been working well for some time now.
You know, the Supreme Court has had statutory authority, I think, for the past 100 years or so to transfer out cases and equalize the dockets. They look at it quarterly and also have discussions with each of the chiefs of the appellate courts about those transfers.
Members, any other questions? Chairman Murray.
Ms. Lavoie, I'd just like to highlight a couple of things. In looking at statistics from OCA, and I'm looking back to pre-pandemic levels, consistently the amount of cases filed in our courts of appeal in total for all 14 were consistently above 10,000 cases a year. And so that looks at like it's years 2017, 2018, 2019. Obviously, with pandemic activities, it slowed down. Last year was about 9,000, but clearly it's creeping back up to that level. So my observation is the amount of cases that are appealed from any court of appeals to the Supreme Court, for example, and I'm ignoring the Court of Criminal Appeals for a moment, but I acknowledge that they have a high volume of criminal appellate work to do. Approximately, on average, how many cases are appealed to the Supreme Court annually?
Well, you know,
I know it varies.
Right. The Supreme Court does have the discretionary review, and so they take about 13%. I think when I last looked, and this is for fiscal year 22, it was about 13% of the cases.
So about 13% of 22 is about 9,000 cases. So we're only talking about a little over 100 cases is where we are on that. And that's their capacity in which they're operating on, or excuse me, several hundred cases. They don't have the capacity to handle higher volume than that because the court is working diligently.
The Supreme Court?
Yes.
Yes.
And then likewise, their a review to the Court of Criminal Appeals, the amount of cases that go there, that's also a lesser amount. And I guess my point is that I'm trying to make is everybody's working hard, but our courts of appeals, they are the engine that's handling literally 10,000 cases a year. And if you're a party to those cases, the chance that you want additional review, it's low because we're pushing around 10% or 13% for any case to go above that. And that's just the way the system is designed. It's kind of like a pyramid, and as you get to the top, there's just not a capacity for 10,000 cases in front of the Supreme Court or the Court of Criminal Appeals. And would that be a fair assumption?
Yes.
Okay.
And I would say, something I didn't talk about was clearance rates. And our courts of appeals, they are diligently working and clearing their dockets and have actively typically had above 100% clearance rate consistently. In fiscal year 21, their clearance rate was 114%, which is outstanding. And so it does show that the appellate courts are working diligently.
And I would certainly acknowledge that they are working very diligently. Thank you so much.
Members, any other questions for Megan? Okay. The chair now recognizes Amy Befield with the Texans for Lawsuit Reform. Amy, I've got you here on behalf of Texans for Lawsuit Reform testifying for the bill.
That is correct. Thank you, Chairman Leach. Thank you, members. As the chairman said, my name is Amy Befield, and I am here representing Texans for Lawsuit Reform in support of House Bill 3166. I think Representative Murr did a really good job explaining the bill, so I will keep my comments very brief. This may sound somewhat similar and kick in some deja vu because we just talked about the business courts, but we in Texas really have shown a preference for specialty courts from the top of our court system to the bottom. This is a similar situation here where we've realized that when a judge is permitted to focus on a narrower set of issues, the result is judicial efficiency and consistent application of the law. Creating a 15th Court of Appeals with specific subject matter jurisdiction will allow judges to narrow their focus to issues involving sovereign immunity, administrative law, and constitutional law. This will allow the development of a strong jurisprudence in these areas of law. As mentioned, the Texas Supreme Court transfers cases between the 14 intermediate courts in order to equalize dockets. For the past 7 years, by the information I have, the Third Court of Appeals has had the most cases transferred out. In fiscal year 2022, for example, out of 323 cases total transferred out, and my data might be a few months old, so it may not exactly match, but about 142 were transferred from the Third Court, which is almost about half. And of those cases transferred out, about 10% approximately were administrative law cases. And as a practical matter, these cases are going to whichever intermediate appellate court happens to have the bandwidth at the time. And that means that the judges who receive them may or may not have had experience with administrative law. These kinds of cases are very time consuming. They have massive records. One former Third Court of Appeals justice I spoke with said that one of these administrative cases is as time consuming as 3 criminal cases or 2 complex business litigation cases. They even currently receive additional staff resources specifically to deal with these cases, but it still has the highest numbers of transfers to other appellate courts. They also have, just like district courts, very broad appellate jurisdiction. And so even though administrative law cases, constitutional cases, even though these cases are important, they are not statutorily designated as accelerated appeals, but they're approximately 36 other things that are designated as accelerated appeals. So additionally, all civil interlocutory appeals are given precedent as well. So even if justices have had oral argument already on, say, a PUC case, they may have to delay its outcome if a parental rights case comes up on appeal. And that's appropriate, right? Those cases are more important, more timely. But creating a new 15th Court of Appeals will serve the dual purpose of getting these cases out of the regional Third Court of Appeals and unclogging the dockets, and also ensuring that these administrative cases are heard in a timely fashion.
Okay. Members, any questions? Yeah, Chairman Murr.
Thank you, Ms. Befield. I know earlier you mentioned constitutionality, and so I just want to go ahead and talk about that real quick. Are you aware of any constitutional provision that prevents the legislature from drawing an intermediate appellate court however it chooses?
So I thought I might be asked about this, and it turns out I have written a memo on this as well. I did not know I was going to be a constitutional scholar today, but I do want to, again, give a little bit of historical background because I always think it is a little bit telling to know the history of our Constitution. So you may remember from our earlier discussion that in 1891, the legislature did amend our Constitution, and at the same time as the other amendment, it also created the Intermediate Court of Appeals system. The revised Article 5 required the legislature to divide the state into not less than 2, but not more than 3 judicial districts, and to give each a civil court of appeals. So between 1891 and 1967, the legislature did create 14 intermediate appellate courts, with the last being in 1967. So throughout those years, it was very common for statutes creating new intermediate appellate courts to provide for overlapping geographic jurisdiction with one or more of the appellate court districts. For example, when the legislature created the 14th court, the last court in 1967, it had completely overlapping jurisdiction with the first, in terms of subject matter jurisdiction and geographic jurisdiction. So in 1981, the requirement that the state be divided into at least 2 districts was removed. And today, Article 5, Section 6 states that the state shall be divided into courts of appeals districts and that justices shall be elected by the qualified voters of those respective districts. So if we were back in 1892, then right after that, the first provision was created, it might have been argued that the legislature could not create a court with statewide jurisdiction for an intermediate appellate court because that 1891 amendment required the creation of at least 2 districts. But as noted, that requirement was removed in 1981. So the Constitution is currently silent on the number of intermediate appellate court districts that must exist and the number of counties that must be included in each district. And then history really shows that the legislature has never read Section 6 to require the counties within the state to be divided evenly between the intermediate appellate courts. And it is also clear that the legislature does not read Section 6 as requiring distinct geographic districts. Overlapping districts have existed since 1925. They still exist today. Miles versus Ford Motor Company, decided by the Texas Supreme Court in 1995, the Supreme Court upheld the legislature's ability to draw overlapping districts. So what I would say to sum all of that up is that if divided into courts of appeals districts means divided into distinct districts, then the 14th Court of Appeals would not exist today as an exact replica of the first court, because when the legislature created the district in 1967, it did not divide the state any more than it was already divided.
Thank you for going into that level of detail. I appreciate it.
It's helpful. Members, any questions? Vice Chair Johnson.
But I have Section 6 right here. The state shall be divided. I mean, it doesn't contemplate a whole entire statewide court of appeals, though. I mean, it contemplates a division of the state to have different appellate regions.
Sure, and thank you for that question. I would say the state is already divided into 14 different intermediate appellate court districts. And as I said, the 14th court in no way divided the state any more than it already was divided.
But the 14th court is not a statewide court. It's a divisional court. I mean, it has a certain regional geographic finality to it, right? It's not the entire state.
That's right. But I would just say that I believe the state has already been divided into intermediate appellate court districts. And that is my reading.
All right, thank you.
Members, any other questions? Mr. Chairman? Yes, Representative Schofield, I'm sorry.
Just a quick question. The memo that you referred to, is that something that you can provide to us, or is that covered by attorney-client privilege and you can't give it away?
I think I will make an exception. Yes, of course. I'm happy to provide it to anyone who would like.
Thanks.
Sorry, Representative, I didn't see you, but yeah, if you get that to all of us, that'd be helpful. Members, other questions? Okay, is it Ms. Alvarez?
Yes, it's Mrs. Alvarez, and you can call me Patricia.
Okay, Patricia Alvarez, I have you here registering, Justice Alvarez, I should say, I have you here registering on behalf of yourself.
That's correct.
And your position is against the bill.
That's correct.
Okay, you can go ahead.
And first of all, good afternoon, not good morning, and thank you for allowing me to speak today. As the chair stated, I am a justice in the Fourth Court of Appeals, and my testimony today is my own testimony, and nothing but my testimony. And before I proceed, please read my thesis. It'll give you a little bit of insight as to where I'm coming from, and you might not agree with it, but please read it. I really urge you to read it. And I'd like to begin my presentation by acknowledging all the work you've done on this bill. thank you very much because I know what it is to work on a bill. And I know that you want the best for Texas, and I recognize that, and that some of you believe that this new 15th Court of Appeals is going to be good for Texas. But we must not lose sight of a very important fact. We are a democracy, and that is very important. And democracies, as you know, require at the very minimum the rule of law, and they also require checks and balances. And that is the division, the powers, the three powers that we have, and they have to be separate powers. HB 3166 concerns me because I see it as a potential threat to our democracy. I see three issues with this bill. The first one is the effect it has on the Texas rule of law. Second one is whether the bill threatens the independence of the judiciary. That's really important. And third is the issue of the Constitution, whether the Constitution allows you to take away judicial review on matters that you would like to entrust to a statewide court. And then let me start with what the rule of law is. We all learn about the rule of law. And, believe me, when I started doing the research for my thesis, I thought the rule of law was something different. So let me tell you what the rule of law is not. It is not the rule of men. The rule of men always refers to the will and the desire of a person or a group of people with power to rule arbitrarily and with tyranny. The rule of law, on the other hand, is the ideal principle that our rules are clear, and they're enforced by independent judiciary. And what is an independent judiciary? Well, you all know what an independent judiciary is. We have to be independent. We have to be able to rule according to fairness and according to the law and follow the Constitution and definitely always, may I?
Yeah, you can wrap up.
I'll wrap up. And always defend our Constitution and the rule of law. In conclusion, let me tell you, the independence of the Austin Court of Appeals is at stake, and it is at stake because you're taking away jurisdiction from it. You're taking away its power to review. And when you take away a power of a judiciary, of a judge to review, you threaten the rule of law. And that is why I really urge you to consider, like I said, if you think it's a good bill, take it to the Constitution. Let the people decide. Let the people decide whether they want a 15th Court of Appeals. Any questions? And thank you for the time.
Chairman Murray.
Just briefly.
Yes, sir.
Justice, I appreciate you coming today and sharing your testimony. And as the author of the bill, what I will tell you is first, you serve a 31 county catchment area.
32.
32, excuse me.
Yes, 32.
That includes my county and many of the counties that I represent. Second, I'm going to tell you that I have this today and you can count it. I will read it.
Thank you.
And so a lot of people bring us documentation electronically or in paper and hand it to us. And, we get busy. We have other committees. We have bills. We have other responsibilities. But you have a document here, and I'm telling you that at the very least, it will be perused and read by myself.
And thank you very much for that, because like you, like all of you, I love the Constitution. And I am a big advocate of the Constitution. And I'm also a huge advocate that people should vote for what they want in their Constitution. And that's why separation of powers is so important. And I really thank each one of you for your attention. And thank you very much to all who have testified here.
Thank you, Justice. Members, any other questions? All right, thanks to each of you.
Thank you very much.
Okay, we have 15 more witnesses on this bill. All of the witnesses have registered positions against the bill, which is fine. We welcome, I know Chairman Murray is the bill author, and every member of this committee welcomes your testimony on any bill, no matter what your position is. I would ask you to take into account that our committee has over 15 bills left to hear today. And I would ask that you would ask yourself as you approach and start your testimony, number one, do I need to take the whole 3 minutes? And number two, am I offering the committee something new, something that the previous witness hasn't already said? You can be repetitive of a previous witness. You can take the whole 3 minutes if you want. The committee welcomes you, but I would ask as the chairman that you take that into account as we go throughout the day. The chair now calls Linda Gray, Lisa Soto, and Darlene Byrne, and Corey Carlisle. Ms. Gray? Are either of you Ms. Gray?
I'm Darlene Byrne.
Okay. Is Linda Gray here? She might be over in the overflow room, so I'm going to give her a sec to get here. And Justice Byrne, I'll start with you. I've got you.
And if you would correct the record, Chairman Leach, my apologies.
That's okay.
Made the same rookie error as I did in the prior bill.
Okay, well, I wasn't here for your error. And so,
Oh, you were.
Oh, yes, I was.
Yes,
we were on
sir,
the first.
you
That's
were.
true. That seems like 3 days ago. So Justice, welcome back. You're here testifying just on behalf of yourself.
Yes, sir.
And you're against House Bill 3166.
Yes, sir.
Okay, if you could start your testimony.
Certainly. I'm Darlene Byrne. I'm the Chief Justice of the Third Court of Appeals. I have many concerns about this bill, but I only have a limited amount of time. And so I will focus on a few things: data or lack thereof, as well as present efficiency, expertise, and the reversal rate of state issues matters before the Third Court of Appeals. Many of my colleagues from around the state are here. I would just like to honor them, and many of them will not testify today, but there are numerous justices from the courts of appeals across the state of Texas in this room, and I would be honored if they would rise to their feet so that you can see how important they think this matter is to all of us and the rule of law. As it relates to data, we've already talked about OCA is not capable, or right now, their system does not maintain case-specific data, and therefore, they cannot draw out how many state issues cases nor big dollar business cases exist in the state of Texas. So there's no data. But in order to get data, our effort is the Third Court of Appeals. We do preside over most of the state issues cases in the state because we are the home of state government. So therefore, we did a manual dive of 7 years of the data at the Third Court of Appeals. And with that manual dive of the data of the Third Court of Appeals, based on that data, the 5-justice court that this bill intends to establish would have approximately 130 cases total, or 26 cases per justice on its docket, when the other 80 justices across the state have got 130 case load each individually. So one, the docket is tiny, so is it worth $6.6 million in a biennium? The total cases filed in the Third Court of Appeals over a 7-year period were 5,680 cases. Of those total cases, over those 7 years, 406 remained in the Third Court of Appeals as a state issues matter. That's a little less than 10%. Yes, about 10% of those cases were transferred out because of the size of our docket. The number of total petitions for review on state issues cases in that period of time was 130. Of those, only 38 were granted by the Texas Supreme Court in the 7 years. Of those, only 7% were reversed in any way whatsoever, some only in part. In other words, saying it a different way, 93% of the cases that were issued by the Third Court of Appeals were not reversed by the Texas Supreme Court, of those that they looked at under petitions for review. Efficiency, and I've run out of time, so I can't talk about expertise or reversal rate or correct the record, that The Third Court of Appeals does not get one additional penny of additional resources than my brothers and sisters in the other courts of appeals to handle the administrative appeals. Not one. We get same funding for similar sized courts. We just use our money wisely and pay our lawyers less so that we can have more lawyers and less clerks so that we can manage our docket and create a 100% disposition rate in 2021 and a 92 disposition rate in this last year. So we are doing the business of the state of Texas efficiently, including state issues cases. And we have almost a minuscule reversal rate when the Texas Supreme Court takes up state issues cases.
Thank you. Chairman Moody.
Thank you, Mr. Chairman. I appreciate that is very helpful. And I'm glad you all put in the time, energy, and effort to bring this specific data.
It took about 50 hours of manpower to do that.
Okay. Well, I'm glad you did it because it gives us a very good idea. And I do want to give you an opportunity. I know you mentioned you have other concerns. And based on the fact that obviously this bill implicates specifically the work that you all are doing, I want to ask you a fairly open-ended question as a courtesy, based on the subject matter of the bill. What are other concerns that you'd like to make sure that Mr. Murray hears, but also that this committee hears?
As it relates to expertise, because over the many years we've handled administrative and state issues cases in this region, because we are, just like everybody else has a house, the state of Texas has a house, and the house is Austin, Texas. And I'm proud to live in that house and proud to be able to serve the state of Texas as well as the residents of this county as their judicial officer. Again, 20 years on the trial court bench and 2.5 years on the appellate bench. As a trial court judge, I have presided over state issues cases for 20 years on the trial bench. My colleague, also on the Third Court of Appeals, has presided over state issues cases and administrative cases in excess of 20 years. At the Third Court of Appeals, we have in excess of 70 years of experience among our staff attorneys who have served both political parties in their 10, 20-year careers doing state issues cases. So as it relates to expertise, you have it right here, right less than a block away. With regard to efficiency, I've already talked to you about disposition rate. It's there. Yes, we work hard and we take our job very, very seriously. Other issues that I'm worried about, and I thank you, Representative Moody, for saying that. The taxpayer money that will be siphoned off, the $6.6 million in the first biennium, that will be siphoned off to support this unnecessary court, could be better used for the much-needed raises for staff salaries in the present court system, which system is impartially, effectively, and efficiently meeting the needs of Texans. My staff has not received a state raise in over a decade. And we are starving our staff. They're having to move out of Austin because they can't afford to live here. The 15 Court of Appeals would further urbanize and delocalize the work of the court and its justices. The appearance of bias in a judicial selection, which would occur based on the way it's written right now, is concerning because the justices would first be appointed by the governor, who happens to be the CEO of Texas, when the state of Texas would often be the main party to the litigation before this very state issues court. The lack of diversity in the judiciary is concerning because this court will be sited in Austin with judges likely coming from the larger urban areas of the state like Houston and Dallas due to the large media markets and the bigger donor pool for campaigns. And the likelihood of forum shopping, as is seen in the Texas federal court system, is of great concern. Those are just a few of my concerns. I have many others, but those are a few of my concerns. And thank you, Representative Moody, for the question.
Chairman Vice Chair Johnson.
Thank you, Justice, for being here. Thank you. You know, you brought a point that I hadn't really thought about when thinking about this bill prior to this hearing, which is just the expertise level of the trial bench of Austin, by virtue of the fact that the trial level cases are brought here. So you have a decade experience of dealing with those at the trial court level that, say, a Dallas judge doesn't have.
Yes, ma'am.
Yeah, and so that when you then use that expertise and you run for the appellate court, the Austin court, so the justices on the Austin Court of Appeals have that background experience coming in that a lot of the justices around the state do not have to handle statewide matters.
Yes, ma'am, that is correct. And I know probably a thing that will tag team off of that is we'll then judge what happens to that 10% of the state issues cases that get caught up in the transfer system. Mm-hmm. I can tell you that right now, under the law, the transferee court is obligated to abide by the law of the transferring court. There is a vast array and body of law already related to constitutional issues, state issues, administrative law. It already exists in our common law in the state of Texas. And if a case of mine that happens to be an administrative law case gets transferred out to El Paso, they have to use the precedent of the Austin area for consistency purposes already.
I just want to make sure I got the factual data right on your testimony, that you said approximately 10% of the total load of the Austin Court of Appeals is relating to state-related matters?
Yes, ma'am.
I hope I can ask you this question, but as a justice on the Austin Court of Appeals, are you telling this committee that that the Austin Court of Appeals in its current form is able to handle the load of the state as brought to you?
Absolutely. We've been doing it. Did it last year, did it the year before. I've only been on the court 2.5 years. We exceeded 100% of disposition rate 2 years ago. So yes, ma'am.
Thank you.
Thank you.
Members, any other questions? Okay, thank you. Thank you, Justice, for your testimony. The chair calls, is it Lisa? Lisa Soto? Okay, I have you here testifying on behalf of yourself against House Bill 3166. Is that correct?
That's correct.
Okay, you can start your testimony.
Thank you. My name is Lisa Soto, and I've come today from El Paso. I am a justice on the 8th Court of Appeals, and just as Chief Justice Byrne has articulated, that in fact does happen, where we are and have been a transferee court in recent history. And I can say that we absolutely follow the precedent of the transfer or court pursuant to the Texas Rules of Appellate Procedure and the law. I came today simply because our Chief Justice, Yvonne Rodriguez, got called to an emergency with her sister in Australia. And I come, in the interest of time, I can just say that or I'll speak for myself in saying that I share Chief Justice Byrne's concerns coming from the 3rd Court of Appeals, with the exception of not having assessed the data myself, because that does take a manual approach. But we certainly do appreciate her having spent, her court and her team having spent those 50 manpower hours to produce data for you. We urge you to assess whether there's a problem, assess how we're handling as a courts of appeal system the jurisprudence of Texas at the intermediate court level, and urge you, as the OCA just spoke, to examine our clearance rate across the state in terms of how cases are being disposed. And as a court system, I would submit to you that the Court of Appeals, the 15th District, is not necessary. Thank you.
Okay, thank you. Members, any questions? Okay, thank you. Is it Corey?
Yes, sir.
Okay, Corey Carlisle, and is Linda Gray, if you're here or can, maybe outside the room in the overflow room, you need to make yourself, make your way here. Corey Carlisle, I have you here testifying, Justice, I should say, good to see you. I hear you testifying on behalf of yourself against the bill. Is that correct?
Yes, sir, correct.
All right, you can start your testimony.
Thank you all very much. I'm Corey Carlisle. I'm a justice on the 5th Court of Appeals in Dallas. We sit in Dallas. The courthouse is in Dallas. I live in one of the outlying counties, Rockwall County, the smallest county in our state. And it's a person like me.
What county again?
Rockwall.
Okay.
Voter like me, potential litigant in the Court of Appeals like this, like me, who is affected by the particular type of delocalization that this bill will bring to us. The Constitution has set forth
Go ahead, you're good.
a geographically diverse set of Court of Appeals, and this bill, for these special cases, for this highlighted types of litigation, is going to pull that expectation that we have as Texans, the societal compact we've had here and created and lived under for a long time. It's going to pull that right out from under non-urban Texans. I think we can look to how we select our state bar presidents as pretty good evidence of what this court might make up, the makeup of this court might be. In year one of state bar president elections, people are allowed only from the big 5 counties, Bexar, Travis, Tarrant, Dallas, and Harris. In year 2, it's anybody can run from the rest of the 249 counties. And in year 3, it's a free-for-all, and you can probably imagine who wins those year 3 elections. I'll pull it closer to the judicial election discussion that we're having today. Texas Supreme Court and Court of Criminal Appeals, there's 18 judges and justices on those courts. All 18 are from big 5 counties. 13 of those 18 are from Dallas and Harris counties alone. And so with that, I think we can accurately forecast a reality with this new court where these people will be from. And it will be bringing folks to that court who don't speak for people in Kerrville and in Kaufman and in Terrell and in Rockwall, Waco, even Lubbock, Corpus, okay? We can forecast that pretty accurately with the longstanding makeup of those high courts. And so I'm against this bill. I appreciate your consideration in this matter. One other small point I'd like to make. I've heard the words predictability and inconsistency thrown around today, and I'd ask you to consider and not to confuse those words with dissatisfaction in outcomes. With that, thank you. I'm happy to answer any questions.
Members, any questions? Okay, thank you, Justice. Thank you to the entire panel. And the chair will show that Linda Gray, who was here testifying on behalf of the League of Women Voters, did not appear to testify. The chair now calls Jim Perdue, Stephen Vladeck, Luz Elena Chapa, and Kevin Hale. Jim, good to see you. If you'll state, I'll state it for you. I've got you here on behalf of yourself and the Texas Trial Lawyers Association testifying against this bill. Is that correct?
That is correct, Mr. Chairman. Mr. Chairman, thank you. Mr. Chairman Murr, thank you for laying out the bill, the committee. I'll be extremely brief. I know that you guys have had a long day already and have got a lot, and I don't want to be repetitive. On behalf of the trial bar, let me try to lay out some specific concerns. In the layout, the description of the mechanism of the bill is a statewide jurisdiction court of appeals involving claims by or against the state. Unfortunately, the jurisdictional brackets on this court, according to the terms of the bill, are not limited to that. Most importantly, the committee will see on page 3 at line 27 that 3166 contemplates the jurisdiction of this court, including any other matter provided by law. The bill that this committee just took up earlier today, House Bill 19, then has in its section under 24A-006, the contemplation that all appeals from a business court system, if created, that is private litigation between private parties that has nothing to do with issues of the Constitution, administrative law, or sovereign immunity, would go to an appeal to this statewide elected court. That is the primary concern, I would say, because of the interlocking of the concept of business courts now to an appeal to a statewide intermediate court of appeals that is elected, and I think the point is well taken, to jurists that more likely than not will be from the urban areas. Now that then leads to a second point. The concept of this, which I think is perhaps at least justifiable, is that if you have issues that involve the state as a party, then all voters of the state should be electing the judges who are hearing that. The problem is that you still have in issues that involve the state, local issues that are addressed differently in the Tyler Court of Appeals, in the Midland Court of Appeals. So, for example, the jurisdiction of this bill, every single Texas Tort Claims Act tort involving a motor vehicle used by a state department or a malpractice case at University Hospital in Lubbock would be subject to appeal to this Court of Appeals. That breadth in the jurisdictional power given to a statewide 254 county Court of Appeals is of equal concern or different concern. That is really the two main issues. We would be honored to work with the stakeholders and the author on the bill to see if there's a way to address the jurisdiction and certainly to address the concept of this being a new Court of Appeals, but for private litigants in a specific class of litigation.
Okay. Thank you, Jim. Members, any questions? All right. Thanks for your testimony. Judge, good to see you. Luz Elena Chapa, Judge, you're here on behalf of yourself.
I was born, so don't worry.
Well, no, I'm having a hard time reading the record here. You're here on behalf of yourself, and you're registered against this bill, correct?
Correct.
Okay, you can go ahead. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, and this incredible committee. You have more stamina than I do. I've been here since, I don't know, 8:15 a.m., and I'm about to pass out, but I'll do the best I can. I'll speak quickly because I know time is of the essence. As stated already, my name is Luz Elena Chapa, and I've had the honor and privilege of serving the citizens of this great state as Justice of the Fourth Court of Appeals since January 1st of 2013. After being nominated by Texas Supreme Court Justice Eva Guzman, I also have the honor of serving as Board of Director on the American Bar Association's Judicial Division Appellate Judges Conference and the Appellate Judges Education Institute, as well as the ABA's Standing Committee on Judicial Diversity. In no way, shape, or form do my comments here today reflect the opinions of any one of my Fourth Court colleagues or fellow board members of AJC, AJEI, or the Judicial Diversity Committee members. I provide this testimony because my judicial oath is sacred. I almost get emotional, as you can see. And it is incumbent upon me to help protect the independence of this third branch of government. Our citizens deserve an independent judiciary, and justice demands it. Respectfully, I oppose HB number 3166 because it strips citizens of their constitutional right of electing their district's appellate court judges. Citizens rightfully deserve local appellate court judges to hear their civil cases and issue opinions on those cases ultimately affecting their respective communities. Citizens also deserve an elected judiciary that mirrors their diverse population. The more diverse the judiciary, the stronger the rule of law. The strength of the rule of law can only persevere if the public has trust and confidence in its justice system and how government works. The public's trust and confidence, Representative Moore, is what I really hold true in my heart. The election of judges is an absolute factor in preserving that trust and confidence. At its historical core, Texas elects judges. And to be clear, I am a twice elected justice after contested races because voters had a say in a district with over 3 million in population, whose Hispanic citizens comprise 57% of the electorate. The Fourth Court's makeup is 6 out of 7 justices are Hispanic. The entire 13th Court of Appeals bench is comprised of Hispanic justices. Does that mean I'm up?
You can finish.
Thank you.
Seconds left. Take your time.
I'm not used to your timer, just used to my timer.
I understand.
So going back to the 13th Court of Appeals bench is comprised of Hispanic justices whose Hispanic voting population is 70%. The 8th Court of Appeals, for instance, comprised of only Hispanic justices, sits in El Paso, where 78.96% of the electorate is Hispanic, according to the 2020 U.S. Census. Bear with me.
You're okay.
I grew up in El Paso and witnessed firsthand throughout my childhood the significance of judicial races and the electorate's voice in those races. You see, I will never forget how a Texas senator had a Texas flag flown over the Capitol that was draped over a coffin belonging to my late uncle, Judge Sam Paxson. Sorry, that was big. Who served as a district court judge for nearly 40 years in El Paso County. I grew up in his shadow. The executive branch also fully appreciated the significance of his judicial independent role as the then governor ordered flags flown at half-mast on the day of my uncle's funeral. I can visualize Judge Bill Moody waving from the El Paso County courthouse steps as the procession drove by. It was a sad day, but it turned out to be the perfect example of our three branches of government working independently of one another with a different purpose as it was intended all along. All in all, our Constitution gave me and my three children the gift of valuing hard work in judicial races starting at a very young age. It also gave me the gift of witnessing my Mexican immigrant grandmother and mother, who both later became U.S. citizens, exercising their right to vote for my Uncle Sam and other local judges in every election cycle. That said, appellate judicial races matter. The citizens of our state must continue to have a say in who hears their civil appeals against a state and their own government. This will allow for judicial diversity, strengthen the rule of law, and the preservation of the public's trust and confidence in our justice system. Thank you for your patience, and I know I went way over time, but I'm very honored to be here, and thank you for your service. I know it's a lot, especially those with a family.
Thank you, Judge. Yes, Chairman Murphy.
Justice Chapa, I appreciate you being here as one of your constituents.
I know.
And so we've all been here a long time today, and I appreciate everything that you have provided to us. Your input's important.
Yeah.
Members.
Thank you.
Thank you, Justice. The chair calls Kevin Hale. Kevin, I've got you here registered on behalf of yourself and the Libertarian Party of Texas. Is that correct? You're against the bill.
Yes, sir. Yes, sir, Mr.
Okay,
Chairman.
you can start your testimony.
Thank you, Mr. Chairman and committee members. I really appreciate you giving us this time. Some parties claim to be about small government, some about the Constitution, some claim to be about civil rights, some claim to represent the little guy. The Libertarian Party of Texas believes that all power derives from the people, and the only legitimate power held by the state is strictly by the consent of the governed. The Libertarian Party of Texas believes that Texans should be able to seek redress from those who have aggressed against them and be made whole, even when their aggressor is the state. The Libertarian Party of Texas is opposed to any expansion of sovereign immunity, including this scheme where the government guarantees a permanent home court advantage with captive referees. This bill attempts to shift some government power from the hands of one subset of government elites into the hands of another subset of government elites at both the literal and figurative expense of the rest of us, ordinary Texans. In this battle between Republicans and Democrats, the Libertarian Party sides with ordinary Texans and against this bill. Recent polling has shown that Americans support ending qualified immunity, not expanding governmental immunity. Nobody is out there picketing for the state and its agents to have even more advantages in the courtroom. Most Americans, even a lot of Republicans, want to end qualified immunity, not further empower it with hand-picked judges. The Libertarian Party of Texas is with the majority of Americans on this. House Bill 3166 are big government attempts by the elites to further eat away at our civil rights as ordinary Texans. That's why the Libertarian Party of Texas opposes this bill, and you should too. Thank you very much.
Wow, Chairman Murr, elite status. Representative Asute.
The Supreme Court of Texas is a court of statewide jurisdiction. Do you believe that it's an instrument of tyranny if it's statewide jurisdiction?
Absolutely.
Okay. No further questions, Mr.
Okay. Members, any other questions? Okay, thank you each for your testimony. The chair now calls Elizabeth Miller, Jennifer Doan, Tim Newsom, and Rudy Medier. If anyone else wishes to testify on, for, or against House Bill 3166, please make your way to the kiosks now and get registered.
I think Representative Smith is dying to join us.
Oh, yeah. Ms. Miller? Hi.
Aye.
I've got you here, Elizabeth Miller, testifying on behalf of yourself against House Bill 3166. Is that correct?
That's correct.
Okay, you can start your testimony.
Thank you. Thank you for your time today. I am a lawyer of 30 years. This morning, that sounded like a long time. It doesn't so much anymore. There have been plenty of people here today. I feel so much better about that now. There have been plenty of people here today who have given you very articulate arguments about the constitutional issues, which I have a problem with. I understand the impulse, but if rather than waste your time, I'd like to address Representative Vasut with his question for Mr. Hale. There's a huge difference in what you're doing. The king can do no wrong. That's the impulse behind governmental immunity. I think we can let go of that particular impulse at this time. We got a lot from the Crown, but that we can let go of. What you're doing here is Republicans are frustrated. Let's just be honest and say what's going on. We haven't discussed the elephant yet. Republicans are frustrated that cases against the state are landing in Democrat judges' hands, and they want to change that. And so this is a battle between blue and red, frankly, elites, no offense, who control the government, and you guys decide the rules. Now you're going to choose, you're not just forum shopping, you're forum birthing, forum guaranteeing, and guaranteeing that you have the home field advantage. You're choosing the judges. And with the Supreme Court, that's in the Constitution. There's nothing in the Constitution saying I should have to answer statewide every time I sue the government. And we're talking about real people. We're talking about maybe somebody who lost a child in Uvalde, a rancher who's arguing with getting hassled by agencies, a parent who's maybe lost a child, maybe one of the dozens of people who've died in recent years at Tarrant County jails. These are real people who have to go through so much to get into the courthouse. They have to get beyond, they have to find a lawyer willing to take a case when you're suing the government. Good luck. Then you have to penetrate governmental immunity. Then you're in a court where you're suing the government who's created the court, created the rules, chosen the judge. It's a huge uphill battle, and I doubt Texans appreciate, regular Texans, ordinary, normal, non-lawyer Texans appreciate how hard it is. I won't take up any more of your time unless you have questions.
Thank you so much. Members, does anyone have any other questions? Thank you. Okay, the chair calls on Tim Newsom, and let the record reflect that you're here on behalf of Tex Oboda, as well as yourself? Or?
That is correct, Chair Johnson.
Need to make that modification?
Yes, please.
Okay, so let the record reflect that you're on behalf of yourself, as well as Tex Oboda, registered against the bill. Is that correct?
That is correct.
All right, please proceed.
Chair Johnson, Tim Newsom, I'm president of Tex Oboda. Some of the members of the committee, and by the way, thank you for having me, and I thank all the members of the committee. Some of the members of the committee were not present when I testified on House Bill 19. So
Please keep your testimony to this bill.
Yes. I apologize. Tex Oboda is comprised of the Texas chapters of the American Board of Trial Advocates. American Board of Trial Advocates, or ABOTA, is an invitation-only organization. It's national. It's comprised of plaintiff and defense lawyers that are brought in by invitation only, subject to peer review, and then voted into the organization if they are voted in. Tex Oboda has 15 chapters, stretching from Amarillo to the Rio Grande Valley, El Paso to Deep East Texas. I come to the committee today to present a letter that was finalized last night, where Tex Oboda, along with the Texas Association of Defense Counsel and the Texas Trial Lawyers Association, have jointly come together as plaintiff and defense lawyers, 4,000 lawyers, civil trial lawyers representing individuals, small businesses, business interests, and large businesses, have come together in opposition of House Bill 3166. Now, the first thing that we discussed, I need to tweak a little bit based upon Justice Burns' comments. At least from what the committee has been presented with, there's been no data to support the creation of a 15th Court of Appeals. Justice Burns' comments show there's no data at all to support a 15th Court of Appeals. Mankind, a 93% passage rate to the Texas Supreme Court. The other comment that we heard earlier is that the business interests want a specialized set of laws. Justice Byrne hit it right on the head. We have it. You have it here in Austin with the Austin Court of Appeals that time and again and for years has built precedent, has created stare decisis on governmental issues. So the data is there. The data supports not creating the 15th Court of Appeals. In addition to that, the 15th Court of Appeals also, and I'll finish quickly, it establishes, at least at the start, for the justices to be appointed. And it ties that to another bill, House Bill 19. I don't mean to get in, but the business courts bill that allows the pure appointment of judges on those trial courts to then be appealed to judges that are again appointed by the executive branch of this state government. It's improper and unconstitutional, and we talk about that in our letter. Chair Johnson, thank you very much for the committee's time. Thank you for your time here today. We ask that the committee vote against House Bill 3166.
Thank you. Members, does anyone have any other questions? Thank you, sir. Chair now calls Jennifer Doan. You've registered on behalf of yourself as well as Tex Oboda, and you're here to testify against the bill. Is that correct?
I am.
Thank you. Please proceed.
Absolutely. I'm Jennifer Doan. I am the past president of Tex Oboda. You might not have heard of Tex Oboda before, but Tex Oboda is the 15 Texas chapters of the American Board of Trial Advocates, which is one of the 4 large trial organizations in the United States. I'm currently national vice president of Oboda as well. Representative Murr, with respect to this bill, I refer you again, I really appreciate what you said, that you will read Justice Alvarez's thesis that she wrote. It is really important. It is written to each of you. You are the committee that is looking at setting up a business court with appointed judges and at the same time setting up a court of appeals to which not only all state matters are referred, but to which that business court refers to also. That is setting aside our democracy and the separation of powers. The title of the thesis is the legislature silencing the Texas judiciary? As a member of the state of Texas, I encourage each of you to read this. I can't imagine that you would even think about releasing this bill or House Bill 19 without reading it. It deserves your attention. Optics matter. Judge Moya told us that earlier. Not only do you need to look at this thesis, but look at what we had last 2 years ago. 2 years ago, you had TLR here telling you, we're going to go from 14 Court of Appeals, and what we really need is to cut it all the way down to 7 Court of Appeals. TLR is the only body that's testified before you today that this bill should be passed. And now what does it want to do? No, we're going to leave all the 14 Court of Appeals, and we're going to have another Court of Appeals. Optics matter. Don't be used by certain groups in our state. You have a lot of organizations testifying against it. It's not just the judges. It is the Texas trial lawyers, plaintiff, defendant, all together, Democrat and Republican. We matter, and we'd like for you to listen. Thank you.
Members, any other questions? Chairman Murr.
I'll bite. I have a couple of questions.
Sure.
I'll bite. Do you know my district director? Her name is Kelly Early, and I believe she used to work for you.
I do.
Okay.
Very well.
All right.
She's great.
So that's most important. Second, whenever the state, through the legislature, creates a new district court, for example, are you familiar with the process that typically the governor appoints the initial person that occupies that office?
On a new district court or a new court of appeals?
District court.
So the governor sometimes can do that. I am aware of that. I'm aware he has that ability to do, or
it depends on when the creation date of the bill occurs.
It does.
Yes, ma'am.
Yes.
So I point out to that. And then in the past, do you have any background knowledge on creation of past courts of appeal, including the 14th Court of Appeals or the expansion of seats thereof? I know there's been some judicial review over the decades to see in an analysis of caseload if additional appellate seats were needed, and during that process, how were those occupied?
So is the question, how are they occupied and who appointed them?
Yeah, the question is, did they arrive at the similar conclusion that whenever a new judicial district is created, that the initial part was an appointment, a gubernatorial appointment?
I don't know that all 14 Court of Appeals were set up by appointment by the governor of the state.
No, they were all established at different times, but the last one that we did was the 14th.
The 14th might have been appointed by the governor sitting at the time. I don't know that. Okay. But I know that all 14 of them were not.
I understand. Thank you.
Yes. Okay.
Members, any other questions? Thank you so very much for your testimony.
Thank you.
Chair now calls Rudy Medier. I don't know if I said that right.
Yeah, Mateer.
Oh, please. I just did not get that right at all. Mateer. It shows here, the record is showing that you're testifying on behalf of yourself as well as the city of Pflugerville against the bill. Is that correct?
Madam Chair, I'm a council member in the city of Pflugerville, but I'm testifying on behalf of myself.
Okay, well, let us get that corrected. Okay, so that the record is clear. You are here to testify on behalf of yourself against the bill. Is that correct?
Yes, Madam Chair.
Please proceed. Thank you.
Again, I don't want to belabor the points that's been consistently brought up over and over again. You're having people from various different sides of ideologies, viewpoints, the docket, all come here and say the same thing. There's not a necessary need for this court. I'd say that one of the biggest arguments that I've consistently heard over and over again as a kid from a small town North Texas place is that what is going to happen to people who don't have people on their bench who are representing their values and their viewpoints? Make no mistake, as somebody who practiced, in the public sector, for various state agencies, for a long period of time before going back to private practice, you get frustrated. You get frustrated at times with judges, with rulings. Administrative law cases aren't necessarily the easiest cases. Someone said that, they can be some of the most complicated. Absolutely, I can see that. But at the same time and time again, over and over again, what I've seen is that when we've brought up issues regarding concerns regarding those matters, those were addressed. We haven't had to whole cloth create something entirely different to go ahead and honestly chase us, with a solution, a problem that doesn't exist. I think from your standpoint, you're being presented a variety of different viewpoints and ideas regarding, the legal system and the courts. I think that from us, thinking about our clients and the citizens of Texas, it's key for us to make sure that when we're having these conversations, we think about the normal person, the person who it's already hard enough to go ahead and navigate the court system, least of which add another edifice, another complication. We're Texas. Why are we looking to try to complicate things as opposed to find viable solutions on there as well? We haven't seen a problem here. Why go ahead and create one? I give back my time.
Okay, thank you. Members, any questions? Okay, thanks to the panel. Appreciate you being here today. Does anyone else wish to testify on, for, or against House Bill 3166? Chair hears none. The chair recognizes Chairman Murr to close on the
Members, if there's any questions
on the bill.
If there's no questions, then I close.
Members, any questions? Okay. With that, the chair will leave House Bill 3166 pending at this time. The chair now lays out House Bill 2117 and recognizes Chairman Oliverson to explain the bill.
Thank you, Mr. Chairman and committee members. It's a pleasure to be with you today. House Bill 2117 attempts to rectify a problem that I really wish.
Hold on. If y'all could take your conversations outside the room, that would be
outside the rail.
That would be great. Thank you. Go ahead, Chairman Oliverson.
Thank you, Mr. Chairman. So House Bill 2117 attempts to rectify a situation that I wish we didn't have, and that is that, unfortunately, despite the fact that we passed legislation in the last session, I think it was the first special session, that made it unlawful for a defendant charged with a violent felony to be released on a PR bond. That is, in fact, still occurring in Texas after the law went into effect. And subsequent to that, unfortunately, in certain circumstances, these individuals continue to commit felony acts. And so I proposed a fairly simple bill, obviously not simple in terms of its consequence, but simple in terms of its concept, that would allow for, in the event that a magistrate was to release a person charged with a violent felony on a personal recognizance bond, and that person went out and reoffended and committed another felony act, a violent act, that the victim of the second criminal act that occurred while the person was out on PR bond would have a civil liability towards the judge. So in other words, the judge would have liability created because, to the victim and the family of the second victim for the fact that that person was let go on a PR bond in violation of the law in a situation where they actually caused harm to someone else in the community. I guess the way I look at this, and I'm happy to talk about this more if you really want to, but the way I look at this is from a physician's perspective, and that is that as a medical provider, I am held to a certain standard as a professional that whenever my conduct is a flagrant violation of my oath and my standard to do no harm and to practice according to the best ethics of my practice, not only can the medical board hold me accountable for my actions, but I can also be liable for damages if there was harm that resulted to a person as a result of my actions. So again, this bill only takes effect in a very, very unusual and specific set of circumstances. It's a person charged with a violent act who is let out on a personal recognizance bond, not a low-dollar bond, but a PR bond, a $0 bond, in violation of the law, by the way. And that action results in a second violent act being committed where somebody else is harmed. And so in that case, there would be a liability that would occur. I understand that this creates a situation where a judge's immunity would be pierced. But I feel like the current remedy for this kind of conduct, which is clearly unlawful conduct, is insufficient to address the fact that it's still occurring and that people are being harmed. And so with that, members, I just offer that up for your consideration. I'm happy to take any questions, and I'd like to reserve my right to close.
Okay, you've got a couple questions. Representative Schofield, and then Representative.
Mr. Chairman, we are understandably hesitant to put liability on judges for decisions that they make. But in reading the bill, my understanding is this liability would only attach if they violate Article 1703B2, which is the the law that specifically states the circumstances under which you may not release a defendant on a PR bond.
That is correct.
This isn't a judgment call. There's a statute that says a judge does not have the authority to do this. Mm-hmm. And so as I understand your bill, and you can correct me if I'm wrong, your bill only applies if the judge knowingly, well, it doesn't even have to be knowingly, maybe he just doesn't know the law. The judge violates the law that says you cannot let certain defendants out on a PR bond. That law's on the books. The legislature has passed it. People can challenge the constitutionality of it if they want, but it's the law. You're thumbing your nose at it. As a result, somebody else is harmed or killed. Mm-hmm. You're saying in those circumstances, the judge would be liable because he violated the law and put other people in danger. Is that the thrust of your bill?
And that is exactly the thrust of my bill, Representative. I appreciate that.
So now you've never filed the bill in general, to put civil liability on a judge because you don't like their decisions or because the judgment call doesn't go your way. You're talking about specifically violating a law that was put in place to protect the safety of the public. The judge ignores it and somebody dies.
Exactly. And I would add to that I'm a board certified anesthesiologist. I'm a physician. I am the beneficiary of the landmark 2003 tort reform bill that was passed. I am the poster child for not wanting to create new causes of action or increase civil liability. However, I understand that I am held to a higher standard as far as the consequences of my actions than a judge would be under this circumstance.
You and I share a county. In fact, we share a border. Our districts are adjoining. Do you know how many people in our county have been killed since 2018 by someone who was out on a PR bond?
Hundreds.
175. 175 of our neighbors whose family will never see them again, who will never get to see their grandchildren or see their children graduate from school because the judge thought, I don't care about the safety of the community. I'm letting this guy out on a PR bond. You passed a bill to avoid that, and you tell me judges are ignoring it.
Yes, they are. And I do have documented evidence that this is still happening.
Thank you.
Thank you, Representative.
Thank you, Representative Schofield. Let me go to Representative Flores and then Chairman Moody.
So how did you come up with the $10 million damages? Because you're capped at $250,000 as a doctor under the medical malpractice caps.
So that was,
Why don't we make them all 10 million then?
well, I don't know. I would say that this is a very, very unique circumstance. This is actually an act which, in addition to, I would argue, being below the standard of practice, is illegal and unlawful. A judge could, I think, under existing law, the legislature could decide to remove them from office for this act. Although that's obviously, I don't know if that's ever been done. And if it has, I don't remember the last time that it has been done. So it's a pretty high bar. Representative, if the number is what bothers you, I'm obviously happy to work with you on that. I think we wanted to set the expectation that we felt that this was a serious breach of conduct and duty that goes way beyond the pale of, a judge's discretion. This is a clear and flagrant violation of the law with very little recourse in terms of how this could be remedied otherwise, especially from the victim's perspective.
So if they gave a low dollar bond, it wouldn't apply?
That is correct.
So wouldn't they just shield themselves by, doing low dollar?
Well, and my understanding of SB 6 is that it talks about PR bonds. And so you can correct me if I'm wrong on that, but I believe that we were trying to harmonize this concept with a violation of an existing statute, which we, the legislature, put into effect in 2021, which is being ignored.
Thank you.
Members, any other questions? Chairman Moody? Okay, no other questions. All right, so you've reserved your right to close. You have two witnesses who've registered to testify. I'm going to call you both at the same time. The chair calls Ruben Gonzalez and J.R. Woolley. If anyone else wishes to testify on, for, or against House Bill 2117, please make your way to the kiosks right now. The chair calls Ruben Gonzalez. I've got you here, Judge, testifying on behalf of yourself, and you are against the bill. Is that correct?
That is correct.
Okay, you can begin your testimony.
Good evening. I am the presiding judge of the 432nd District Court. I've been on the bench since 2009 and been elected subsequently after being appointed by Governor. Prior to it, just to give you a general concept, I've been practicing for almost 30 years. And prior to that, I was an Air Force officer, served on the nuclear war planning staff as an intelligence officer. The service after that served as a prosecutor in the district attorney's office in Tarrant County, and then private practice both in state and federal courts. Now, in those capacities as a public servant for most of my adult life, I am concerned over the tenor of this bill. And the reason for it is that it would strip the judges of their immunity. Unlike any other public servant that is presently serving in our state or federal, as I understand it, this would probably be one of the first events that we were carving out specifically in the duty of a capacity as a judge, where we're going to remove their immunity for their acts. If there is something that is foreseeable, that's one thing, as the representative has spoken about. But there are other things that are sometimes not foreseeable that a PR bond may be required. Now, obviously, we would follow the statute as it's written. But there are times, however, where we are directed by, let's say, a federal judge or a federal court, just like they've seen in The O'Donnell cases in Harris County, for example, we may run afoul of it. And then what are we to do? Are we going to ignore the federal court? We are now in a position where we have this personal liability if we have a duty to act. And as that such, there's going to be a chilling effect. Now, specifically, I understand that we were talking about the capital murder and those other offenses that are specifically outlined that are prohibited, that a PR bond may be applied. There are other circumstances, however, that I think is a slippery slope, that once a judge has exercised their discretion, that it would result in a judge being personally liable. And as a result of that, I don't think there are many judges that could afford a $10 million judgment against them. And quite frankly, it's going to have a chilling effect on the people that may run for office or want to be a judge. Thank you very much.
Thank you. Members, any questions for the witness? All right. Thank you, Judge. Appreciate you being here.
Thank you.
The chair calls J.R. Woolley, Judge. I have you here on behalf of the Justices of the Peace and Constables Association of Texas and yourself against the bill. Is that correct?
That is correct, sir.
Okay, you can go ahead.
Chairman, appreciate y'all letting me come speak today. I want to start off and say I understand where this bill comes from. And Chairman, Representative, I know you and I talked about this yesterday. There is issues, but this isn't the fix. There's problems with how it's written. There is an opportunity in the statute for me to release somebody on a personal bond. I have to do it by statute, and because the way the different statutes are written, if I release this person on a personal bond under this statute and they hurt somebody, I can then be held liable under this new bill. And there's the specific example is compelling prostitution. If someone has a mental illness and the charge is compelling prostitution, I have to release them on a personal bond if they agree to mental health treatment. Compelling prostitution is not covered as a violent offense under that statute, but it is under Senate Bill 6, is the additions to Chapter 17. So if they then hurt somebody, I could be liable for the 10 million. And it's kind of it's one instance that it can happen in the law, but it's there, and that's scary. And it's scary enough that judges are very concerned with this because we are just humans as well. I can give you the example. Last weekend, I was magistrating, and the PSRS gave me this person's criminal history, and it showed nothing. Well, he had a warrant out of Colorado, so I knew he had a criminal history. He had a warrant, and it was for failure to appear. So he's been arrested in Colorado. Why am I not seeing it? So I dug a little deeper. He had an extensive criminal history. But had I released him on a personal bond, not that I would have because it was a violent offense, but if that mistake was made on him, it could easily be made on someone else. How would I know if he's on probation or meets the other parts of that where it's a parole piece? But if that's the case and I released him because that's not the information I had, even if I came back and got the right information and tried to fix it, and something happened, I would still hold that judge liable. And that's scary. And judges across the state have mentioned that this is germane to their existence as a judge anymore. I mean, I've talked to a district court judge that says if this passes, he will step down from the bench, and he is a good judge. And I fear that we're going to lose good judges if this passes.
Okay. Judge, I appreciate it. Members, any questions? Okay. Okay, yes, Representative Basu.
You and I had spoken yesterday, and I know you may, correct me if I'm wrong, you may have some alternative language that maybe the bill author could look at or consider. Have you gotten a chance to be able to run that by Chairman Oliverson yet?
We did. We dropped it off to his office.
Okay. You know, I empathize and agree with Chairman Oliverson about the issue, and I agree with you about the issue. But I do echo those sentiments about maybe the chilling effect of this bill, and some of my judges have reached out to me on that too. But if there's a way that we could carve the language to be able to get at the really, really bad actors without had that chilling effect, I mean, if there's a way, I'd love to be able to do that. But I just want to encourage you to work with his office.
Oh, absolutely, absolutely. And I'll say to the chairman that I'm from Waller County. I share that same border. So I know exactly what this is, you know, I understand the issue. And the ones who are doing it intentionally absolutely should be held accountable. But don't wrap everyone else up in it that may have been an error, may have had some other things that played into it and to cause that problem.
All right, thank you, members. Any other questions? All right, thanks to both of you. Does anyone else wish to testify, excuse me, on, for, or against House Bill 2117? Seeing none, the chair will recognize Chairman Oliverson to close on his bill.
Thank you, Mr. Chairman and members. I appreciate the opportunity to just draw your attention to this and bring this forward as a possible solution. Obviously, happy to work with folks on this. You know, the whole point of this is to give the victims and the victims' families some redress, because right now the problem is that there's zero accountability for these actions. And it's not like, you know, somebody failed to yield at a stop sign. We're talking about murders, rapes, aggravated assaults, violent offenses being committed over and over and over again by the same individuals who keep finding a way to get out of jail with a get out of jail free card. And we were obviously, I thought, explicitly clear in SB 6, but obviously not clear enough. I just want to point out that this is just like any other provider that would be held to a standard like this. This is not a fine or a penalty. This is not a guarantee. This is an opportunity to actually seek redress for a situation where you feel like somebody else's actions cause direct harm, much like a malpractice suit would be brought against a doctor. So I'm happy to work with you on the language. I'm happy to work with you on the numbers or what you think the penalty would be. But ultimately, at the end of the day, there's no guarantee here. If it's frivolous, it's still frivolous, right? So this would only be applicable in a rare circumstance. And hopefully this will make this chapter would go into effect and it would never be needed, because it would have a chilling effect, but it would be the appropriate chilling effect that would force magistrates to stop doing this. And with that, I close.
All right. Yes, Chairman Moody.
And I'm sorry, I'm catching up and reading language, and been involved in a lot of these conversations regarding bail. In fact, I'm back involved in that conversation this session too. So I think there's going to be more coming.
For sure.
That way. I'm reading so the way you've got this constructed, victim of so this is the broad language that I want to draw attention to. A victim of an offense. That's not limited in any, that could be a property offense or any other, just as a victim of an offense. They have the right to come after a judge to remedy that problem if the judge released that individual on a PR bond. Now, this is where you do have some limiting language. If that PR bond was right, if they were given a PR bond in an instance where they're not lawfully allowed to have one because they were, what's the term of art we use? Offense involving violence, right? So offense involving violence is something we have defined.
Correct.
And so that, I mean, it's a laundry list of things, but, right, okay, you're going to, it's, you know, A through N or something in the code. That's the first threshold to get past. So judge has to wrongfully give that person a PR bond when they're precluded from doing so in the law.
In violation of the law.
Yes, correct. So, but then that person, I mean, the way I read this, if that person goes out and graffitis their home, property crime, the judge is liable for that. So we're not talking about someone going out, and I am aware of the situation in Harris County. This is not limited to then someone going out and committing an act of, well, the way the way that we define it, right?
Sure. I see that
Offense
now. I
involving
see that.
violence. And so my point is, if we're talking about violent offenders,
Mm-hmm.
and we want to get after that, and that's something that we can all try to wrap our minds around, I would hope that our bail discussion this session is going to make it so that people are going to comply with what we're doing, which is making sure that PR bond is used for people that are being held essentially because they're poor, and we don't want that. We're not supposed to.
And not guilty of a violent offense.
Well, when you're on bond, you're not guilty of anything. You're being accused.
Right, or
default
accused, right. I'm sorry, charged with a violent offense.
I'll go back. The default setting in our system is liberty, right? That's the default setting. And then we try to narrow down if we feel like there is a threat or is a security issue. Then we say, okay, how do we want to limit that? And part of that comes along with the constitutional amendment that we're working on. But so then how do we narrow that down? So what I want you to look at, and I'm happy to work with you on it, kind of aside on, we'll talk about the bail stuff that we're working on. I think the construct will be much easier in practice once we get done with this session. But if we're trying to get after someone that is out wrongfully and then kills someone, or if we want to go further, commit sexual assault or other types
Other
of
violent offenses.
high-level first-degree felony violent offenses,
Yeah.
and want to give them remedy, I think that's a different conversation than from a victim of any offense.
Yeah, I see what you're saying. I'm happy to work with you on tightening that
like
up.
I said, it's just, I'm sorry I'm catching up with you on it, but I'd love to sit down and talk with you about it when you have the chance.
Thank you, Representative. I appreciate you.
Yes, Representative Schofield.
Happy to work with you.
And to Mr. Moody's point, but kind of going back the other way, not every, we'll call it the second offense. Your first offense is the one you got the PR bond for, and then you were let out when you arrested a second time. Not all those have to be a violent offense in order to be oppressive to the victim. You can have somebody who's arrested for a lot of crimes they committed while they're stalking you. They come back out and just start harassing. They start spray painting your house.
Yeah.
You're now living in fear because the judge let this person out that should not have.
Right.
Not everything, the second offense may not necessarily be violent. We've got kids in our neighborhood who realize that in Harris County, there's no there is no penalty for breaking and entering into houses. I've had my house broken into twice since these combination of judges and prosecutors stopped prosecuting offenses. They know they can do that. If they get into a situation where they've committed a violent offense and they're not supposed to be out on a PR bond and they let them out and they start trying to show the neighborhood their boss again, the offense they commit then might not be a violent offense. It might be a property crime. We're just going to go and break everybody's car windows. We're going to show everybody we're here and the hell with you. And I don't see a reason why, if we're going to hold the judge liable for violating the law and letting them out, I don't see why I should have to pay for that, or I should have to have my insurance rates go up because of it. So I would caution you against just saying, well, we're just going to make the violent offenses.
Okay.
Let's find a middle ground, but, not, the guy gets out and steals gum from the grocery store, but let's not let them terrorize the neighborhood.
Okay.
Because that's happening in my neighborhood. Thank you.
Happy to work with you. And I would just say again, last thing I want to say on this is just that I feel strongly that part of the issue here is the lack of accountability. And so I acknowledge that this is a heavy hammer. I acknowledge that this may not be one that you want to swing. But my thought in bringing this bill to you, and the reason I want to have this conversation and work on this policy with you, is that there is zero accountability for these actions and people are dying.
Chairman Moody.
And I'll circle back to what Representative Flores said. Judges don't want to subject themselves to this. They're going to do a split bond or a $5 cash bond, and they're going to be out from under this. So, that's also, the effectiveness of this is, can be undermined very quickly by we saw judges that didn't like the idea of certain violent, what we would define as violent offenses, but could be, because we take misdemeanor conduct and we ramp it up to felonies depending on the situation, particularly in domestic violence. It could be a shove, where they can't give a PR bond on a shove, where a brother shoves his sister and they have a prior conviction for domestic violence, or they did that twice within a certain amount of time. And so they give them $1, cash bond just to quote unquote comply with the law. And so that person still gets back out. I think judicial immunity is a construct we've had for a long time for a reason. I get the concern here, and I do think, and we're having, I think, very productive conversations on bail and on limiting bail and essentially maybe even holding certain offenders without bail and expanding that list. I think we're having very productive conversations around that. I want to talk to you more about that too, because I think it may be the more effective way to get at this problem.
I love where you're going with this. The only thing I would ask is just that I think everybody needs to have some skin in the game. And if you've got a judge that can just ignore the law when they're supposed to be the one actually interpreting the law, and they just don't think it applies to them, that's a problem. I don't think any law that we pass is going to have an effect on those folks.
We shall see.
Okay.
Representative Schofield.
And if I could just say again, we're not talking about not liking their interpretation of law. We're talking about the willful violation of statute by the very people who are there to enforce the law.
Agree.
Couldn't have said it better myself.
Okay, members, any other questions for Chairman Oliverson? Okay.
Thank you, Chairman. Thank you, members. Appreciate you.
Thank you. There's no committee. All right. The chair will leave House Bill 2117 pending at this time. The chair now lays out House Bill 2412 and recognizes Chairman King. I believe there is a committee substitute, correct?
Yes, sir.
Okay, Representative Schofield lays out the committee substitute to House Bill 2412, and the chairman recognizes Chairman King to explain the bill.
Thank you, Mr. Chairman, members. I appreciate the opportunity to bring the House Bill 2412 as substituted to you today. Back in 2015, the Texas Civil Commitment Center opened their facility in Littlefield, Texas. At that time, the entire population of sexually violent predators in Texas were transported to this facility. Littlefield is a small town within House District 88. You can imagine the upheaval just the transportation caused. But since the residents, since they are there and they're civilly committed, they are not inmates. They're not prisoners. They are clients. They are residents of Lamb County. And there are significant costs to the courts in addition to the time spent by the Texas Civil Commitment Office and the Office of the Attorney General when dealing with indigent individuals who are exempt from court cost. House Bill 2412 seeks to help reduce court costs by limiting frivolous lawsuits. Mr. Chairman, I have one of my judges from that county that's familiar with that, and I have the Civil Commitment Office here as well that can explain these incidents much more appropriately than I can, but this is a critical issue in Littlefield, Texas.
Okay.
Thank you for that.
Members, any questions for Chairman King? Okay, and you've reserved your right to close. There are two witnesses. I'm going to call you both at the same time. The chair calls Tim Walker and Marcia McLean. Who wants to go first? Okay.
Judge.
Judge Walker, good to see you. I have you, according to the record, here. You're Justice of the Peace, Precinct 3 in Lamb County, correct?
Yes, sir.
Okay, it says you're here on behalf of Lamb County, Texas.
Yes, sir.
We're going to need to change that for the record since Lamb County, Texas can't take a official position on the bill. Can I just have you here, if I show the record to reflect that you're here on behalf of yourself, is that?
That'd be fine.
Okay. So just for the record, you're Tim Walker, Justice of the Peace, Precinct 3 from Lamb County, and you're here testifying on behalf of yourself for House Bill 2412. Is that correct?
Yes, sir.
Okay, you can start your testimony.
Thank you. Committee members, thank you for the chance to speak to you today. I am Tim Walker, Justice of Peace, Precinct 3 in Lamb County. We have a facility, as you know, it's the only facility in the state of Texas. We are privileged to have that facility. We're here today simply to let you hear of some of the things that go on. In my office alone, I handle all the small claims filings from this facility. In the past 24 months, we've had in excess of 100 small claims, and this is in a small rural county. And they run the gamut from sublime to ridiculous. We have, out of those more than 100 cases, there have been 3 cases that I felt truly had merit to proceed. The rest of those cases are just, to me, unbelievable. We run from small claims filed because an individual bought some things out of their commissary account and got slighted one soft drink. He filed small claims. We had cases of an individual small claims because he didn't get a pair of shorts back from the laundry. We'll come to find out the shorts were created out of a pair of pants that was issued to him. They weren't his personal, that was issued to him. And when they found out that they'd been cut off, they discarded them. He filed small claims on that. Then it goes to the situation of the gentleman, he's filed claims, one of them that had true merit to move forward. The issue here is that in all of those, my office alone has been out in excess of $10,000 just in indigent filing fees and processes. That's not counting postage, man hours, anything like that. We have probably about, just doing the numbers in my head, probably 25% of those that get appealed, that are ruled against, they get appealed into the county court. Now, the county court they will have, if we're out in excess of $10,000, they're going to be out in excess of about $3,000 to $4,000. That's not counting even the ones that then get appealed to the 7th Circuit in Amarillo. We have to address that. In that case, we just simply ask that we are in a situation where when originally it came in to being, this was not an issue. It's gotten to be an issue that is costing this county an enormous amount of money. And we're asking for some help.
Sure. Thank you. Appreciate it. Judge, members, any questions? Representative Schofield.
Judge, I was looking at the scope of this bill. And if there's a committee sub, I haven't seen it. I've just seen the filed bill, so you can tell me.
There is a committee sub.
Okay. At least as it was filed,
yes, sir.
The bill only involved cases in which the plaintiff filed an affidavit of or unsworn declaration of inability to pay costs, right? So we're not talking about a case where he has a lawyer and he's...
No, these are all pro se.
They're all pro se and they're all in forma pauperis.
Yes, sir.
And the second thing was, again, at the filed version, I don't know if it's in the committee sub or not, that it doesn't apply to family code cases. So you could...
No, sir.
You trying to deal with your custody case or any of that, none of that's involved.
No, sir.
So it's a very narrowly tailored bill. Thank you.
Right.
Yes, sir.
Did you members any other questions? All right, the chair recognizes Marcia McLean. Marcia, I have you here on behalf of the Texas Civil Commitment Office. You're just testifying on the bill as a resource witness?
That's right. That's right.
Okay.
I'm the executive director of the Texas Civil Commitment Office, and add a little more to what the judge says. There were several lawsuits filed by these guys because they were given ice cream instead of cookies, and they file a lot on dessert issues with what's going on. They have some time to file those things. There was over 100 lawsuits filed between his court and the district court, and 80% of them were dismissed. They have 100% in 21 were dismissed as frivolous. In 22, 7 filed, 5 were frivolous, 1 is on appeal, 2 have been declared vexatious, which I have a hard time saying, litigants, and 3 more are pending that vexatious claim, and they have filed 7 frivolous lawsuits in Lamb County and 12 in their committing county. What this bill generally says is they have to first work through the facility's grievance procedures and see if they can work things out that way. They have to prove that they really are indigent. They've got to give some paperwork for that, and if they find later that they aren't, that they then have to pay the county back for the suits that they've done. This has been problematic for Lamb County because of how small it is and how we've got 440 clients up there right now. And when they get bored, they'll file something. They filed lawsuits because I found like 700 images of porn on an MP3 player they had up there. And it told them all, if we find any more porn, the whole dorm's losing their electronics. Well, they all filed a lawsuit because they lost their electronics when they violated rules at that time. They got them back after a period of time, but in trying to control pornography up there.
Wow.
Trust me.
Yeah. And the stuff we hear in this building sometimes. Members, any questions? Okay, yeah, Representative Assout.
So in short, this will stop the crazy games that they're playing.
Let's hope.
Well, okay. I mean, maybe in this environment.
You know, how they tend to finagle around things.
Okay.
But yeah, I think it would be a big help in the cost to the county for carrying on these.
Absolutely.
All right. Members, any other questions? All right, thank you both.
Thank you, appreciate it.
Appreciate it. Does anyone else wish to testify on, for, or against the committee sub to House Bill 2412? Seeing none, the chair recognizes Chairman King to close on the bill.
Thank you, Chairman Leach. Members, Representative Schofield, just to clear up, my committee sub simply is a led council version of the originally filed bill. So this is the bill in text. With that, I close.
Okay, members, any questions for Chairman King? All right, thank you. We will withdraw the committee substitute to House Bill 2412 and leave House Bill 2412 pending at this time. The chair now lays out House Bill 955 and recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman and members. Let me start by telling you that this is not the bill I asked to be drafted.
Okay.
And so we have asked for a committee substitute because essentially if you read the bill analysis and you read the bill, they were really talking about two different things. Essentially what I was trying to do was what you've been doing this morning. There are some cases that we ought to look at a little differently because of the size of the case. In this case, in the case of House Bill 955, what I was trying to do was, there are some cases whose value is $50,000 or less in terms of personal injury cases or cases where you are required to have an expert or prove medical damages. And because the case is so small, trying to obtain an expert where the plaintiff has to get an expert and then the defendant has to get an expert, the cost of the experts can almost exceed the value of the total claim. And so what I was trying to do was say that, look, there are some cases where the rules ought not to require you to go and get an expert, that if you're going to have a battle of the medical cost, it ought to be sufficient to be submitted to the court by affidavit. And if the other party wants to argue against that, they could do it either by affidavit or at the time the plaintiff was on the stand or on trial. And that's what I was trying to do. So that's what we've asked the council to do in terms of drafting the committee substitute, which we don't have at this point.
Chairman, do you want to withdraw the bill and come back when you do have a committee substitute?
I would like to do that, Mr. Chairman. I just wanted to do it today because the only reason I did it today is because you were actually spent most of your day this morning talking about the size of claims. And that's under the same umbrella under which I offered this.
Okay.
This one.
Okay, so because there are folks who are at the Capitol today to testify on, for, or against your bill, I have to allow them the opportunity to do so.
And
I would. So I'm going to call a panel. Does anyone have questions for Chairman Dutton? Okay. You've reserved your right to close. There's 4 witnesses who I need to call and allow the opportunity to at least come up and say hi to the committee and testify on the bill in front of the committee right now. So let me do that real quick.
Well, tell them all they need to do is say hi and bye.
Okay. The chair calls Corey Rose, Lee Parsley, John Opelt, and Thomas Hollingsworth. The chair calls Lee Parsley. Lee, good to see you. I see you're here on behalf of Texans for Lawsuit Reform, testifying against the bill that apparently the bill author doesn't even like. So is that correct?
Yes, Lee.
Okay. Go ahead and start your testimony.
Hi and bye.
Okay. You are against the bill.
That's correct. Texans for Lawsuit Reform against the bill.
Members, are there any questions for Mr. Parsley? All right. Corey Rose. Corey, I see you're here on behalf of yourself and the Texas Chiropractic Association for the bill that the bill author doesn't like. Is that accurate?
Hi.
You're registered for the bill.
Yes.
Okay. Do you have testimony for the committee?
I do.
Okay. Go ahead. You sure you want to testify now on this bill instead of waiting for the committee sub? There will be an opportunity to come back once the committee takes up this bill again.
Yeah, I'll testify on the bill.
Well, no, you're for the bill. So go ahead if you want to read your testimony.
Sorry. My name is Dr. Corey Rose. I'm here to testify in support of House Bill 955.
Let me stop you. Okay, you're just again, you're sure that you want to read your testimony, because what's going to happen is we're going to withdraw the bill and we're going to leave it pending, and then next week, if in fact a committee sub is ready, then you can come back and testify at that time. Now,
okay. Yeah.
Is that okay with you?
Sure.
I apologize for the inconvenience. Members, any questions for this witness? All right. You might want to ask Chairman Dutton to pay for your gas. Did you drive in from New Braunfels? Okay. Yeah, all right.
It's on me, Chairman.
We look forward to welcoming you back next week with the committee sub in front of the committee. The chair, John Opelt, is he here? Is John here? Say it again? Okay. Chair's going to call John Opelt again. All right. He's not here. Thomas Hollingsworth?
Tom Hollingsworth, yes.
All right, Tom, I see you're here on behalf of yourself on the bill. Is that correct?
Yeah, we'll say on the bill. Just information along the lines of, as Chairman Dutton had mentioned, I'm actually here today to testify on another bill, but since this one came up, I thought I'd share an experience that I had once. I was custodian of records for a doctor that retired. I guess I should formally say I'm Tom Hollingsworth. I'm from Corpus Christi, Texas. I'm a doctor of chiropractic. Now, so a doctor had retired. I became custodian of records. His phone number rang at my office, and I got a call. It was an unusual call. Normally, I would not take the call, but I took the call. And this person kept me on the phone long enough to serve me a subpoena. Because this particular attorney did not get involved in personal injury matters that often, there was one item that wasn't met. Were the services provided reasonable and necessary? And that was the plaintiff's burden to prove. And so the judge, I believe it was a district judge, Maricela Saldana, I believe, gave that attorney the opportunity to serve me. So I was there the next morning. So what this does, as far as relatively smaller bills, I had to leave my practice. I had to cancel my patients. Now, as it stands, only an expert can determine whether something is reasonable and necessary. And there have been changes since the time of this experience, but it doesn't affect me one way or the other, because then I can charge expert witness fees, okay, if I just need to come in and say it's reasonable and necessary or not. But my patients were not served well.
the plaintiffs were not served well. Even the defense wasn't served well because this was a technicality over something that really didn't need to be fought over. And so I would imagine that's the spirit of where Representative Dutton is going to avoid that. So you don't need to pay me an expert witness fee to show up for something that I didn't need to show up for. Is that about right? Or should I say hi and bye?
Yeah. Members, any questions for the witness? Okay, thank you for being here. Thank you each. Does anyone else wish to testify on, for, or against House Bill 955? Seeing none, the chair will recognize Chairman Dutton to close on the bill. Okay. All right. Let us know when you get a committee sub. The chair will leave House Bill 955 pending at this time. The chair now lays out House Bill 1841 and recognizes Representative Wally to explain the bill. There is a committee sub. Chairman Moody lays out the committee sub to House Bill 1841, and the chair recognizes Representative Wally to explain the bill.
Thank you, Chairman Leach. Members, just to clarify, the committee substitute to HB 1841 ensures that all data is being captured by including any court with eviction cases. And so the initial bill only talked about justice courts. In the substitute, we include all courts. And so HB 1841 is an effort to better understand evictions at the statewide level with the tools already at our disposal. Since federal and state level eviction moratoriums have ended, Texas is facing what we understand, according to the data that we do have, is an avalanche of evictions filed in our JP courts. On average this year, 1,627 evictions were filed weekly in Houston. Fully understanding the eviction crisis in Texas will help legislators know what the next step to take. So HB 1841 will fill in the research gaps to better inform our policy decisions. In October of 2022, 160 out of 184 courts statewide failed to report their eviction data last month. So Chairman Leach, we understand that you are on the Texas Judicial Council, and we appreciate your work on that and understand that Chief Justice Heck has been very aggressive on evictions and trying to combat that, and we appreciate the work that you guys have done on eviction moratoriums, on, I think we put millions of dollars into eviction prevention measures. And so we appreciate the work that you guys done. So counties are already reporting aggregate court data to the Office of Court Administration, which is then made available to the public. So HB 1841 would make eviction a category of cases and separate it from the other landlord-tenant disputes that make it to the court. 1884 also asks counties to report information about 1, the legal counsel representing the defendant, 2, the legal counsel representing the plaintiff, 3, the disposition of the case. And it also would make the information required available on public information on an internet website in a searchable format so that we can better understand what's going on in our counties. So I want to address the fiscal note, members. So the fiscal note indicates that I think that it's about $4 to $6 million in the analysis. And in this fiscal note, that language in that fiscal note is actually the same language that was in the introduced bill of HB1. And so it's in Article 4, page 25 of the OCA requests for $4 million in FY24 and $2 million annually going toward replacing a legacy system for case level data. So if HB1 passes with this in it, as expected, there would be no fiscal note. And so we are providing a lot of agencies a lot of IT work or IT dollars. And so this is why currently there's a fiscal note to it, but once HB1 passes, we expect it to not be an issue. So we appreciate this committee's favorable consideration. Last session, you voted it out unanimously. We would request respectfully the same outcome for HB 1841. I'd be glad to answer any questions from members, and I think we might have some resource witnesses as well.
Thank you, Representative. Members, any Any questions for Representative Wally? Okay, thanks.
Thank you, Chairman.
There's two witnesses. You've reserved your right to close, and we recognize that. There are two witnesses here who've registered to testify on the bill. The chair calls Sandy Hoy and J.R. Woolley. Hi, Sandy. Good afternoon. I've got you here on behalf of the Texas Apartment Association for the committee sub to House Bill 1841. Is that correct?
Yes, sir.
Okay, go ahead.
Hi, thank you, Mr. Chairman, members. My name is Sandy Hoy. I'm here on behalf of the Texas Apartment Association, testifying in support of House Bill 1841. Just short and sweet, we are supportive of this bill. We like transparency. Having good statewide data on evictions and other landlord-tenant matters is a good thing. We appreciate the committee sub. We'd like to work on expanding the bill to make sure we get definitions and different processes and the level of detail that is in the section 1 of the bill. We are working with the author, and we appreciate him bringing this forward, and hope to work through it with the process. And that's all I have.
Okay, members, any questions for Sandy? All right, thanks for your testimony. The chair now recognizes Judge Woolley. You're here on behalf of the Justices of the Peace and Constable Association of Texas and yourself, testifying on House Bill 1841. Is that correct?
That is correct.
Okay, go ahead.
Again, good afternoon. Most of the evictions in the state of Texas are held in JP courts. We too have been visiting with the author on this, and that's where one of those changes came from, that if you want to collect the data, you want to collect all the data and not just part of it. The list of data that's being collected here, I will tell you, is not all inclusive on a lot of the CMS, case management systems. As the representative stated, there is a chance of this having a fiscal impact to the counties because that software system coming in and asking to add things to it. So I'd like to have you take note of that. The rest of it is, as has been said, how do you get good information? You collect good data. We're willing to give some good data as long as it's not at our expense.
Okay. That's the extent of your testimony?
That's
okay.
really it.
All right, that's
here
fine.
to answer any questions. Like I said,
Members,
we
are
do
there
most
any
of the
questions?
evictions. So.
All right, thank you each. Appreciate you being here. Does anyone else wish to testify on, for, or against the committee substitute to House Bill 1841? Seeing none, the chair recognizes Representative Wally to close.
Thank you, Mr. Chairman. Thank you for your time and the committee's time. I close.
Okay, thank you. Members, any questions? All right, the chair will withdraw the committee substitute to House Bill 1841 and leave House Bill 1841 pending at this time. The chair now lays out House Bill 2139 and recognizes Chairman Burrows to explain the bill.
Thank you, Mr. Chairman. Members, genesis of this bill is I became aware of a court case where the Texas Supreme Court was debating whether or not the word shall actually means shall in one of the statutes that we provided. I took a little bit of offense to that, thinking of the long hours that we stay up trying to debate the actual meaning of the words, and wanted to specifically make it clear that shall means shall, something I did not think we'd have to do. As I began looking at the Code Construction Act, also began to realize that while we debate commas and words and their meaning, it could easily be undone by somebody who gets on the back mic and establishes a legislative record, and the court would have discretion to interpret it differently than perhaps the plain meaning that the other 148 of us voted on. And I thought that probably needed to be updated to reflect our work and make sure it was taken as a whole. And then finally, I added a severability clause, which I think is important, because if one part of a statute that we pass is struck down for some odd reason, the rest of it actually would be preserved. So with that, that is the Code Construction Act bill and 2139 that I give to y'all for debate and consideration.
Okay.
I reserve my right to close.
All right, great. Thank you. Members, any questions? All right, thank you, Chairman. You've got 3 witnesses who've registered on this bill. The chair calls Steve Bresnan, Charlie Maloof, and Sean Hall Lacuna. Is it Sean? Is that right?
Yes.
Okay. Sean Hall Lacuna, I see you here on behalf of Lacuna Law PLLC and yourself.
Yes.
is Lacona Law PLLC doing business as Lacona Life Ministries, BFQ?
Yeah, BFQ is is an additional entity. It's a church. And did that answer your question?
And you're here testifying on behalf of, it looks on the record like it's all the same. It says Lacona Law PLLC doing business as Lacona Life Ministries, comma, BFQ.
Yeah.
You saying BFQ is separate from those?
Yes.
Okay. And yourself as well. And you're testifying against the bill?
Yes.
Okay, go ahead.
So thank you, Chairman, and the Judiciary and Civil Jurisprudence Committee. I have held a license to practice law for more than 35 years, and I also have admitting privileges before the Fifth Circuit and the U.S. Supreme Court. My experience in practicing law includes not only Texas, but the U.S. and abroad, living abroad and practicing the law in other nations. And then also, in addition, practicing both in state and federal court. The bulk of the work that I've done, both for law firms, corporations, nonprofits, has always included words and interpreting words, negotiating words, asserting the words, and understanding the words, including statutes. So today, I'm here because in the Ancient of Days, I stand against HB 2139, knowing He is God in whom we trust. You can't separate the spirit of the law from the word. God is spirit. In law school, first year law, we learn about the spirit of the law. It is the spirit who bears witness because the spirit is the truth. For more than 35 years, I've held a law license to practice the law guided by the spirit of truth who keeps covenant. Evident in committee hearings and the resulting work of legislators, attorneys discern the very moral conduct the Assembly seeks to reinforce in drafting legislation. These things shall be a statute for you throughout your generations, wherever you may be. Whoever of you wants to become first among you shall be servant of all. Honor the Spirit when writing this and all legislation, I ask. In 1789, 22 years after the Declaration of Independence was drafted, a signer to that document, 8th appointee to the Supreme Court, Justice Samuel Chase, did, making reference to the spirit in the majority opinion, Calder and Wife versus Bull and Wife, 3 U.S. 386, 1798. This bill attempts to overlook 123 years of this nation's covenant with the Lord, perhaps unintentionally, but nevertheless, that is what is proposed. That is what I say to you about my reading of it. Must and shall have more than one meaning. The fact that this bill tries to redefine them as synonymous is proof the words have different meanings. Why have citizens testify, make a record, present court findings, and then attempt to erase their effect? Dear to every true American heart, this is a quote, liberty and union, now and forever, one and inseparable. That's an excerpt from Daniel Webster's handwritten notes in reply to Robert Young Hayne in their debate on January 27, 1830 at Faneuil Hall in Boston. I have a service mark, 802258006. It's for the practice of the law in the area in which I practice. Now, it also has been renewed in 2021, while at the same time, my license to practice law, 08774475, has been administratively suspended. May I finish the thought?
Yeah, if you could wrap up, that'd be great. Yeah, yes. The 3 minutes has passed.
Because of my stance in victory in the U.S. Supreme Court in faith for the covenant of God Almighty, because He's the one who gave me the truth to stand to overcome the impossible. Thank you for your time. Do you have any questions?
Members, any questions? I need to clarify the record here. If you don't mind, is it Ms. Hall Lacuna? Is that how you say your name?
It's Mrs. Hall Lacuna.
Okay. So I have you here representing Lacuna Law PLLC.
Yes, I'm the sole shareholder.
Okay, doing business as Lacuna Life Ministries.
Yes, we have a ministry
Okay.
also. In Travis County, we just have a DBA in Travis County. The law firm obviously practiced before the U.S. Supreme Court and the Fifth Circuit and in all states.
Okay. I'm trying to understand who, when a witness appears before a committee, you're of course testifying on behalf of yourself, which is fine, but when you represent to the committee and to the legislature that you're here on behalf of someone else or a group of people, we have to identify who that group of people is and if it's legal for them to actually be spoken on behalf of.
I hear you.
BFQ, is that what is that?
It's a church. It's not a 501c3 registered entity.
Okay. So is it okay if I change the record to just be testifying on behalf of yourself? Is that
No.
okay?
No.
Okay. On behalf of Lacuna Law PLLC and Lacuna Life Ministries, but
Yes.
not BFQ?
Yes.
Okay. So I'm going to take BFQ off the record. So just for the record, you're here on behalf of yourself and Lacuna Law PLLC, doing business as Lacuna Life Ministries, and you are against the bill?
Yes.
Okay. Members, any questions? All right. Thank you. Thanks for your testimony.
Thank you.
Steve? Is Charlie Maloof here? All right, Steve, I have you here testifying on behalf of yourself for House Bill 2139.
Yes, sir. Thank you, Mr. Chairman. I'm sorry if I caused any delay by
That's okay.
being out in the hall. I really want to talk about three things. And the reason I'm for this bill is because I think the legislature needs to take a meat axe to the issue of legislative intent. For 40 some odd years, I've been listening to legislators state their intent in committees and on the floor of the House, and I don't think the Texas Supreme Court gives a rat's behind what your legislative intent is as stated from the floor. And they don't even care necessarily what you say in writing about it. This is Article 3, Section 43 of the Constitution, which directs you to periodically recodify the law, and stating in the enactment that it's codifying without substantive change to statutes that individually relate to different subjects. In 1981, the legislature revised the tax code, and in the very first provision, it said this is non-substantive recodification. How many of those y'all gonna do this session? In the very last provision in the bill, it says the legislative intent, this is a non-substantive recodification. And yet in Fleming Foods versus Rylander, it gave substantive effect to a provision in this bill. So what the legislature did is it passed two statutes, one in 2001 by Representative Woolens, Senator Kane, to say we mean what we say we mean by amending the Code Construction Act. We mean when we say non-substantive, we mean non-substantive. Governor Rick Perry, a former legislator, vetoed the bill. So in 2009, Senator Duncan and Representative Hartnett, none of these people are exactly lightweight lawyers, passed a bill again to the same effect. Governor Perry proved that consistency is sometimes a human trait and vetoed the bill again. So somehow I think you have to make these non-substantive acts mean non-substantive. My second point occurred in the case of superior snubbing that was alongside the case of Energy versus Summers that some of y'all may remember. On the same day, in the same bill, two different amendments. In the Energy case, the court used the plain language of the statute. In superior snubbing, they actually made one side prove that the legislature didn't intend or intended to change the law, completely reversed the questions and reached two different answers on the same kind of amendment in the same bill on the same day. And finally, I'd like to raise to your attention Molinet versus Kimbrell, 2011, which brings me right back to the point I made to begin with, and I'm just going to read very briefly. Molinet and the dissent urge us to consider and give overriding weight to statements made by a senator during floor debates and published by unanimous consent in the Senate Journal. We declined to do so. They might have reclined to do so too, for that matter. Statements made during the legislative process by individual legislators or even a unanimous legislative chamber are not evidence of the collective intent of the majorities of both legislative chambers that enacted the statute. Probably a true statement, but could be some evidence of what the legislature intended and how to construe a statute. So, when people quibble about the wording of these bills, neither you nor your staffs can hold it against us for pushing hard to make the language say and to tell you, if you do it this way, this will be the result, because the court's not going to let you, not going to try to divine what you're intending, except by this plain language. I'm grateful that the chairman allowed me to support his bill and work out on something that got me PO'd for a good long time.
That's wonderful.
I'd be happy to answer any questions, should I be allowed to do so.
Chairman Moody.
Steve, it's hard to tell kind of where you fall on this.
I'm known for my ambiguity, by the way.
I want to drill down a little. You're always obfuscating. No, actually, I want to drill down a little bit further, because I agree with you. I support the idea. I've been through these fights before. I've had to come back and pass legislation to end some of this tortured conversation. There's been a new, and it's not included in this bill, but I just want, if you could, I find that it's in a similar lane. In recent history, at least in the recent, we've started adding these findings to beginnings of bills. They have no legislative effect.
Agreed.
At all.
Agreed.
And they make conclusory statements. Whether I agree with them or not doesn't really matter, but we put them in a whole bunch of bills. Now, I think they're political speak, if I'm being blunt. But what about, I mean, what do we do with that? Because that is in the statute then.
Yes, sir.
So it's essentially the same thing. It's essentially the same thing. It's surplus words that have no bearing on how the statute is, needs to be read, but it is part of the statute. So it wouldn't be impacted, I don't think, by the bill. Maybe Mr. Burrows can speak to this too. But I also find it is wasteful and is going to probably cause issues down the road. I don't know when that practice began or why, but I don't think it's wise for us, because they're called findings, but I don't know who did the finding other than just someone who wrote a sentence. I mean, I can find a lot of things and stick them in a bill and, whatever. So that, I feel like it almost has the same, it's the same problem, but I know we're not covering it here. I just want to get your thoughts about, I mean, historically, you've been around this building for a bit. Has this been done for a long time?
Yes, sir. It's been done many times over the years. I got an AG opinion requested one year, got the opinion back, wrote the opinion into findings. Y'all passed the bill. I think most of y'all were here at the time. Y'all passed the bill. It dealt with a very sensitive matter of law, Islamophobia in the law, as a matter of fact. It's the law today. Those findings were extremely helpful to my cause. And so I think if it's on the page, I know I'm about to make an extreme statement. I think if it's on the page and it passes both houses and it's signed into law by the governor, that's the law. And the court can't have it both ways and say we're going to pay attention to the plain language. If you are the lawmakers, then the court, there should be limits on the court's ability to tell you how to make the law. And if you define the word black as meaning white, that's the law. That's the way I look at it. If that's not right, then we've got to, I guess we just quit fighting about all these words. I just like to have it one way or the other. Okay, I'm pretty fair statutory drafter, not perfect, not as good as Mr. Parsley if he's still here to hear the comment. But the thing about it is we're spending this time trying to get the words right. And then people are talking about intent. I think many legislators don't know this. I got on this diatribe in the Senate last session over a family law bill. So those findings, in a way, they're the law. Now, I think that one of the beauties of Chairman Burrow's bill is it will write into the law a law review article by Oliver Wendell Holmes.
I noticed that.
Which I can say, in my vast experience, will be the first time I've ever seen that happen.
I'm gonna vote for it just for that.
Yes, but I mean, this, we're having a little bit of fun here.
Yeah.
But at the same time, this is serious business, and I don't make my living over at the court. I make my living here. I represent people who want to speak to you, and they want to get the words right. And if the words aren't exactly the way they'd like them, they'd like for them to be intelligible. And so I think this legislature should be able to set the ground rules for how statutes will be construed, how they'll be written. If you're going to adopt the Oxford comma as your style, then adopt it instead of the court adopting it. When things are determined by an Oxford comma, then I'm afraid I'm going to be out of business because I never really understood the Oxford comma.
Thank you, Steve. I appreciate that.
Members, any other questions? Yes, Representative Schofield.
Mr. Brennan, thank you. First of all, I agree with you on and with the chairman on the whole concept of legislative intent. I always try to tell freshmen coming in, and I quote Mullinett, and I say, court does not care, and I tell my clients, the court does not care what the legislative intent is, and the first thing to do is go write a bill and put one of those things in, and then want to go on the mic and make a point for legislative intent. And so I definitely get where we're coming from. I have a couple of questions for you just about, first of all, and I'm going to ask these to you, not him, because he decides whether my bills go to the floor. You don't.
Hey, mine too, so be careful.
I did notice that we have a section in here on scrivener's errors, and there are a couple of scrivener's errors in the bill. So I thought that on page 1, we have a subsection A, no subsection B. And on page 2, we have some language that should be underlined that isn't. But we'll put that to one side. But I do have a couple of substantive questions about this. And again, it's because we have a statute that is about the intent of the words in the bill, and then we've got words in the bill.
Yes, sir.
And so we have, I think, 3 different sections, the first of which is at the very top of page 5.
I don't have my iPad with me, so if you'll just tell me, I've read it several times.
All right.
And I'll be happy to.
The chairman will make sure you have one. And here's what it is. Here's clearly what we're getting at. And I say we because this becomes the legislature's act once we adopt it. What we're clearly getting at is saying a court doesn't rewrite the law by the way it makes a ruling. So, the law is the law that we wrote, and a court getting it wrong by mere act of doing that doesn't rewrite the law. And I guess theoretically another court could come along and rule correctly. But the way we say it is that a court that declines to enforce or enjoins a state official from enforcing a statutory enactment in whole or in part is never rewriting a statute or engaging in legislative or lawmaking activity as a statute continues to contain the same words. And of course, every statute that's ever been nullified continues to have the same words, but it's been written out of the law by the court. I'm concerned about how I understand exactly what we're trying to say.
Yes, sir.
But I'm worried that we are giving the court license here to basically continue to misread what we do by saying you're off the hook, you haven't rewritten anything, you've just screwed up your ruling. And I wonder if we might want to consider a better way of writing that to get to exactly what we're trying to get to, which is what we wrote is the law, not what you say.
Well, if you're a great lawyer, he's a great lawyer. If y'all are not on the same page, then the court will, what they always say is plain language until there's an ambiguity. And, one man's ambiguity is another's stark clarity. So it seems to me it's got to, the legislature has to agree on that formulation. I think the court's would say, well, you can put this in the Code Construction Act, but it might be true of a trial court, for example, and it might be even true of a court of appeals, and maybe not even court of appeals. By the time you get to the SCOTUX, then, they're going to say, well, we've declared what the law is now, and people are going to have to act accordingly, even if they might individually or another court might construe the statute, differently. I know what you're getting at, especially the limitation to this is as between the parties. But we all know the practice is the parties appeal, it goes up, and sooner or later there's a final version of the statute, whether we think that's what it said or not.
And again, with ambiguity, I used to umpire a bit. And sometimes you're hunting for strikes. You got dinner reservation, you're looking for a strike. If you're looking for ambiguity because you want to engage in judicial activism, sometimes you can find it where it doesn't seem to be.
Has the statute of limitations run on that yet? That sounds like an admission.
I once got hit with 7 foul balls in the top and bottom of 1 inning. It's amazing I can walk. And similarly, further down that page, we basically had the same thing, saying that the court no more rewrites a statute than a decision by the executive not to enforce a duly enacted statute in a limited and defined set of circumstances. Again, I hesitate to inadvertently give them license to do it, as opposed to saying, when you do this, you're not rewriting the law. We write the law.
Yes, sir.
So I do kind of get that. And I had the same kind of concern with the wording of our sections on the grammatical and scrivener's error, where we kind of may give them license to decide that the words don't mean what they say they mean in order to put them back the way we kind of wanted them. But other than that, I'm with you. I think that we give up a whole heck of a lot to come up here and write statute, and our voters expect us to be the ones making the law, and the law bloody well ought to be what we said it was when we passed it.
Can I just say one thing else in conclusion? This is a difficult process. You got 181 people, and I don't know how many staff, and you got, people from the public, lobbyists, you got everybody's participating. And so it's like describing an elephant, sometimes, and you get all these people participating, and you get to a compromise or something that at least that'll pass, right? That's a completely foreign process to sitting over in a robe at the court. Do they wear those robes while they're in their offices? Maybe not, but while they're sitting over there with all the time in the world to look at it and think about it and do the grammar and do all those things, there's a foreignality or a foreign comparison there that doesn't work at all. That's why I think that we all have to be real careful. Y'all might need to slow down. And I'm asking y'all to file bills and do all this stuff and help and encourage, the number of bills creep up and up and up. But if you're going to be held to that kind of standard, then it seems to me we've got to be more careful in the process.
There's no question about that. And I think also but the point of the bill is this whole notion of legislative intent compared to what we wrote. And this is going to surprise you, but I got in trouble in law school for being a smartass. And I'd already worked in the legislature, and we had a professor who had never been near one, except maybe occasionally to testify, who started talking about legislative intent, and I just started laughing. And I said, listen, the legislative intent when this bill was passed of the author was one thing. Of the member from my district was, I got to get along with the author because I got a bill in his committee. On somebody else, it was, if they'll vote for my bill, I'll vote for theirs. There are all kinds, there may be 181 different legislative intents. There's one statute with one set of words.
Yes, sir.
And if it doesn't mean what we wrote down, then it can mean anything.
I'm working on a bill right now where I'm trying to explain to somebody that, your intent, it does not matter. I swear to God, I was going to take Molinet to them, yesterday. And so I'm sure there's more I'll be working on this session that same way. So anyway,
well, thank you, sir. I appreciate it.
Be careful what you say, so I'll shut up and get out of here. Thank you all very much for letting me take a little bit of your time for a personal gripe. Thanks. Thank you, Mr. Chairman.
Okay. Chair calls Charlie Maloof. Going once. Charlie Maloof. Going twice. Okay, we'll just register. He's not going to testify. Chair calls on Chairman Burrows to close on his bill.
Thank you, Madam Chair. Members, now that I have your attention, I appreciate the opportunity to work with y'all. This is a House bill, a Senate bill. This is a bill about reestablishing the separation of powers and making sure that the legislative branch has as much authority as it's supposed to have. And so I would ask for your favorable consideration.
Mr. Chairman, just let me ask real quickly, is there anyone else wanting to test on for or against the bill? Okay, please continue.
I'll close.
Thank you. Okay. Where's the little thing? At this time, the chair will withdraw. We'll we will leave HB 2139 pending. Any objections to leaving HB 2139 pending? Okay, we will leave it pending. At this time, the chair lays out House Bill 2741 and recognizes Representative Smith to talk about his bill.
Thank you, Madam Chair. Madam Committee Clerk, I appreciate it very much. 2741 proposes statutory changes regarding specialty courts. The changes are primarily cleanup. Should just be a real simple situation. When the legislature established the Specialty Courts Advisory Council, the statute identified the type of specialty courts that are considered as treatment courts. Last session, we established the Juvenile Family Drug Court Program under Chapter 130. HB 2741 simply amends statute to add this new court to the Advisory Council. 2741 also amends current statute requiring recommendations of the Specialty Court Advisory Council to be provided to the Criminal Justice Division and the Governor's Office. The law has changed and now gives the Office of Court Administration, or OCA, responsibility in this area. This legislation amends current law in order for the council to provide the best proposed practices to the Office of Court Administration and the Texas Judicial Council, in addition to the Criminal Justice Division. Lastly, HB 2741 allows the governor to appoint judges to the Specialty Court Advisory Council with experience from many specialty court programs. This change ensures that there is a sufficient pool of judges to serve on the council while providing for the opportunity to include judges with experience in additional areas. Thank you for your consideration, and I reserve the right to close.
Members, are there any questions for Chairman Smith? Is there anyone here to testify on, for, or against this bill? Chair sees none. We'll call on Chairman Smith to close.
Thank you all so much. I know y'all have had a hard day. Thank you for your work, and I close.
Okay, if there's no objection, HB 2741 will be left pending. The chair hears none. HB 2741 is left pending. Chair lays out House Bill 2331. Calls on Representative Stuckey to lay out his bill.
Thank you, Madam Chair. Mine's even simpler than Chairman Smith. And members, thank you for the opportunity to lay this bill out. And this is a simple problem with a simple solution. Texas municipalities regularly receive subpoenas for documents from third-party attorneys for legal cases where the city is not a party to the litigation. A hypothetical example of this would be if a plaintiff's attorney sues a defendant for causing an accident in a construction site, and the plaintiff's attorney subpoenas the city for information relating to every construction project that happened that month throughout the city. As you can imagine, in many cases, fulfilling the request of these documents can require a significant amount of staff resources and time to collect and review prior and to distribute. Unfortunately, currently under Chapter 22 of the Texas Civil Practice and Remedies Code, municipalities may only charge $1 for production and certification of the documents and compensation for said staff resources. As a result, it is a local taxpayer who really ends up paying for these third-party subpoena requests. By comparison, under Texas law, members of our communities and the general public who request documents through the Public Information Act can be charged a fee proportionate with the staff resources used to collect and review the documents requested. This bill would simply allow a municipality who receives a request for certification or production under subpoena to charge these third-party requesters a similar fee for this certification or production for the matters in which the municipality is not a party, as it would for any person who seeks records through the Public Information Act. And by ensuring document requests via third-party subpoena are requiring to pay a fee no different than members of the local community and the general public, HB 2331 will ensure that local taxpayers do not subsidize the cost of staff resources used to fulfill, and sometimes high volumes, documents requested. I believe it's a good bill for the taxpayer who has even less involvement than the city in these third-party lawsuits. We have a resource witness here to provide information for these types of requests. If you have any questions, I'm happy to answer. If not, I respectfully reserve the right to close.
Members, are there any questions for Representative Stuckey? Okay. Do any members have any questions for our resource witness? All right. Representative Stuckey, Chair calls on you to close.
Thank you, Madam Chair. And members, I ask for favorable consideration of House Bill 2331, and I close.
If there's no objection, HB 2331 will be left pending. Chair is none. HB 2331 will be left pending. Thank you. Chair lays out House Bill 1791 and calls on Representative Davis to lay out her bill.
Thank you, Madam Chair. This bill is simply, I think we tried to do this last year and we ran out of time, but basically it allows for us to allow a chiropractor to act as a witness for those accidents or malpractice suits concerning chiropractic care. In most instances, we allow dentists and podiatrists and other physicians to be expert witnesses, but with the chiropractic cases, we don't allow chiropractors to be witnesses for those cases. So 1791 would authorize a chiropractor or a physician to serve as an expert witness on causation in malpractice cases concerning chiropractic care. Chiropractor has the knowledge and training like all other professions and would be an appropriate one to provide this kind of opinion on a case dealing with chiropractic care. Finally, a committee considered and passed out this last year, and as I said, I think it got held up in the Senate because of time, and I'd ask for your favorable consideration.
Members, are there any questions for Representative Davis? Okay. Chair calls Jack Walker. And let's go ahead and ask Thomas Hollingsworth. Chair recognizes Jack Walker, and just to be clear, you are here on behalf of yourself and the Texas Trial Lawyers Association in support of the bill. Is that correct?
That's correct, Madam Chair.
Please proceed.
Madam Chair and members of the committee, my name is Jack Walker. I am the Vice President of Legislative Affairs for the Texas Trial Lawyers Association. I'm here to testify in support of HB 1791. A good portion of my law practice is actually in the area of medical malpractice. In the medical malpractice cases, most of you know, at the outset of the case, we've got to serve a timely report to defense counsel that lays out the standard of care, the manner in which the defendant breached the standard of care, and then the causal relationship. As it stands right now and as it's written, the Texas Medical Liability Act is set up to where if you have a chiropractic case, the chiropractor expert that you need can testify as to the standard of care and as to the breach of the standard of care, but is not allowed to testify as to causation and put that link together. So what that means is, what do you have to do? You have to get two experts. This amendment makes sense. The purpose of the bill, the purpose of the law is to advance fairness and justice, and there's two reasons that this makes sense. It's already accepted that the chiropractor is an appropriate expert to testify, identify that standard of care. And these are cases where you're dealing with injuries caused by chiropractors, so they're going to know, they're going to be familiar and experts in this area. That same expert should not be prevented from making the causal connection between the alleged breach and the injury. It creates efficiency in the litigation, cuts down on the costs. It's allowed the parties to save time and expense of the case by cutting down on the cost of having to hire a doctor, to simply connect those dots. And for these reasons, we support the bill, and I'm happy to take any questions.
Thank you. Members, are there any questions? Thank you. Okay. Chair recognizes Thomas Hollingsworth. And just for the record, you are testifying on behalf of yourself as well as the Texas Chiropractic Association in support of the bill. Is that correct?
That is correct.
Okay, please proceed.
Good evening. Thank you for all of your hard work. My goodness, watching you do everything that you do all day long, just today, that's impressive. This one is easy for all the reasons that he just said. Once again, my name is Dr. Tom Hollingsworth. I'm a doctor of chiropractic from Corpus Christi, Texas. I serve on the board of directors for the Texas Chiropractic Association, and I am the chairman of legal affairs for the last several years for the TCA. Thank you for the opportunity to be here. And Representative Davis, thank you for your work last session, shepherding this through unanimously through this committee as well as through the floor last time. Now, as far as my planned testimony, he stole my thunder. So I'll skip a lot of that part because the most important thing to understand is that injury causation or alleged causation or alleged injury is going to be involving the procedures that we are trained to do as chiropractors. And only we as chiropractors are trained to do them. This is our bread and butter. This is our specialty. And right now the law allows people that are not trained in our specialty to be the only people who can give an opinion on it. The problem is very clear there. And so that's what this bill does. If a dentist can talk about a dental case, if a podiatrist can talk about a podiatry case, a chiropractor should be able to talk about a chiropractic case. Now, the important thing to note is that this does not prevent an allopathic physician, an MD or a DO. They can still be chosen as an expert witness. They're still qualified. This does not remove anybody else's right. It just allows us to have that right as well. The limitation currently, as it is in law, is inconsistent with other areas of law. So, for instance, when we're dealing with a mechanism of injury in a personal injury case or the mechanism of injury in a work comp case, chiropractors can talk about the causation of injury all day long. It's only in a malpractice case that we're restricted in this case. I know this may not be the most exciting issue to come before this committee. Unfortunately, it's not a frequent one since chiropractic malpractice suits are not common. But for the chiropractor involved in a malpractice suit, it's really important that they be able to call upon an expert who is familiar with chiropractic techniques and their impact on the human body. House Bill 1791 simply authorizes a chiropractor to offer that expert testimony on alleged injury causation in a chiropractic malpractice case. Thank you, Madam Chair, and if you have any questions, I'm happy to answer.
Members, are there any questions? Thank you. Is there anyone else who wishes to testify on for or against House Bill 1791? If not, Chair recognizes Representative Davis to close on House Bill 1791.
Thank you, Madam Chair. Again, I appreciate your favorable support. As you can see, this just makes sense. And with that, I close and look forward to vote on it as soon as possible.
If there's no objection, House Bill 1791 will be left pending. Chair has none. House Bill 1791 will be left pending. Okay. Chair now lays out House Bill 2636, represents and recognizes Representative Murr to lay out his bill.
Thank you, Madam Vice Chair. House Bill 2636 seeks to amend the Civil Practice and Remedies Code to exempt a recreational vehicle park or campground entity from liability to any person for an injury sustained by a participant in a recreational or educational activity at the park or campground, or for damages arising out of such an injury if, at the time of the activity from which the injury arises, a prescribed warning sign was posted and maintained in a clearly visible location. The bill's limitation on liability is in addition to other limitations of liability out there and does not limit liability for an intentionally caused injury or an injury proximately caused by the entity's negligence, a potentially dangerous condition, or their failure to train or improper training of staff. Importantly, this bill defines recreational vehicle park entity because Texas needed that definition, and campground entity. Finally, I will note that a version of this bill passed out of committee last session unanimously. And I'm happy to answer any questions and reserve the right to close.
Are there any questions for Chairman Murr? Okay. Looks like we have 3 witnesses. If you will all please come forward. Michael Moore, Jack Walker, and Craig Island. Craig, are you not wishing to testify?
I'm going to cover it.
We'll change that on the record. Okay, Chair recognizes Michael Moore. It says here that you are on behalf of the Texas Association of Campground Owners.
Yes, ma'am.
You are testifying in support of the bill, is that correct?
Yes, ma'am.
Please proceed.
Good evening. Thank you for allowing me to be heard today. My name is Michael Moore. I am the Assistant Executive Director and Legislative Liaison to the Texas Association of Campground Owners, or TACO, as we like to refer to ourselves. Our industry allows the public to enjoy the great outdoors of Texas and provides unique experiences that last a lifetime. This bill provides protection for nuisance lawsuits against campgrounds, something already on the books for agritourism Texas. Camping has certain natural hazards, uneven terrain, weather conditions, vegetation, bodies of water, insects, and animals. But camping allows activities that a person might not experience in their normal everyday life, such as running, biking, jumping, and other physical activities. This bill would not exonerate a campground for all liability or negligence on their part, but rather establish that campers accept the risks of their participation in camping and related activities. Insurance companies weigh the cost of litigation currently to the cost of a settlement, opting for settlement with the result being higher premiums for park operators. It's a business decision that costs campgrounds thousands of extra dollars in premiums that this bill would help mitigate. Our association members have been sued in the past for guests slipping in laundry rooms because of their own clothes dripping with water on the floor, while another camper has received permission to bring their own golf cart to the park and then injured their own ankle when they parked too close to a curb. Frivolous lawsuits were filed in both, and in both cases, the insurance companies settled out of court, affecting those park premiums. With this liability bill, frivolous lawsuits would be greatly reduced. The Texas campground industry needs the same protection that federal and state parks already enjoy and that House Bill 2636 will provide. I have the honor of also sitting on the board of the National Association of RV Parks and Campgrounds, and I'm also submitting on their behalf a document and letter supporting HB 2636 that also confirms that other states have passed similar legislation.
Thank you. Members, any questions? All right. Chair recognizes Jack Walker. The record suggests that you are here on behalf of the Texas Trial Lawyers Association testifying on the bill. Is that correct?
That's correct.
Please proceed.
Thank you, Madam Chair. Again, my name is Jack Walker. I'm the Vice President of Legislative Affairs for Texas Trial Lawyers. I'm here to testify on HB 2636. As this committee is well aware, TTLA is not a big fan of immunity bills. And so when they come across and get filed, we take a big, long look at them. Luckily, in this case, we were able to work with Chairman Murr and work through this, and I believe we'll get to a place where we can be neutral on this bill. The purpose of the bill is to assure protections are still in place. We want to assure that protections are still in place for the patrons and visitors for any injuries that are proximately caused by negligence, dangerous conditions on the property, failure to train, and intentional acts. And I think that's preserved. It's preserved, and we have tweaked some language. I think we can work through it. And so we hope to keep working on this to get it kind of down to, as what Chairman Murr says, the best policy we can make for the state of Texas. And so with that, I will end my testimony and take any questions.
Thank you. Members, any questions? Chairman Murr.
Just one question. So, Mr. Walker, appreciate you taking time to visit with me previously about this bill. I believe that we've arrived at a couple of small changes to the bill, and it's the goal that I will try to provide a committee substitute to committee members soon with essentially agreed upon language. The end goal, as we state, is good policy for the state of Texas, and I'll put in my plug now. So after redistricting, I represent over 23,000 square miles of the state of Texas. It's almost the size of the state of West Virginia. And we have a lot of great RV parks and campgrounds. And so this is something that I'm not doing just for Texas, but it's constituent driven for me. So I appreciate the opportunity for you to be here and for us to talk about it. Thank you.
Thank you, Chairman.
Representative Davis.
And this is just for clarification purposes, because a couple of folks have mentioned this. Don't we have a law to eliminate frivolous lawsuits already? Isn't there a law already to minimize the number of frivolous lawsuits that are filed?
You mean as pertaining to campgrounds specifically or just in general?
Just in
Excuse
general.
me, I think the questions.
Oh, I'm sorry.
Yes, we do.
And the reason I ask this, because a couple of times they mentioned this, and I'm just wondering, does that law not work?
We think the law works very well. But when we see these type of situations, and we want to work, to try to we'd love to there'd be nobody come to us for immunity. But in these situations, we work through, and I think this ends up with really good language to protect the patrons that will be out at the campground.
And I would tell you, I think that it's important that we have our campgrounds safe and that families can enjoy that quality of life that they associate with that effort. And I know you can't control the bugs and the ants and all, I get all that. But I was just curious or not, whether or not that was still in place, because a few years back, I heard all this stuff about frivolous lawsuits and I know in my community, people always talk about attorneys don't take a lot of the cases now because of that rule. And then I hear people come and testify, with all due respect to you, sir, to say your insurance is going up. I would contend to you that we really need to look at what insurance companies are doing. And I just want to raise that, Mr. Mercer, you want to fix that. Insurance is broke. And these guys are victims of insurance companies raising their rates. And I think we ought to just, at some point, take a look at that from a broader perspective, because he's suffering. He's doing as much as he can to be with you. Citizens are still getting harmed, and so maybe we need to figure out what insurance companies are doing to you. Maybe you ought to change your policy or get a new provider. I don't know. But I hear this all the time about insurance rates, and we're putting small businesses and we're putting businesses out of business because of the cost of their insurance. And I just want to offer that, and I know this didn't have to do anything with insurance other than the fact that people continue to tell us that lawsuits are creating insurance rates increasing, and we're putting people out of business. Certainly none of us want to do that. So we want to make sure we attack the problem where the problem is. So I just offer that as a follow-up to the question I had. Thank you.
Thank you, Representative.
I look forward to you working with me on that.
Any other questions? Is there anyone else here who wishes to testify on, for, or against House Bill 2636? If not, the chair recognizes Chairman Murr to close on House Bill 2636.
I appreciate the witnesses being here after a long day, and I think this bill strikes a good balance between those that offer and operate RV parks and campgrounds and those that patronize them. So I will provide a committee substitute that will have agreed upon language, and I close.
Thank you, Chairman. If there's no objection, House Bill 2636 will be left pending. Chair hears none. House Bill 2636 is left pending. Chair lays out House Bill 1857 and calls on Representative Guillen to lay out his bill. Chairman Guillen.
Thank you, Madam Chair. Members, over the years, I've received numerous concerns from my constituents about the inadequacy of court-ordered rehab for their loved ones struggling with addiction. Today, you'll hear testimony from one of my constituents who struggled for years to get her daughter the help she needed. Every time she was sent, her daughter was only given brief stays in drug rehab centers before being released, and she's since lost her. Inspired by her story, we researched what other states are doing, and we discovered that while there's a maximum limit to the number of days a person can attend a court-ordered drug treatment program, there's no minimum stay, as can be found in other states. The most recent drug abuse treatment outcome study conducted by the National Institute of Drug Abuse found that those who left treatment early had the same relapse rates as those who stayed only for a day or two. However, after long stays, relapse rates decreased as the length of stay in treatment increased. With that in mind, HB 1857 sets a minimum duration of 60 days for individuals undergoing court-ordered drug treatment programs. This bill will allow them to receive adequate treatment, break the cycle of addiction, and establish healthy patterns of behavior that they need to overcome their addiction and lead a clean life once again. We are working on a committee sub with stakeholders to make sure that we develop language that best accomplishes our goal of providing the appropriate length of treatment. I can help answer any questions if you all have any.
Thank you, Chairman. Members, are there any questions for Chairman Guillen? Okay. The chair calls Tracy Clark.
Hello.
Hello. So the record reflects that you are here on behalf of yourself, testifying in favor of the bill. Is that correct?
Correct.
Thank you very much. You may proceed.
Thank you. Okay, like you said, Tracy Clark, and I reached out to Mr. Gann about 2.5 years ago in regards to my daughter. She committed suicide in 2020, 10 days before her birthday. We struggled with her addiction for several years. She was addicted to meth. When she started, it was smoking meth. She deteriorated really quick. Her brain wasn't functioning properly. She would see things, hear things, do crazy things. Every time we tried to get her some help, law enforcement considered it a liability to the jail and would send her to the hospital. Hospital would consider it just being high, let her sleep it off for a couple of hours and then release her. And she'd be back on the streets doing the same thing. In the time that from when she started to her last day, she'd been beaten several times, raped several times, drugged behind a car, left practically for dead on several occasions, couldn't find her most of the time. She became homeless, difficult to find, attempted suicide a couple of times. She finally decided she wanted help. So I made the trip to Longview to go get her. 9-hour drive. The drive back was 3 days as opposed to 9 hours. She kept jumping out of a moving car. Totaled the vehicle on our way there. When we got there, she decided she wasn't doing it. She wasn't going to rehab. In my desperation, I pushed every button that I could and got her to hit me so that I could at least get her picked up on assault charges and hopefully sober her up to where she'd agree to be put in rehab. It worked perfectly. They picked her up again as soon as she was picked up. Liability, cry suicide, jail doesn't want you anymore. They took her to the hospital. They decided they would take her to the South Texas Behavioral Center in Edinburgh. She was there a day and a half. Psychiatrist came in to meet with her on that second day, visited with her for about 10 minutes, give or take, and said there was nothing wrong with her. She was an addict with anger issues. At this point, my daughter was now at about 70 pounds from 130. She had no more hair. She had gashes all over her head that she would slice open herself because that was the way that she could go to the bathroom. There was no other opening, and so when she needed to use the bathroom, she'd slice her head open. A trained psychiatrist didn't see this as a problem and sent her home. 3 days later, I got calls at midnight, and she had put a gun to her head and pulled the trigger. The last time I saw my baby alive, we argued because she left.
There's so many things that we went through with her. My problem was law enforcement, doctors, lawyers, psychiatrists, therapists, counselors, and everybody that I went to. I got the same response. She's over 18. She needs to want the help. She was slashing her head open to use the bathroom, but they're gonna go with that crazy, no, I don't need help, to the sane drug-free mother that's reaching out. Hospitals would call me and tell me we have to get her out of here, but she can only be released to a parent. If she's an adult and you will not treat her for her addiction and her mental problems, why are you calling her parents to get her out of the hospital? Same way you won't help her, keep her. There's nothing I can do with her. They're not given enough time when they are placed in a facility. It's a 72-hour hold. And basically what that does is just gets them low enough off of their drug to release them back into the street. They're not sober, they're not fixed, they have no counseling, no help, no treatment, nobody to express things to. I didn't graduate high school. I got my GED. How am I supposed to sit there and try to explain to my child that, no, you're not unraveling and attaching to your dog? And she made no sense. And every single time that she was picked up, body cameras on the officers in the vehicles captured every crazy, psychotic thing she said. And it still wasn't enough.
Thank you so much.
My son was her best friend. And he's in the same situation that she's in now. Several suicide attempts. He's been shot, he's been stabbed, he's sliced himself. This is what I have left of my daughter, the ashes that are in this pendant. Because on meth and crazy, my son broke into the cemetery and took his sister. He doesn't remember any of it. He was so messed up. I'll never know where my baby girl is. Never. This is all I have left of my child. There needs to be something done about the minimum requirement for somebody that is an adult to be held and treated. Arresting them and throwing them in the jail cell makes them worse, especially on meth. If you weren't crazy before, you're gonna be crazy after. No matter how long you use, when you quit, you're not the same. You'll never be the same. You'll always need help. You'll always need treatment. It's too late for my daughter. She's gone. But if her death can help save somebody else's life, then I'll do whatever it takes. And my son is right behind her. I've already lost one. I can't lose another one. We're asking for help in getting the system changed to ensure not just the safety of my son, but of every other adult addict that nobody can control. In my opinion, a bullet didn't kill my daughter, the system did. If she would have gotten help, if they would have listened at the very beginning, my baby would still be here.
Thank you so much for coming to share your story. I'm so sorry for your loss. I think I can speak on behalf of the committee. We honor your courage for coming in to tell your story.
Thank you.
Thank you. Members, any questions? All right, thank you for being here. Does anyone else wish to testify on, for, or against House Bill 1857? Seeing none, the chair recognizes Chairman Guillen to close on the bill.
Thank you, Mr. Chairman. Again, as I mentioned before, we're working on a committee sub with stakeholders to make sure that we develop language that best accomplishes our goal of providing the appropriate length of treatment for cases like these.
Okay, great.
I'll get that back to you as soon as I can put it together.
Powerful testimony. Thank you, members. Any questions? All right, thank you, Chairman. We'll leave House Bill 1857 pending at this time. Chair now lays out House Bill 2342 and recognizes Chairman Guillen to explain the bill.
Thank you, Mr. Chairman. Members, HB 2342 would amend current law related to civil actions for negligence against licensed funeral homeowners. As it currently stands, individuals who aren't related to the deceased person can take civil action against licensed funeral homes for negligence. HB 2342 would only allow lawsuits to be brought by the immediate family members of the deceased, which is defined as the spouse, adult child, parent, or adult sibling of the deceased. Other attendees at the funeral service who wish to sue for negligence would need to involve an immediate family member to prove the suit's merit. The bill would reduce delays in the judicial system by limiting unjust and unnecessary claims from distant relatives or other attendees. We're working with stakeholders on a committee sub as well on this one to address some minor issues over language usage, and we'll have that back to y'all as soon as possible. I can help answer any questions if y'all have, and we do have some people here to testify.
Members, any questions? Okay, thank you, Chairman. I recognize your right to close. We've got two witnesses who've registered to testify on this bill. The chair calls Harvey Hildebrand, former colleague, and Craig Island, former colleague. Wow, look at this panel. Let's see. Let me, Representative Hildebrand, start with you. I've got you here as Harvey Hildebrand on behalf of the Texas Funeral Directors Association, testifying for the bill. Is that correct?
Yes, sir.
All right, go ahead.
Yeah. Thank you, Mr. Chairman, members. I'm Harvey Hildebrand, Executive Director of the Texas Funeral Directors Association. We appreciate a long day for the committee and y'all's service, and also appreciate Chairman Guillen for carrying this bill for us. It's the bill, HB 2342, amends the Chapter 651 of the Occupation Code and adds language about in the first degree, next of kin, or relatives in the first degree, being the parties narrowing the scope. Currently, the law is based on case law, and even though generally it's followed, it was a Supreme Court decision and also appeals court decision. There's been a series of other smaller cases, but those are the two biggest ones and with the most bearing. But there are some cases around the state in different regions that tend to not view that particular case law from the Supreme Court. And so we just want to put in the code a definition for relatives in the first degree as the parties that can carry or can sue for negligence. We are working with the chairman and the other interested parties. We are working on a committee substitute to address the issues raised by some of the interested parties and to perfect the intention of the bill in a committee substitute.
Okay, thank you. Representative, members, any questions? All right, thank you. The chair calls Craig Island. Hang on just a sec, Craig. I've got you here on behalf of yourself and the Texas Trial Lawyers Association testifying on House Bill 2342.
Yep, thank you, Mr. Chairman. We are working with Chairman Guillen and Mr. Hildebrand and his association to very, very, very minor tweaks, and then we are neutral on the bill.
Okay. Members, any questions? All right. Thank you both. Appreciate it. Does anyone else wish to testify on, for, or against House Bill 2342? Seeing none, the chair recognizes Chairman Guillen to close on the bill.
Thank you, Mr. Chairman. If there's no further questions, I close.
All right. Members, any questions for Chairman Guillen? All right. Thank you. We'll leave House Bill 2342 pending at this time. Members, before we get to the bills of the committee members, of which we've got just a handful left, I'm going to lay out this bill for Representative Cook. Chairman Murr, just for your purposes, your planning purposes, we are going to, Representative Slauson just started laying out her bill in State Affairs. She said she's got 5 witnesses, and as soon as she's done, we're going to take up pending business. Thanks. So the chair lays out House Bill 1989 by Representative Cook, and recognize myself to explain the bill for him. He couldn't be here today, so I'm going to lay this out for him. Thank you, Chairman Leach and committee members. That's me. So thank you, committee members. House Bill 1989 waives the district clerk's fees for an out-of-state criminal justice agency that requests a document for a criminal justice purpose. Currently, district clerks charge a fee for a copy of any document on file or of record in the district clerk's office. Data sharing across state lines is critical to the prosecution of criminal defendants who commit crimes across the country. Clerk records may reveal and prove past criminal convictions at trial. District clerk fees are already waived for the United States Immigration and Customs Enforcement and U.S. Citizenship and Immigration Services federal agencies. HB 1989 in front of you now strengthens our criminal justice system through data sharing for criminal justice purposes. I'm happy to take any questions if you have them. With that, I will reserve my right to close on House Bill 1989. We have one witness for this bill. The chair calls Lindy Borchardt.
Sorry, I ran over here from the.
Yeah, thank you. I've got you. Just a sec. I've got you here on behalf of Phil Sorrells, the Tarrant County Criminal District Attorney, testifying for the bill. Is that correct?
Yes, Chair Leach.
Okay, go ahead with your testimony.
Okay. Chair Leach, member of the committee, I'm Lindy Borchardt. I'm an assistant criminal district attorney in Tarrant County. On behalf of Phil Sorrells, the criminal district attorney, I'm here in support of House Bill 1989. From all the bills you have heard today, I think this is a simple bill that promotes sound public policy by sharing district clerks' criminal history records with either other states or the federal government when they are requested for criminal justice purposes. Right now in the current bill, there is already a carve-out provision for ICE and U.S. citizenship and immigration, so district courts do not charge, or district clerks do not charge a fee for copies for these governmental entities. And in this bill, this just extends the carve-out to out-of-state law enforcement agencies requesting district clerks' records for criminal law purposes. What does this mean? It's usually for certified judgment and sentences that can be used in punishment or enhancement purposes. And most often, though, it is for requests by the federal government to ensure that a person is eligible to purchase a firearm. And so by sharing criminal history records, it strengthens our criminal justice system by, again, providing past criminal convictions and sentences, and also, and I think more importantly, safeguarding against criminals illegally purchasing guns. And so for that, I fully support House Bill 1989. And as you will see, there's really not a fiscal note to this bill.
Okay, Lindy, thank you. I need to clear up the record just a little bit.
Yes, Chair.
You're here on behalf of the Tarrant County Criminal District Attorney's Office. Is that correct? It says Mr. Sorrell's name, Phil Sorrell's name, and I need to testify on his behalf.
Okay. I'm here on behalf, yes, of the Tarrant County Criminal District Attorney's Office.
Okay, all right, and so I have your permission to change the record to reflect that?
Yes, Chairman.
Okay, and you're in favor of House Bill 1989?
Absolutely.
All right, thank you. Members, any questions?
Thank you, I appreciate it.
Thank you. Thanks for being here. Does anyone else wish to testify on, for, or against House Bill 1989? Seeing none, the chair closes on House Bill 1989, and the chair will leave House Bill 1989 pending at this time. Did you lay out your bill? You've already gone. Okay. She's closing? Okay. All right, the chair lays out House Bill 2431 and recognizes Vice Chair Johnson to explain the bill.
Thank you, Mr. Chairman, committee. I appreciate the opportunity to talk to you today about House Bill 2431, which seeks to address the cost of appeals in court proceedings. Currently, parties to an appeal are required to request that the county or district clerk prepare a record to be sent before an appeal is able to proceed. The appellant must pay for the record. The clerk has the sole responsibility for filing the record, and the deadlines for filing the appellant's brief runs from the date the record is filed. Despite mandatory e-filing that requires all parties to have access to the documents pertaining to a case, some Texas court clerks continue to charge a fee, sometimes as much as $1 per page, to send documents that all parties already have in their possession. House Bill 2431 would allow parties to file a prepared appendix in lieu of the clerk's record. The appendix must contain electronic file stamp copies of all the documents required by appellate procedure and may not include documents that have not been filed in the trial court. House Bill 2431 also requires that the party must inform the court within 10 days of filing a notice of appeal that they intend to prepare with an index. This will reduce the cost of appeals for the parties and expedite the ability of the court to hear the case, as it would not need to wait on a court clerk to send documents that the parties already have in their possession. I appreciate your time today. If there are no questions, I don't know if we have a witness here anymore or not, but if we do, I'll reserve my right to close.
Members, any questions for Vice Chair Johnson? Okay. Seeing none, the chair recognizes Matthew Kita.
I think he had to leave.
Okay. Matthew Kita. Okay. David Gonzalez. Is David Gonzalez here?
That's perfect.
Is the overflow room still open? Okay. Does anyone else wish to testify on, for, or against House Bill 2431? Seeing none, the chair recognizes Vice Chair Johnson to close on the bill.
Thank you, Chairman. I close.
Does anyone have any questions? No one has any questions, actually. Representative Schofield.
As you know, I never lose, so I never have to appeal it. Is there anything that you'd have to include in the record that the parties wouldn't already have?
Yeah.
There isn't, right? Okay, thanks.
Okay. Members, any other questions for Vice Chair Johnson? All right. Seeing none, the chair will leave House Bill 2431 pending at this time. The chair now lays out HJR 39 by Representative Vasut. And the chair recognizes Representative Vasut to explain the constitutional amendment.
Thank you, Mr. Chairman. Members, posit to you one simple thing, that age is just a number. It's no guarantee of wisdom. It's no guarantee of folly. It's just a number. That's all it is. In Texas, however, when you turn 75, your number is up. You can no longer serve your state as an elected judge or justice. You can be the brightest legal scholar in the nation, the best candidate to serve your community, yet you cannot. Because Texas, in my humble opinion, discriminates against senior jurists solely due to their age. Specifically, Article 5, Section 1A1 of the Texas Constitution was added in 1965 to bar judges and justices from continuing to serve as elected jurists after their 75th birthday. Provision was amended in 2007 to allow them to serve briefly past their 75th birthday if they turn 75 during the first 4 years of a 6-year term. Now, lest you believe these provisions only apply to current judges and require them to retire, the Fifth Circuit and the Attorney General have both stated very clearly that this prevents anyone 75 and older from running for a judge as well. So for almost 130 years, our judiciary functioned without these rules, and I believe they serve no purpose today other than to discriminate against senior Texans. They discriminated against a good jurist and constituent of mine, Judge Ed Denman of the 412th Judicial District Court. He is a well-respected jurist, but he was forced to resign from office, and his crime was he turned 75. HJR 39 proposes a constitutional amendment to repeal the mandatory retirement age from the Texas Constitution, so senior Texans are not discriminated against in serving an elected office. So Just a few things real briefly here. It's not a novel concept. Texas didn't have it for 130 years, and our judiciary functioned just fine without it. 15 states don't have mandatory retirement ages, and the federal government does not have mandatory retirement ages for justices. This amendment came up in 1965. It's not 1965 anymore. The percentage of Texans over the age of 65 has risen dramatically the past few years, and this actually shocked me. The number of practicing attorneys in Texas over the age of 65 has doubled in the last 10 years alone. Over 20% of our current district and county court at law judges are over the age of 65 right now.
What percent?
20% of judges are over the age of 65. So basically, we've got 20% of our judges in danger of being kicked out of office in the near term solely because they're going to turn 75. Repealing the mandatory retirement age will not materially impact the quality of the jurists because several reasons. If you have an issue with your competency, as some of the prior case laws noted, the purpose of the amendment had to do with senility, about people staying in office longer than they needed to, you can resign. We had a judge in the First Court of Appeals resign because of an Alzheimer's diagnosis, and by the way, they were younger than 75. The public can refuse to re-elect a judge if they don't believe they're competent to serve. The legislature can remove a judge if they believe they're not competent to serve. We can do that by address or impeachment. And finally, in 1984, the Constitution was amended after this 1965 provision was put in place that explicitly gave authority to the State Commission on Judicial Conduct to investigate when a judge is no longer competent and then to recommend to the Supreme Court through a review tribunal to remove that individual from office or suspend them in the interim. So stated simply, Mr. Chairman, members, we do not need a mandatory retirement age in our Texas Constitution in order to have a competent and qualified judiciary. It serves no purpose other than to discriminate against people just because of their age, which, remember, is just a number.
Look at Steve Bresnan back there looking so hopeful, wanting to run for judge. Members, any questions for the bill author?
Just a couple.
Yeah, Chairman Moody.
As the son of a 72-year-old jurist, no, has it ever been challenged? I missed the beginning of your list. Has it ever been challenged on
Under the federal grounds as a constitutional, I don't think it has. And I would be shocked if you could. I think a state has probably a right under the age portion to put an age restriction in their constitution. So
your HJR does away with the mandatory retirement age?
It does away with it entirely. I mean, another option would be to raise it, but mine just does away with it entirely. Because we would just come up with another number, and remember, age is just a number. We'd just be making up another count.
I know we have minimum age requirements.
We do.
To have elected office. Is there any other example of this in Texas law where we age someone out of elected office?
Not that I am aware of. I mean, we have very esteemed colleagues in the legislature that are over the age of 75 that are doing.
No, we don't do
job.
it here. I was just wondering if we had
not that I'm
anything
aware
else
of.
comparable. Okay, thank you.
Okay. Members, any other questions for Representative Basut? Okay. No one has, you've got a few witnesses who've registered positions on the bill but don't wish to testify. Does anyone want to testify on, for, or against HJR 39? Okay, seeing none, the chair will close public testimony on the HJR and recognizes Representative Basut to close.
Thank you, Mr. Chairman, for the hearing, the opportunity to discuss this, and I just encourage you all to join me in repealing the mandatory retirement age so that we can maintain a good quality judiciary in the state of Texas. I close.
So Representative Basut, I actually do have a question. So if there's currently a sitting judge that, and I imagine this applies at any level, correct?
It applies to any level for which the mandatory retirement age applies to, and I know that's for sure all of the judges listed in Article 1.
Right.
Or Section 1.
So if there's a current justice who believes under current law is serving his or her last term because they're going to age out, and this HJR passes the House and the Senate with 2/3, and the voters pass it in November, they would be eligible to run again?
Yes, or continue to serve as long as they haven't resigned before it takes effect.
Okay.
Or they don't turn 75 before it takes effect and it otherwise applies to them.
Okay. Members, any questions? All right. Thank you, Representative Basut. We will leave HJR 39 pending at this time. Chair now lays out HB 616 and recognizes Representative Basut to explain the bill. I think you do have a committee sub.
I do.
Okay, Representative Schofield lays out the committee substitute to House Bill 616, and the chairman recognizes Representative Vasut to explain the bill.
Thank you, Mr. Chairman. Members, 616 addresses a simple but profound issue. Texas law includes initial and continuing education requirements for district clerks, but the law does not set out any mandated topics to be covered during this training. Now, one of the core, and I would say perhaps the most critical duty of a district clerk is to properly compile a veneer panel. Because if you don't do it randomly, you may deprive a defendant of a fair trial and otherwise disrupt the legal process. In 2021, allegations were made against the Brazoria County District Clerk, my district clerk, that they did not properly select certain petit jury panels over the course of several years. Based upon my review of the investigative report by the Texas Rangers, it appeared to me that this individual either didn't receive initial or continuing education on the proper selection of petit juries. The law on the selection of juries is clear. You have to assemble them randomly. As a state representative, I can't guarantee that law will be enforced because I don't enforce the law. But I believe I can help my constituents and make sure that we reduce the likelihood of a future district clerk in properly selecting a jury panel by increasing the training requirements for district clerks. So how do we do that? Committee substitute for House Bill 616 simply mandates that 1 hour out of the 20 hours of initial training or 20 hours of continuing education cover the topic of proper selection of juries under Texas law. The committee substitute just simply ensures that it applies to district clerks who are responsible for selecting juries. And with that, Mr. Chairman, if there are no questions or witnesses, I reserve the right to close or to answer any questions.
Okay, members, any questions for Representative Vasut? All right. This is 616, right? Okay, does anyone want to testify on, for, or against House Bill 616? Okay, seeing none, public testimony is closed, and the chair recognizes Representative Vasut to close on the bill.
Thank you, Mr. Chairman. Members, I respectfully request your due consideration, and if we want to send it to local and consent if no one's opposed, or otherwise, I defer to your judgment. Thank you.
Okay, members, any questions? All right, the chair will withdraw the committee substitute to House Bill 616, and we'll leave House Bill 616 pending at this time. Chair now lays out House Bill 2381 and recognizes Representative Vasut to explain the bill.
Thank you, Mr. Chairman. Members, House Bill 2381 is a cleanup bill. In 2019, the legislature passed legislation to generally increase the jurisdictional limits of justice courts from a maximum of 10,000 to 20,000. The bill, however, left out the jurisdiction of justice courts for issuing orders in certain repair and remedy cases under the Texas Property Code. All House Bill 2381 does is increase the maximum judgment of a justice court in those types of cases from $10,000 to $20,000. And I believe we will have a witness to testify. I reserve the right to close and happy to answer any questions to the extent I know the answer.
Okay. Members, any questions? All right. The chair calls J.R. Woolley. Judge, I've got you here on behalf of the Justice of the Peace and Constables Association of Texas and yourself testifying for House Bill 2381. Is that correct?
That is correct, Chairman.
Okay, go ahead and start your testimony.
Well, good evening. I think I've said a good afternoon a few times already, but we're moving on through the day, so good evening. As such, I'll keep it pretty short. This was, as Representative Vasut said, was just left out. It was missed in the 86th legislature. The 87th legislature, it was before this committee. It went out of this committee, went to the Senate where it didn't make it for time. So it really just makes it easier for our courts, but it makes it easier for the citizens of the state of Texas. If you have anything less than $20,000, you come to JP Court, except for repair and remedy, and then it's 10. So it's a little confusing, so this cleans that confusion up. It makes it a lot easier for the citizens to understand that the $20,000 limit in justice courts.
Okay. Members, any questions? Okay. Seeing none, thank you for your testimony. Does anyone else wish to testify on, for, or against House Bill 2381? All right. Seeing none, the chair recognizes Representative Vasut to close on the bill.
Simple cleanup bill. respectfully ask for your favorable consideration. Send to local if you like. If otherwise, let's just get it passed. Thank you.
Members, any questions for Representative Massoud? Seeing none, the chair will leave House Bill 2381 pending at this time. Look at that.
I saw Shelby walking. I was out seeing something else. Prosecution after this. Probably taking it down. I don't believe it.
See, this is a harmless bill. So should we raise the age of jurors? Is that what you thought?
Jurists. Jurists.
Yes, but each has one. Yeah.
Obligations.
I mean, if you're gonna have them. No, do they have to get these seasoned because when they're older?
But it's optional, they get to choose.
They do? Yes.
You can basically say, I want to be, or you can walk up and say, I'm this age and I don't want to be. I don't know that your constituents will have basics like a mandatory minimum.
They don't want me to raise it.
No, they want the option, right? So if I feel like an appetite,
But they won't be required to show up for voir dire, for going to voir dire.
All right.
Or what?
We're gonna do something. All right, so the current plan is, I'm gonna lay out House Bill 1745. And once the entire membership of the committee gets here, which should happen shortly, I'm gonna leave the bill pending, we'll take up pending business, and then we'll pick it back up. So the chair lays out House Bill 1745, and I'll recognize myself to explain the bill. Members, appreciate you allowing me the opportunity to lay this out today. In Texas, transportation network companies like Uber and Lyft are required to maintain $1 million in auto liability coverage for drivers to help protect riders and third parties who are injured while taking a ride on that company's platform. More and more frequently, however, these companies are being directly named in lawsuits despite damages claimed being within the coverage amount and without claiming any independent fault or negligence on the part of the company. So instead, the sole basis for naming the transportation network companies as defendants in the majority of Texas cases is based on a claim of vicarious liability. However, vicarious liability is inapplicable to transportation network companies since their drivers are defined as independent contractors pursuant to Texas Occupations Code, Chapter 2402. This bill, House Bill 1745, seeks to reduce legal costs for businesses and in turn costs for Texas consumers by ensuring only meritorious claims are able to proceed. And importantly, this bill maintains the state's strict auto liability insurance coverage, which is much higher than any other vehicle on the road. This bill also requires that any action against a transportation network company on a covered incident include affidavits. showing that damages will exceed the policy limit and describing the negligent act alleged against the company. Under this bill, a transportation network company could not be held vicariously liable if no crime was committed and that company had fulfilled every obligation under their governing statute in the Occupations Code. This does not prevent someone from suing a transportation network company. Those companies can still be sued if there is an independent allegation of negligence. I'm happy to answer any questions and have several witnesses who are here and can speak to more of what's happening in the in this market right now in terms of litigation here in Texas and why our transportation network companies like Uber and Lyft feel this bill is necessary. So, members, I will reserve my right to close, and I'll be happy to answer any questions you may have. Okay, let's go to our witnesses. Chair calls Joe Messina and Lee Parsley, and then Laura Temez and Kelly Cook. Good evening. Thank you for your patience today. Joe, let's start with you. I've got you here representing Uber Technologies, Inc., testifying for House Bill 1745. Is that correct?
That's correct.
Okay, you can proceed with your testimony.
Thank you, Mr. Chairman, committee members. My name is Joe Messina. I'm the Director of Insurance Law and Legislation at Uber. I appreciate the opportunity to provide public testimony on House Bill 1745, which Uber strongly supports. This is a critical piece of legislation that will reduce meritless lawsuits while maintaining the state's demanding insurance requirements for rideshare companies. Texas law currently requires transportation network companies, TNCs like Uber, to maintain auto liability insurance on behalf of drivers while operating on our app. Now that includes $1 million of auto liability insurance once the driver's accepted a trip and is en route to pick up the passenger or is traveling with the passenger. Now, even with that requirement, which mind you is 30 times higher than what is required for every other driver on Texas roads, accidents on our platform are exceedingly rare. 99.99% of trips are completed without any incident. And in the rare case of an accident, these existing insurance requirements are almost always enough to cover injuries or damages. Now, despite that, Texas has seen an increase in the number of cases that name TNCs as defendants, even when the damages sought are within that $1 million liability requirement, and even when there is no independent alleged liability on the part of the TNC. Instead, these lawsuits tried to hold TNCs vicariously liable for the acts of the driver, which is really an employment concept applicable to employers and employees, not independent contractors. They cost TNCs millions of dollars a year, which is then passed on to Texas riders and consumers in the form of higher fares. That is what this legislation tries to address. And the problem is particularly acute in Texas, which is the third most expensive state in the country for these types of lawsuits, trailing only New York and California. Now, the vast majority of these cases are dismissed eventually, but companies are forced to spend millions fighting them in court. I'll give one particularly egregious example if you bear with me. It's a recent case out of Houston. Uber was added to a lawsuit that involved a driver who wasn't engaged on a trip on our app at the time of the incident, and in fact hadn't completed a trip on our app for over a year prior to the accident. Now, despite that, the plaintiff trial attorneys refused to immediately drop us from the suit. Instead, we had to spend 10 months fighting these sorts of vicarious liability allegations before we were properly dismissed, obviously incurring defense costs all along the way. Now, importantly, this legislation is not new or novel. A similar bill was passed in Florida, and other states are actively pursuing their own versions. And a federal law known as the Graves Amendment applies to rental car companies on the issue of vicarious liability. And the law is effective. The Florida law helped reduce frivolous lawsuits by more than 20%. But to be clear here, riders and drivers will still be able to add TNCs to lawsuits when there is independent alleged liability on the part of the TNC. We continue to see that happen in Florida. Thank you, and happy to answer any questions.
Okay, members' questions. Yes, Vice Chair Johnson.
Hello. I have several questions relating to this. One of the things that stands out to me is the provision of the bill that requires counsel for claimants to file an affidavit. That is unprecedented in Texas civil law for the lawyer to file an affidavit of a claim for something that's within their personal knowledge, because none of the events are within the lawyer's personal knowledge. So how in the world are they supposed to sign an affidavit saying, this is within my personal knowledge and all events are true and correct? When they weren't in the car, they weren't part of it. How in the world can they do that?
So my understanding is that these sorts of affidavits are somewhat common in medical malpractice actions.
No, they're not. Not by lawyers. The lawyers do not sign affidavits in medical malpractice cases.
So I actually see it more analogous to a lawyer signing a pleading. A lawyer, when the lawyer signs a pleading, the lawyer is subject to potential
A pleading
sanctions.
is different. A pleading is signed by a lawyer, by the bar, filing a pleading, but it is not an affidavit, which is under oath, sworn to, signed by a notary within somebody's personal knowledge.
So two thoughts on that. One is I actually think the analogy to a pleading is accurate, because that could subject a lawyer to sanctions. The other point is I think the affidavit requirement makes sense. I mean, I don't see a reason why lawyers should be permitted to engage in a fishing expedition without any factual basis to pursue the claim.
There's a difference between pleading requirements where you as a lawyer, we all have an obligation as attorneys who sign our name to a pleadings to, there are remedies for lawyers who falsify pleadings. But what you're asking in this bill becomes an impossibility under the law. Because you're saying, that except at the time the claimant makes to bring the suit, an affidavit by the claimant's counsel that sets forth each theory of recovery for which the damage, well, you already have a pleading that they've already signed. So why is it necessary to have an affidavit? Because again, as I said, none of this is within the personal knowledge of the lawyers that they've been hired to represent. It is impossible for a lawyer to sign an affidavit verifying the facts of a case when they have no personal knowledge of it.
Verifying the facts of the case are true to the lawyer as the lawyer knows them. I mean,
but that's not what an affidavit is.
The intent here is to make sure that meritorious claims proceed. We're open to a discussion on how to achieve that intent, but that is clearly the purpose here.
Well, and we all want that goal. I certainly understand in the situation where somebody has a random $5,000 car wreck case and of innocuous facts, and they sue Uber just because, or whatever, when you have plenty of coverage. I get that. But I have serious concerns over this bill as drafted, because I just don't know how any lawyer can sign an affidavit that the facts are true and correct under their personal knowledge, which is what's required to say. So I would love to see us work on alternative ways to address that. And I brought that up to y'all before, that I had a lot of concerns, and I thought we were going to work on some additional language. So that's a huge issue. The second issue I have is, under what circumstances do you feel, that Uber should have vicarious liability?
Frankly, I don't think that there should be any circumstance. Texas law is quite clear that drivers are independent contractors. The basis for a vicarious liability claim is one of agency or employment. So that legal theory just does not apply in the instance of a TNC with independent contractors.
Yeah, I disagree. But one of the things that I think one of the issues that I've had reached out to me the most about Uber, in particular in context to this bill, that people have reached to my office about, expressing concerns, is over sexual assault cases. In that Uber has had something like 10,000 claims for sexual assault of drivers on its female passengers. And the concern that I have, especially with respect to this hearing, is you make them all sign non-disclosure agreements. They were asked to waive it so that claimants could come into this committee and testify about their experience with Uber, about the seriousness of this bill, and they were refused to be let out of their non-disclosure agreements for purposes of this testimony, and I'd like to know why.
So one instance of a sexual or physical assault is in itself a travesty. I think what needs to be recognized, though, is they are incredibly rare on our platform. You mentioned 10,000. We did 1.3 billion trips last year. So what I think also needs to be made clear is that a claim that Uber somehow contributed to that injury or that damage could still proceed notwithstanding this law. What this law would require to find vicarious liability is to show that there was some violation of law, that there was some violation of the statute. If there is no finding of that, then in that case, the claim of vicarious liability should not proceed.
Well, don't you agree with me that part of the reason of Uber and Lyft's or transportation companies, let me just say, success is that for whatever reason, the public has viewed you as a trusted place for that it would be safe to get into a car when they call for a ride through your app, right? I mean, that's the whole premise of your business.
We have taken many steps over the past several years to try to improve safety on the platform. But again, I think it needs to be recognized that those incidents are very rare when you're talking about 1.3 billion trips.
Well, it might be. I don't think it's rare if you're one of the 10,000 women that were sexually assaulted.
I certainly agree. One instance is too many.
I don't think it's rare. But I mean, the whole point is that the distinction is the public perception that you have, that these companies have screened and continuously screen their drivers such that the public feels safe getting in a car. Otherwise, why not just get in the car with anybody driving down the street? You know, the whole point is that you guys as a company would have verified your drivers in some capacity such that the public relies on that service to justify the fee you take off of taking the ride.
Sure, that's fair, but we are statutorily required to run those sorts of background checks. So if we were to fail in that background check, according to the chairman's bill, that would be a basis to proceed in vicarious liability.
How's the lawyer supposed to know that when they file an affidavit at the beginning of the case?
Well, the affidavit actually doesn't need to be filed under the chairman's bill at the beginning of the case. The case can proceed against the driver, and if at some point it becomes clear to the attorney that there is some basis to bring the TNC into the case, well, then at that point, the affidavit would need to be filed. But any claimant can proceed against a driver in the meantime.
But what if the statute of limitations is run?
There's actually a provision
there's
a provision within the bill that addresses statute of limitations and also allows, at the court's discretion, elongation of the period in the pleadings.
How often does Uber perform a criminal background check on its drivers?
I could be wrong about this, but I believe yearly. But I'll follow up with that, but I believe that that's the case.
How often does Uber perform a driving check on its drivers?
My understanding, again, I'll follow up to be clear, but my understanding is that when a driver is onboarded, the driver needs to provide evidence of insurance, they need to provide their own license, and at that point, a driving record is done. I don't know that it's done again.
You don't do it again. So a driver could be driving with Uber, they might have a clean driving record at the time of initial inception, but they could have subsequent to that, they had 5 accidents, 8 speeding tickets, and Uber doesn't go back and verify their driving record on any systematic basis after the initial onboard. Is that correct?
So my understanding is that that's statutorily dictated, and we comply with Texas law on the point.
Well, no. You have the opportunity to set corporate policies as you see fit, and you have chosen not to do that.
We choose to follow Texas law.
Comply with Texas law.
But they could also, as a company, do updated driver's checks if they wanted to.
So once again, we comply with Texas law, and if we were to violate Texas law under the chairman's bill, we would be subject to vicarious liability.
Thank you.
I have a question.
Representative Davis, and then Representative Flores.
All right, thank you. So just kind of following Vice Chair Johnson's question, and tell me what kind of background checks do you all require?
So my understanding, and I am not an expert on background checks, but my understanding is that we perform background checks that are otherwise run by governmental agencies as well.
I know, but my understanding is, one of the concerns has always been that your background checks are not subject to the most strenuous background checks, FBI, figure back. Is that correct? Are you still doing the partial background check versus the full one?
We do not do fingerprinting. That has long been an issue. It was our position, and it remains our position, that doing fingerprinting would unfortunately prejudice a segment of the population that has had to go through the judicial system.
Okay, wait just a minute. You threw something else in there to me. Tell me, what do you mean by doing an adequate fingerprinting background check? Would do what?
We do not do fingerprinting.
Okay, but isn't that considered the most extensive background check available when you're talking about background checks? Isn't that the one that's lauded as the strongest and most deliberate one to check?
Yeah, I'm not familiar as to how background checks ranked. I mean, I'm sure I would agree that fingerprinting would be an additional step than what we do.
Okay, and so could that be some of the concerns with regard to these cases, because you've not gone back and you don't have the most extensive background, and you may very well have hired someone who had a record that needed to be used to determine whether they should be a driver for you?
Respectfully, I don't agree that would be a valid concern. Texas law is clear on the type of background check that transportation network companies are required to perform, and we comply with the law. So if there was a dispute there, I would suggest that the focus on the statute.
No, don't. But so with all due respect, I appreciate you're saying that's what the law is today. And so the question I'm trying to figure out, can we do better? And would the fingerprint background be better, stronger, and provide more protection?
We would not agree with that. It's our position that it would prejudice a significant segment of the driver population.
And I'm asking you, what is the significant segment that would be prejudiced?
Anybody that's gone through the judicial system and has unfortunately been convicted of a crime, we don't think that those folks should be precluded from taking a trip.
But do you think they should be able to drive and have people in the vehicle with them that they may have they may have background that has that kind of criminal behavior?
I think that is entirely dependent upon the charge with which that they went through the system, and I'm confident that our existing background check satisfies that concern.
So I guess I'm trying to understand, if you were to do your background check and you cleared 10,000 drivers and you did the fingerprint background and you cleared 8,000 drivers instead of the 10,000, for safety purposes, wouldn't that be a benefit to society? To take those 2,000, they may have had questionable backgrounds, or this 2,000 segment wouldn't that be something that?
Yeah, I apologize. I'm not trying to be evasive here. It's very difficult for me to make that comment without knowing about those 2,000 drivers that are being included.
No, we're just hypothetically, if you could find 2,000 drivers that had dings that would appear that they may very well create a crime, and through the background check, fingerprint backgrounds versus what you're doing currently, wouldn't that appear to you that might be a safety measure that could be considered?
It's not a safety measure that we're willing to consider. We view this as a settled matter. But on that point, if that were to be found that we committed a crime in connection to that sort of background check, well, then focusing on the chairman's bill, that would be a live claim. That would be a permissible vicarious.
Okay, so the chairman's bill doesn't ask for that background check. And so I'm wondering if that's something we need to be considering based on the benefit of the value to society, the safety to society. That's the question I'm trying to ask.
I understand.
It's not a trick question.
No,
I'm just trying to figure out, well, this is his bill, he can do it any way he wants to. The question seems to be that of your drivers and people being assaulted. And it would appear if we had some way to measure folks that are being assaulted and separate them from those that don't, that would be a benefit to society. That's all I'm trying to.
Sure, I understand the question. What I can tell you is that no state, to my knowledge, requires fingerprinting. Texas would be an outlier in that regard, and we view the matter as settled law.
No state
requires Uber or Lyft to engage in fingerprinting.
Okay, fingerprinting. I thought you were saying no background check.
Oh, I'm sorry. No,
okay,
fingerprinting
really?
is part of the background. I apologize. That's
okay, thank you.
Representative Flores.
I just have a question about that whole independent contractor question, because Section 2402-114 says they're considered independent contractors if, and then there's A, B, C, D, and then also if you have an agreement in writing with the driver that you agree that they are. And so is that always, are all those elements met so that they are in fact independent contractors? Or is there a way that perhaps maybe one of these elements hasn't been fulfilled and they are not?
No, that is the case. Drivers are independent contractors, and that has been conclusively determined in court in Texas.
How, what do you mean? I don't understand.
There's been several cases on that point.
Okay, so your company does not prescribe specific hours during which the driver is required to be logged into the company's network?
We do not.
Or impose restrictions on the driver's ability to use other transportation network companies?
We do not.
Or limit the territory within which the driver may provide digitally prearranged rides? And restrict the driver from engaging in another transportation, occupation, or business?
No.
And then you always have a signed agreement with the driver that you are independent contractors?
Correct.
Okay, so you meet all the elements of that?
Yes.
Thank you.
Members, are there any other questions for this witness? Thank you. Chair calls on Laura Tamez. And let's say the record reflects that you're here to testify on behalf of the Texas Trial Lawyers Association and yourself against the bill. Is that correct?
Yes, Madam Chair.
Please proceed.
Thank you. Yes, Laura Tamez, President of Texas Trial Lawyers, here against the bill. And I know Chairman Leach is not in the room, but we thank him for allowing us to visit with him about our concerns, and as well as inviting us to meet with the stakeholders, namely Uber, to visit about our concerns on this bill. So these California tech companies have come into Texas, and it's a high-risk business, and that's why they have to carry the policy that they do. But Uber and Lyft and the others are entrusting drivers who are minimally qualified with our Texas families, and our most precious treasures, our daughters and our sons. And therefore, there are exceptions within Texas statutes, although they are afforded protections, unlike other industries. For example, trucking companies, highly regulated, can be sued for vicarious liability, can be sued for gross negligence. So they are afforded protection regarding independent contractor, but there are exceptions. And those exceptions include if there is control of the driver, actual control, if they enable the driver to be distracted, which the app very well can distract while I am in an Uber or a Lyft, and I am a passenger. Sometimes those drivers can accept new rides, which requires them to look at the app and be distracted. And of course, in the event of sexual assault cases where the rideshare companies are required to do the background check, and if they don't, there is an event. But the only way to get to the truth, the only way to get that evidence is discovery. And that brings it, so Section 005 of the bill is problematic because these rideshare companies would be held to the lowest standard of care, where they would only have to show that they didn't commit a crime under the penal code, state or federal, which is unlike, again, any other industry in Texas to be afforded such protection. The Section 003 does create the legal impossibility where the lawyer would have to swear under oath that is more than sanctions. That could subject the lawyer to perjury. If the facts don't turn out, it essentially makes the lawyer a fact witness in the case, creating a conflict because that attorney may only have a police report and was not in the vehicle as a fact witness. So that is part of the issue, because at the end of the day, a sexual assault victim would not be able to find an attorney if attorneys were not willing to risk their license and risk perjury. So that is Section the other issue with Section 003 is the other legal impossibility of having to find an expert witness who could testify that all damages, including non-economic damages, would total over $1 million in advance of any discovery. The Supreme Court has been instructive that we cannot hire experts on hedonic damages to go in and testify about mental anguish, physical impairment. There may only be very little in medical bills with a sexual assault victim, but great damages with mental anguish, pain and suffering, and other trauma. And those damages are within the province of the jury once and if the case is tried. So the other issue I wanted to address is that we want for the committee to have all of the information. And once we met with Uber and their counsel, we did ask if they would waive the confidentiality and non-disparagement agreements for those victims just to tell their experience with provisions without disclosing anything other than the facts that are public. And we were told no. So the other issue is just suing the driver from the outset. That driver may not have access to the platform data or to the communications between the rideshare and the driver or the complaints that have been made about the driver or reviews. If the driver is involved in a crash and there are reviews within their system, which they have to under Texas law keep for 2 years, that information of the rides, then there have been cases with obstructed discovery, pretty heavy-duty protective orders. They're, not engaging in sharing provisions. So it's very difficult to just sue the driver and then believe that you can access information from a California company that would require discovery potentially from a third party if they're not essentially a party. Therefore, to gain discovery, to find the evidence and the truth, Uber is sued. That way we would be able to learn if they violated any of the statutes in Texas and learn if they had controlled actually the conduct of the driver or knew from complaints that submitting them to vicarious liability. So I don't know where my time is because I no longer see the clock. But I am happy to answer any questions. Oh, well then.
Laura, I think you've got some questions. Chairman
Technical.
Chairman Moody.
Actually,
and members, after this witness, we're going to leave this bill pending temporarily, and we're going to take up some pending business and come back to it. So, Chairman Moody.
thank you, sir. And you mentioned it at the top of your testimony. I want to circle back to it. Opportunity to have stakeholder meetings. Chairman Leach is always very good about making sure that those get set up. We deal with, obviously, as this data has shown, we deal with a lot of issues that people come from far apart on. And I have seen a lot of those meetings go very well to where everybody can walk away. And that's always my preference. If we're able to find that ground, let's find it. If we can't, I mean, that happens too. It's a rarity. What can you, if you're able to kind of let us peek behind the curtain and how that's gone, where do you feel there's space when you have those stakeholder meetings to do some work on this? Because it seems like this is one that people are a little bit far apart on.
Right. So in this instance, in meeting with Uber and their counsel, the question was, what is the impetus for the bill? And the answer was, we're getting sued in every case, even when there isn't vicarious liability. And, part of us being a comparative fault state is, you sue the parties based on maybe a police report or based on information, and then you're allowed to discover. Because there are exceptions to a ride share being liable for vicarious liability, that has to be discovered. If there is no instance where there is vicarious liability, they have the affirmative defense, and actually, quite a few defenses within the occupations code that you don't see for a general contractor, that you don't see for trucking companies or other industries that are sued for vicarious liability. The question of direct negligence and that they can still be sued for that is another conversation that we had. And the issue is when there's not an employer, employee, principal agent, direct negligence actions of supervision, hiring are difficult when there's not that relationship. So there's a question there. And those were the conversations that we had, but more importantly about, are there any other states that have the affidavit requirement? And we were provided with the Florida statute They don't have the affidavit requirement. I think there's pending legislation in Missouri, doesn't have the affidavit requirements, the 2 affidavit requirements. So at that, I'm sorry.
I'm so sorry, been
Sure.
a long day. You said that Florida does or does not have?
Does not. So,
To
I'm
me, it
sorry.
seems like we're trying to do things like Florida nowadays. That seems to be the flavor of the day. So that's an interesting point.
So really, that started the discussion, and we were trying to find out, tell us about the cases where you shouldn't belong. How many are there? Is it a ton? Is it a flood of this frivolous litigation? And that is still information that we're waiting on.
Okay, can you, I mean, I guess how those conversations go in advance is important, particularly with our timelines and how things work here. So I'm sure you're informing the chair of those things. If you could also keep us up to date on how those are going.
I am happy to,
Thank
Mr. Chairman.
Members, other questions? Vice Chair Johnson.
Let's talk about affidavits. Are you aware of any circumstances where the lawyers have to provide a personal affidavit of sworn testimony verifying the facts of a case?
No, Madam Chair, I don't.
And then, so then not only that, but then they want to add an affidavit that plaintiffs have to hire by a third-party expert to testify on damages too, correct?
That is correct.
That is also nowhere when you have to provide a damages expert.
They're right. To find an expert qualified in non-economic damages is something that we don't do because, again, that goes back to the province of the jury.
One of the only spaces I'm aware of where at the inception of a case, plaintiffs have to hire under Chapter 74 of medical malpractice cases, but it's on liability facts, it's on negligence. And, but this is a whole different scope of what that is.
That is correct.
Yeah. Thank you.
Thank you.
Members, any other questions for this witness? Okay, thank you. Right now, the chair is going to temporarily close public testimony on House Bill 1745, and we'll leave House Bill 1745 pending at this time so that we can take up just a few quick matters of pending business, and then we'll get right back to it. Members, the chair lays out as a matter of pending business, House Bill 255. This is Representative Swanson's bill relating to the maintenance of records and charging of fees by a notary public and increasing the amount of certain fees. There is a substitute. Representative Vasut offers up a committee substitute. Members, this is the substitute that was laid out during last week's hearing. It adds an additional section stating that the notary public may not either provide a copy of the notary public seal to another person or affix the seal to any document except to authenticate an official act. Are there any questions? Is there any objection to the adoption of the substitute? Seeing none, the substitute is adopted. Members, Representative Swanson has requested that this be sent to the local and consent calendar. Is there any objection to doing so? Okay, seeing none, Representative Murr, Chairman Murr, moves that House Bill 255 as substituted be reported to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr.
Aye.
Schofield. Vasut.
Aye.
Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. The chair now lays out House Bill 266 as pending business. This is Representative Swanson's bill relating to the required filing and use of an affidavit containing the contact information of certain persons in a guardianship proceeding. Are there any questions? Members, like the previous bill, Representative Swanson has requested that this bill be sent to the local and consent calendar. Is there any objection to us doing so? Seeing no objection, Representative Slauson moves that House Bill 266 without amendments be reported to the full House with the recommendation that it do pass and be printed and sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr. Schofield. Vasut. Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. The chair now lays out House Bill 785 as pending business. This is Representative Swanson's bill relating to the delivery of certain notices or other communications in connection with guardianship proceedings. There is a substitute. Representative Schofield offers up that committee substitute. Members, this substitute incorporates language brought forward by stakeholders to address concerns that not every type of guardianship proceeding was given the qualified delivery method option that House Bill 785 seeks to provide. Are there any questions? Is there any objection to the adoption of the substitute? There being no objection, the substitute is adopted. Representative Swanson has requested again that this bill be sent to the local and consent calendar. Is there any objection to us doing so? There being no objection, Representative Chairman Murr moves that House Bill 785 as substituted be reported to the full House with the recommendation that it do pass and be printed and sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr.
Aye.
Schofield. Vasut. Slauson. Flores.
There being nine ayes and 0 nays, the motion prevails. Thank you, Lauren. The chair lays out House Bill 367 as pending business. Members, this is Representative Chatan's bill granting the State Commission on Judicial Conduct the authority to enforce the same actions on judicial candidates that they do on sitting judges. Are there any questions? Representative Johnson moves that House Bill 367 without amendments be reported to the full House with the recommendation that it do pass and be printed and sent to the general calendar. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr. Schofield. Vasut. Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. The chair now lays out House Bill 603 as pending business. Members, this is Representative Shaheen's bill.
Which one?
Actually, the chair withdraws House Bill 603. We're going to leave that pending for now.
All right.
The chair lays out House Bill 1182 as pending business. Members, this is Chairman Harless's bill relating to judicial statistics and other pertinent information gathered by the Texas Judicial Council and certain populous counties. There is a substitute. Representative Vasut offers up a committee substitute. Members, this is the substitute that we laid out during last week's hearing. It narrows the focus by only requiring, in addition to their requirements under current law, the Texas Judicial Council to collect monthly court activity statistics for each trial court in the state, and it removes the listing of all court officials. Are there any questions? Is there any objection to the adoption of the substitute? There being no objection, the substitute is adopted. Representative Flores moves that House Bill 1182, as substituted, be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr.
Aye.
Schofield. Vasut. Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. The chair now lays out House Bill 1255 as pending business. Members, this is Representative Smithy's bill amending current law relating to limitations periods and arbitration proceedings. Are there any questions? Seeing none, Chairman Moody moves that House Bill 1255 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr.
Aye.
Schofield. Vasut. Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. The chair now lays out House Bill 1561 as pending business. Members, this is Representative Smithy's bill relating to the decision of a court of appeals not to accept certain interlocutory appeals. Are there any questions? Seeing none, Chairman Murr moves that House Bill 1561 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr. Schofield. Vasut. Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. The chair now lays out House Bill 1552 as pending business. Members, this is Chairman Guillen's bill relating to a trust beneficiary's approval of a trustee's accounting. There is a substitute. Representative Davis offers up that committee substitute. Members, this is the substitute that was laid out during last week's hearing. It extends the required term limit to object from 180 days to 2 years. Are there any questions?
Yes. I thought, Mr. Chairman, he was going to work on this bill.
Okay.
Am I wrong about that?
Well, have each of you communicated directly with him? I got a notice that it was ready to vote out. But if we can leave it pending if you'd like to have a discussion.
No, if he's.
No, let's leave it pending. I want the members to be comfortable with That's fine. I imagine you'll be hearing from Chairman Guillen this evening. Members, yeah, members, the chair's going to leave. Did I already lay out the committee substitute? All right, so members, the chair is going to withdraw the committee substitute and leave House Bill 1552 pending at this time. Members, the chair lays out House Bill 1741 as pending business. This is my bill relating, creating a criminal offense for the unauthorized disclosure of non-public judicial opinions and judicial work product. There is a substitute. Representative Vice Chair Johnson offers up that committee substitute. This is the substitute that was laid out during last week's hearing. It eliminates a potential concern about prosecutors or defense attorneys filing information with the court under seal. It just clarifies that protection for them. Are there any questions? Seeing none, is there any objection to the adoption of the substitute? Seeing none, the substitute is adopted. Representative Slauson moves that House Bill 1741, as substituted, be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody.
Aye.
Murr.
Aye.
Schofield.
Aye.
Vasut.
Aye.
Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 1763 as pending business. Members, this is my bill relating to the disposition of money from certain attorney accounts delivered to the comptroller as unclaimed property. There is a substitute. Chairman Murr offers up that committee substitute. Members, this is the substitute that was laid out during last week's hearing. It adds additional clarity to the language and contains no substantive revisions whatsoever. Are there any questions?
This is the $50,000 thing?
Correct.
Okay.
Correct. Are there any questions, or is there objection to the adoption of the substitute? Seeing none, the substitute is adopted. Representative Vasut moves that House Bill 1763, as substituted, be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr.
Aye.
Schofield.
Aye.
Vasut.
Aye.
Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. Members, the chair lays out House Bill 2014 as pending business. This is my bill that seeks to increase the amount of juror reimbursement to $20 for the first day or any partial day and $58 for each additional day. Are there any questions? Representative Moody, Chairman Moody moves that House Bill 2014 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr.
Aye.
Schofield.
Aye.
Vasut.
Aye.
Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. Member, the chair now lays out House Bill 2015 as pending business. This is my bill raising the age to qualify for a juror exemption to 75 years of age. Are there any questions? Seeing none, Representative Vasut moves that House Bill 2015 without amendments. On one hand, he's going to make the 75-year-olds happy, and on another hand, he's going to tick them off. So Representative Vasut moves that House Bill 2015 without amendments be reported to the full House with recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis.
Aye.
Moody. Murr.
Aye.
Schofield.
Aye.
Vasut.
Aye.
Slauson. Flores.
There being 9 ayes and 0 nays, the motion prevails. Okay, members, I was going to take up my House Bill 2022 relating to the Residential Construction Liability Act, as well as my House Bill 2024 relating to the statutes of limitation and repose for certain claims arising out of residential construction. We've made substantial progress working in good faith over the past few days on both of those bills. I'm ready to vote them out tonight, but there has been a request that we allow for a couple more days. And so I'm going to call a formal meeting for Monday upon adjournment, and we'll take up these two bills as pending business, and also we'll take up and consider, imagine Chairman Guillen's going to want to vote on his bill on Monday. We'll take up and consider other pending business, including some business that we considered today. Are there any questions, members?
Mr. Chairman.
Yes. Any questions? Did you have questions? Okay. And members, here are the printed, I'll pass these out. Here are the printed committee substitutes for House Bill 2024 and House Bill 2022 for you to review. All right, the chair now lays out as a matter of pending business, House Bill 1745. Members, this is my bill relating to civil actions or arbitrations involving transportation network companies that we were just on. I'm happy to take questions, members, so far if you have them. With that, I'll reserve my right to close, and we're going to reopen public testimony on House Bill 1745, which is currently before the committee. The chair calls Lee Parsley. Lee, I've got you here registered on behalf of Texans for Lawsuit Reform for House Bill 1745. Is that correct?
Yes, that's correct.
Okay, you can start your testimony.
Thank you, Mr. Chairman, members of the committee. Glad to be here again this evening for the last time. I believe that I have reached retirement age since y'all were discussing that earlier. Well, we've been together today. I would note that in our conversation here from the panel tonight, you see what the problem is. The Uber representative tells you that they get sued in every case that a driver is involved in an accident. And they think that they shouldn't be sued in very many of those cases because they don't have vicarious liability because the drivers are not their employees. The TTLA witness says, and this is not a quote, but a shorthand version of, we sue them every time because we need to sue them to find out whether we can actually sue them. In other words, we need to sue them so we can conduct a bunch of discovery and figure out whether or not we've got a claim against them. And that may be an insoluble problem, I'll tell you, because if the idea is that we got to sue them every time in order to figure out we want to sue them, then Uber ends up in every case, which is Uber's complaint. The bill does a commendable job of trying to figure out what to do about that, which is to say something that is not unusual. Let's have some requirement that you prove you've got a lawsuit, sort of. You establish some right to sue somebody before you bring them into the lawsuit. And we do it as this bill seems to be maybe a little bit built around the architects and engineers statute, where you've got an affidavit requirement before you can proceed with a lawsuit. The medical liability statute has a requirement that you file a report before you can proceed with a lawsuit. The old asbestos and silica bill requires that you've got medical criteria met and you've got a medical doctor provide information before you can file a lawsuit. So it's not unusual in Texas law to do what this is doing. Now, I take Chairman Johnson's point that it's unusual maybe for lawyers to have to fill out the affidavit, but the idea of saying that you might have to cross some hurdle before you bring someone into a lawsuit is not unheard of in Texas law. And the second part of the bill really is what says that Uber doesn't have vicarious liability except in some circumstances, which I think is actually a sort of a redundancy in the law. I think Uber doesn't have vicarious liability when these people are not their employees. And so saying so in this bill is not earth-shattering. It doesn't strike me. The bill doesn't do away with direct negligence claims. And so those seem to be retained. So as Ms. Tamez said, if Uber has distracted the driver, then Uber has been negligent in its own right, and it may have liability under a direct negligence claim. If it has hired somebody it shouldn't have hired, it may have a direct negligence for a sexual assault. So the direct negligence claims seem to survive under this bill as written, which again seems reasonable enough to us. So we appreciate the ability to come to you this evening in support of the bill. We've not been involved in the stakeholders meetings on this, but if anybody thinks our involvement would be helpful, we'll be more than happy to do that.
Okay, members, any questions? Any questions? All right, thank you, Lee. The chair calls Kelly Cook?
Yes.
Okay. Kelly, I've got you here registered on behalf of yourself, testifying against House Bill 1745. Is that correct?
That's correct.
Okay, go ahead and start your testimony.
My name is Kelly Cook. I'm a board-certified personal injury trial attorney practicing in Houston, Texas since 2008, and I'm here to talk to you very briefly about two of my favorite clients. One of them was a police officer for 20 years of uniformed service. When he retired on the Friday, the following Monday, he went to work for the West Virginia Governor's Highway Safety Program, teaching police officers how to run radar, how to do lasers, how to install child safety seats, how to avoid distracted driving, and he gave driving lessons or driving courses to businesses all across West Virginia and that part of the world. The other one of my favorite clients was an insurance agent. She sold insurance in West Virginia for many years before she moved to Texas and started selling insurance and sort of a part-time job in her retirement. Most significantly to me about these two folks is they're my parents. And back in May of 2022, they were going to go to a baseball game and asked me to drive them, and I dropped them off at the Houston Astros baseball game. And when they were ready to come home, they called, and I had just had a
really long day at work, and I said, you know what, I'm just gonna call you an Uber, and you can come home that way. And so I called an Uber for them, and about 15 minutes later, I got a phone call from my mom that they had been in an accident, and that my dad was hurt, and that the driver either couldn't or would not call 911. Apparently the driver did not speak English, and so even though I could hear my dad in the background saying that he was hurt, I had to tell my mom, get off the phone with me and you call 911 and get help. That crash happened because the Uber driver, and I'm not meaning to pick on Uber, it's just that's who this particular one was distracted by the app on his phone. My mom watched as he was looking down, responding to a ping or whatever was happening. She sees him looking down at his phone as he goes right through a red light without turning or slowing down. And they were T-boned right in the right rear of the vehicle, spun around. Dad hurt his hip. And I've seen the same thing when I'm in a Lyft or an Uber where the driver is looking at the app, accepting calls, or on the phone with other people during the ride. That is what my biggest concern is. Respectfully, I do not understand why this committee, this legislature, or the people of the state of Texas should erect barriers to holding out-of-state transportation companies responsible when the app that they use, their business model, involves distracting drivers. Ironically, one of the very things that my dad teaches people not to do, not to drive distracted. Thankfully, my folks survived with not life-threatening injuries, not life-altering injuries, but someone's parent, someone's child, someone's spouse is going to be seriously hurt, seriously killed, and I hope that this committee does not close the courthouse door. Thank you. I respectfully request the committee reject HB 1745.
Okay, thank you for your testimony, and I'm sorry to hear about your parents, but it sounds like everything's okay now? Okay, thank you. I'm glad to hear that, and thank you for sharing your testimony. Members, are there any questions? Okay, can I go back to, before I close this panel, Mr. Messina, can I go back to you? And yeah, Mr. Messina, I've got you here on behalf of Uber Technologies, Inc., testifying for House Bill 1745, is that correct?
That's correct.
Okay. Can you, I don't want you to have to get into case level specifics on that specific case, but I've heard that testimony a lot, is drivers either using apps. I've actually never had the personal experience with an Uber or Lyft driver where they're answering calls in the middle of a ride. I've seen them receive calls and it's always decline. That's my own personal experience. Or they're watching the Waze app and trying to efficiently navigate traffic, which all of us do, which actually is not prohibited under state law to use real-time mapping software. And so, but I'd like for you, Mr. Messina, to the extent that you can, respond to that. And what does Uber do specifically when it comes to distracted driving and of the drivers?
Sure. Thank you, Mr. Chairman, and I'm very sorry to hear about your parents. Two thoughts there. One is if the driver was distracted or doing something wrong on his or her own, in that instance, the driver would likely be negligent, and that's the type of situation where a $1 million auto liability policy would come into play, and that there would be $1 million to recover from the driver for the driver's negligence. If there is a claim that Uber somehow contributed to that accident by providing an app which was inherently distracting or sent a ping that was negligence on Uber's part to contribute to the accident, well, that's the type of thing that I think would still live on separate from a vicarious liability claim. So I'm not sure, I don't think that this bill would preclude that lawsuit.
So it would be a direct claim against Uber for,
yes.
And you're saying that in the situation, and I hate to speak about that specific case, but a case like it, so the plaintiff's attorney would, or the plaintiff would file against the driver and then perform some discovery and then bring in Uber if necessary?
Correct, yeah, the claim would be directly against Uber too. That would not be a vicarious liability claim, so it wouldn't be touched by this legislation. It's to the point that I think the legislation in itself is not precluding all claims against TNCs. This is a perfect example of a claim that would survive.
Okay, members, any questions? No. All right, Thank you. Appreciate all of you for your patience today. The chair calls Toby Toller, Brent Walker, Quentin Brogdon, and Lauren Wilk. Toby Toller, Brent Walker, Quentin Brogdon, and Lauren Wilk. And then the next panel of witnesses will be our final 3 witnesses on this bill: Andrew Tugel, Molly Fryer, Hedgepeth, and Ross Evans. You'll be next. Toby? Actually, Lauren, let's start with you.
Okay.
Lauren, if you'll state your, actually, I've got you here registered on behalf of yourself against House Bill 1745.
That is correct.
Is it Lauren Wilkie?
Yes, it's
Okay.
Wilkie.
Lauren Wilkie here on behalf of yourself against House Bill 1745. That's correct?
Yes, sir.
Okay, go ahead. You can start your testimony.
Awesome. Well, good evening, everyone. The few left of you still.
Well, just for your information, for those of you who are still here and aren't used to this, members have other committee obligations tonight. They could be back eating some dinner in the back room, but please be fully aware and advised that they're listening to your testimony. Their staffs are listening to your testimony. They will receive your testimony. So I apologize for their absence, but it's just part of the process. But they hear you loud and clear. I promise you that. So you can go ahead and start your testimony. I'll restart your time.
Good evening. My name is Lauren Wilkie, and I am from the great city of Dallas, and I oppose House Bill 1745. On August 20th, 2022, a night out with my older brother and his girlfriend full of karaoke and cheap beer turned into a nightmare in a Taco Bell parking lot. Usually, as a 20-something-year-old, that means someone may have just gotten too drunk. For me, that was a different story. After my night out, a safe ride home in an Uber was my best choice and my next choice. At 12:05 a.m., I was picked up at the local karaoke bar by my Uber driver. At that time, I verified that the vehicle and the driver match exactly the information Uber provided me based off of their recommendations for their safety. Upon pickup, I was met with inappropriate comments about my face and my body. Shortly after pickup, I was taken to a Taco Bell parking lot where my driver took the opportunity to penetrate my body without consent. I had sent my location to my best friend pleading for help, and that was the last thing I remembered of that encounter. Shortly after realizing the magnitude of the situation and trying to process what occurred, I demanded that the driver actually drove me home while frantically calling my friends for help. Upon arrival, he followed me into my apartment where he attempted to sexually assault me again. In terror, I ran to the bathroom and demanded that he leave immediately. He left me in my apartment violated and scared. At first contact with Uber's safety incident team was at 6:30 a.m. following the incident. At 6:33, I was thanked for submitting a report, and at 6:55 a.m. on August 20th, I was refunded $22.09 and told they would investigate the situation further. This was the last time since August 20th, 2022, I had been contacted by Uber. Was my body, my dignity, and my safety worth the $22.09? For once in my life, I felt like I do not have control of my body. After extensive and expensive therapy and a new security system, I'm starting to live somewhat of a normal life again, but nothing will take away the fear, vulnerability, and horror instilled in me from that night. I have no closure on my driver's whereabouts and any accountability from Uber. Uber is continuously finding ways to remove liability from themselves and silence victims. I stand here today seeking accountability for rideshare platforms and those drivers who are employed by these platforms, however you want to label that and define it. It states in Uber's mission statement that they champion your right to move and earn freely and without fear. However, fear is all I associate with Uber now. I urge you members to put these corporations' best interests aside and think about your constituents and consider voting no on House Bill 1745. Thank you.
Lauren, thank you so much for your testimony. I know how what it takes to so courageously and bravely share your story, and on behalf of the committee, I thank you for your testimony. This bill, this committee will pass no bill this session, nor would I ever support a bill that came in the way of victims of sexual abuse and assault from seeking justice. The reality is you'll never be made whole. But we should give you every single opportunity to attempt to be. And so I'm so sorry for what you went through, but I appreciate you sharing your story with us today. Vice Chair Johnson.
I was just going to echo Chairman Leach. Thank you for being here and waiting all day. A long day. We started at 8 o'clock this morning. We're 11 hours in for you to share your story and the courage to do it. Thank you.
Thank you.
And I'd like to follow back up with some, I know we're about to hear some more testimony like this, which is fine. It's great. We welcome that, and it will help us perfect this legislation. And like I said, in no way would I support or will this committee vote on any bill that prevents you or any other victim from obtaining justice. You have my word on that. So we'll communicate further as we work to fine tune and perfect the bill. Members, any other questions? Okay. The chair calls Toby Toller. Toby, if you'll, I've got you here registered on behalf of yourself against House Bill 1745. Is that correct?
Yes.
Okay, you can start your testimony.
Thank you, Mr. Chairman. My name is Toby Toller. I'm accompanied by my wife, Carol Toller, at this hearing. We are opposed to House Bill 1745.
Mr. Toller, can you state again who you just testified in opposition on behalf of? I'm sorry, I was asking my vice chair a question. Can you repeat what you just said?
I'm sorry, Mr. Chairman.
No, you're fine. That's my fault. Go ahead.
Of course. I'm here on behalf of myself.
Okay.
To testify against House Bill 1745. May I leave it at that? May I correct the record?
Yes.
Thank you.
That's what the record reflects.
Thank
so
you.
If that's accurate, then
we got a good record,
all right,
Mr. Chairman,
go ahead.
so far.
Go ahead.
I want to amend my prepared remarks to go along with what I've heard already and what the chair and other members have said to this moment. So if I might have just a moment to gather myself.
Take your time.
Thank you. I appreciate that. I know time is short. My daughter met friends at an uptown Dallas watering hole to celebrate a friend's birthday. My daughter at the time was 27, and she had a little more than she should to drink, and she did what we asked her to do, two things. She did not get behind the wheel, and she hailed an app to take her, hopefully, safely home. And that's not what happened in my daughter's case. And we live with its effects all the time, which is, I think, one of the questions the chair asked just, or somebody asked just a moment ago. It's a daily thing. She was the victim of a sex assault. The driver followed her into the house, popped her on the back of the head with something we don't know what, and pushed her to the ground, rifled through her possessions, and sexually assaulted her, and hung around for a little while and left. My daughter gathered herself by the next morning, reported it to authorities, and I must say, if you've ever heard of anything called a sane nurse, sexual assault nurse is angels from heaven. And investigators and prosecutors from the Dallas PD Sexual Assault Department, equally angels sent from heaven. They moved with amazing speed, and they asked my daughter to do something I don't know where she found the strength to do it. They asked her to make a phone call to her rapist Uber driver, and she did. And the substance of the phone call was to have a meeting. Let's get together. Well, and that was agreed to, and the next thing you know, the cops show up instead of my daughter, and that's when the suspect was arrested. And that arrest led to all sorts of publicity. Publicity went viral, if that's a thing, back in 2015. So with that context as a backdrop, the next couple of things happened, of course, included her testimony and prep at a criminal trial. And the jury found the defendant her attacker guilty, and Her Honor Judge Gracie Lewis sentenced him to 25 years, which he is now serving today. So, again, excuse me. It never goes away, Mr. Chairman. I'm sorry, it never goes away. Give me just one moment. Let me tell you about when we got her back home after all of that investigative cooperation. We stopped everything. We run a small family-owned property tax consulting business. We just have the most boring lives ever. Nothing ever happens in our life except appraisal review boards. But we brought our daughter to our home, and we sat her down and we nursed her as best we could for days on end, never left the house. And when the press story came out about her attacker's identity, which our daughter had no idea who it was, I just opened a browser on my laptop and did a simple web search. And I typed in his name. And what poured out initially and what led me to further steps included, if I may, the following. Her attacker was a 3-time loser in the judicial system. When he was pursued because he was a terrorist threat. Coming out of the 9/11 attacks, the Justice Department formed an anti-terrorism task force. And it was an amazing thing. And they targeted this guy immediately. And the Bureau and all kinds of things happened. But long story short, by the time they arrested him, they busted him for being a felon in possession of firearms, that he was trying to buy and sell Stinger missiles. I have no idea what a Stinger missile is, so I had to look it up. Anti-tank weapons and other military items, which would have been purloined from the nearby military base in Central California where he lived at the time. And also, I forgot this one thing. There was a murder for hire in their sentencing memorandum as well, for trying to find a hitman to take out his wife. And it was not his first instance of a domestic assault, nor was it his last. So, Mr. Chairman, members, this is part of the learned experience that we had. And I guess I bring it to you because we're just simple folks. We don't know anything about writing legislation. We don't know anything about affidavits other than it's a pint of blood. We don't know anything about that. We just know what happened to our daughter and how when she pushed her app button, she had no idea. She had no disclosure. I don't know if the guy had a rap sheet that he could have showed her, say, before you get in my car, you want to look at this? I don't know what your answer is. And I heard the chair say, over your dead body, you weren't interested in any of these cases not being heard. Thank you for that. I look forward to following this and knowing that, Mr. Chairman. And if I may, everything I've said today, I've found the vast majority of it, especially the sentencing memorandums, things like that, written by DOJ, the Joint Terrorism Task Force, for his sentencing in 2006. And by the time he served his term and was released on, and I get this word messed, supervised release. I don't know if that's probation or parole, somebody will have to tell me, but he was on supervised release. And while he was on supervised release, he moved to Texas, came to Dallas, and applied to be a driver while on supervised release. So I'm just, I know that's 7-ish years ago. Seems like yesterday. Getting ready for this hearing made it seem like it was an hour ago. And with that, Mr. Chairman, you've been considerate to my time constraints, and I want to express my appreciation to the chair and to the panel for putting the clock aside. I very much appreciate that. I hope you'll take all the adequate considerations possible considering this bill and understand that 100% of what I've talked about, I found on a Google search in the public domain. And if I could conclude with, immediately after the suspect's arrest, there was this interesting interchange between the media, the city, and the Uber folks. They were having a dispute over who did what. It was kind of an interesting thing. So we sat there and watched those bullets fly across the screen. And by the time all that was said and done, the rideshare company submitted a letter to the morning news, and the letter said that they're going to change their policies as a result of what's occurred. And this was, forgive me, Mr. Chair, 2015, early 2016, right in there. And here's what it just feels like to me. Again, just a simple old property tax guy. I'm better on making adjustments on real estate appraisals than I am on trying to write or recommend legislation. But it feels like what they said in the letter, public, this feels like an about face. This feels like it's now a different animal. They're going back to what it was. So it feels like it's a change of policy. And that's what strikes at us. So beyond that, any of the other technicalities, forgive me. I don't write laws. So I want to, again, Mr. Chairman, members, thank you for your courtesy for me. And
all right.
Thank you.
Thank you. Thank you for your testimony, and I'm so sorry what happened to your daughter. We're all taking notes up here, and I know I am, and we'll be discussing a lot of what you just mentioned with the folks from Uber and Lyft and others. So thank you for your testimony. Members' questions. The chair calls Quentin Brogdon. Quentin, I've got you registered here on behalf of yourself and testifying against House Bill 1745.
Thank you, Chairman Lee.
Correct?
Yes, Quentin Brogdon testifying for myself against the bill. I've been a trial attorney for 33 years, and fortunately, during almost all of those 33 years, I've handled in one form or another sexual assault cases. I started out as a prosecutor in Houston, where I handled cases involving rapes, among other serious criminal cases. And then for a number of years, I was a defense attorney, during which I defended mainly premises owners, but also sliding glass door manufacturers and window manufacturers in cases involving violent rapes and assaults, usually almost exclusively of women. And so I've had, unfortunately, the experience of handling these cases for a number of years. Beginning in 1998, I moved to Dallas, and I became a plaintiff's attorney from that point on, but I've continued to handle those cases, including cases against rideshare companies, Uber, Lyft, and others. I'll tell you, beginning about 8 years ago, I started receiving a good number of calls from passengers in Ubers and Lyfts who had been sexually assaulted. Enough of those calls, and I've now handled probably 24 of those cases, enough of those calls that I began asking myself why. I had never gotten calls from people who rode in taxi cabs. I still haven't gotten those calls in anything like these numbers. Something is very broken. And so I began looking into it, and as Representative Davis said, the answer is pretty simple. It's fingerprinting. These companies don't do it. They refuse to do it. I understand they have a publicly stated position as to why they won't do it, but that's the issue. They're not doing proper screening of their drivers, and predictably, obviously, and preventably, those drivers are ending up paired with young, sometimes intoxicated, admittedly, but they market for those passengers, by the way, in those cabs, in those Ubers and Lyfts late at night, where they're basically locked in a car with these people. So the cases against these so-called transportation network companies, TNCs, are already hard because of the bill you all passed in 2017, HB 100. And it gave them quite a few protections that nobody else gets. It prohibits, actually, cities like Dallas and Austin and others from requiring fingerprinting. They only get to require the cities what's in that bill, HB 100, and fingerprinting ain't in there. So they don't get to require that. And then they only have to exercise ordinary care instead of the care that a taxi cab would have to exercise, or a bus driver, which is high degree of care because they're a common carrier. That's been rewritten in the law. So they already have quite a few protections already in the existing state of the law. But I just want to close with talking about some of the statistics, because unfortunately I've had the extremely unpleasant experience of sitting across the table from many, many rape victims. It is the worst nightmare for any woman. It's the worst nightmare for any man with a husband, a mother, a wife, a daughter, heaven forbid, as you just heard from Mr. Toller. So the statistics are pretty sobering. It turns out 2/3 of sexual assaults aren't even reported. So what we know about is the tip of the iceberg. And we wouldn't know what we know about unless it began, CNN in 2018 kind of pulled back the covers on the rideshare industry and the statistics, and I won't get into all that, but they did a comprehensive search. There were 103 Uber drivers accused of sexual assaults in the past 4 years, 18 Lyft drivers. And Uber and Lyft try and put those in a context of, well, look how many rides we do. But if you're the poor unfortunate victim, or if your daughter is, or your wife, of a sexual assault that was preventable, and I just don't see these numbers happening with taxi drivers. In the wake of that, Uber and Lyft have both released now reports of sexual assaults that shed some light on it. And I won't get into all the stats, but stats are pretty sobering. In October 21, Lyft had 4,100 total reports of sexual assaults in October 21. They released it between 2017 and 2019. They had 1,800 reports of sexual assaults just in the year 2019. Uber, likewise, has reported assaults in 2018. 1,560 reports of non-consensual touching of a sexual body part, 376 reports of kissing sexual body parts, 280 reports of attempted non-consensual sexual penetration, and 235 reports of non-consensual sexual penetration. So all of these statistics are sobering, and I'm simply here to say, please keep this in a context, and I understand the pitch has been made, this is traffic accidents and this, but my focus is more on these sexual assault cases, which unfortunately I've had the misexperience, some would say, of handling from both sides. I've defended them, I've prosecuted them, I've never defended a rapist. I've defended companies sued because of them, and I urge you to tread very carefully before you grant Uber, Lyft, and any other transportation network company further protections that would further disincentivize them to do what they should be doing. Firstly, fingerprinting, but other things as well, to make their passengers safe with the drivers they pair them with. Thank you very much for your time, and I'm here to answer any questions.
Thanks for your testimony. Let me go with Representative Flores and then Vice Chair Johnson. Representative.
Thank you for your testimony, and thank you for bringing up the fact that Austin and Dallas got preempted by the legislation, as we had a big fight, as you know, with the rideshare companies about fingerprinting and wanting to bring them up to the same standards that the taxi companies were held to. So I appreciate that, because I too think that the law that was written to not only preempt these cities from regulating their own cities and their own citizen safety, were greatly influenced, let's just say, by those companies in terms of writing in protections already there. So I do appreciate your testimony, and I just wanted to say that. Thank you.
Thank you, Representative Flores.
Vice Chair Johnson.
Hi, Quentin. This bill is aimed at filing frivolous pleadings, but we already have a statute in the Civil Practice Remedies Code, Chapter 10, of lawyers signing and filing frivolous pleadings and motions. We already have sanctions provisions in the statutes that judges can assess against lawyers for filing frivolous pleadings. So this remedy is already available to companies like Uber when they feel like that suits have been brought maliciously, correct? Or inappropriately. Is that true?
Agreed, 1,000%, Representative Johnson.
And
Vice Chair Johnson.
I know, doesn't that sound good?
I will give you your due title.
But I'm very concerned, as I've obviously expressed tonight about the affidavit requirements for lawyers. Are you familiar with any scenario where a lawyer has to sign a personal affidavit sworn to by personal knowledge of the facts of the underlying case of the clients that they represent?
No scenario, and I believe it's not workable for the reasons you've said. It just encourages people to sign things potentially that get them in trouble for perjury later. Even the protection afforded doctors in the state of Texas, and I've handled a great number of medical malpractice cases over the years, does not require anything of this magnitude and putting the attorney in such personal jeopardy. I think it's redundant, it's not necessary, and I think the existing mechanisms in the law are there to be enforced for so-called frivolous cases.
Thank you.
Members, any other questions? All right, thank you for your testimony, Quentin. Chair calls Brent Walker. Brent, I've got you registered here on behalf of yourself against House Bill 1745.
That's correct. Thank you, Chair Leach, for having me. I've listened to far too many parents, far too many people who have been hurt, victimized by Uber and Lyft drivers. And the one thing I wanted to do when I came here was to let y'all feel that. I'm so glad these two people have testified because you've seen the kind of people who call my office. I'm a plaintiff's lawyer. I represent people who are mostly catastrophically injured. I've seen too many victims of sexual assault, too many victims of bad drivers who are now in situations like being quadriplegic. I've had 2 cases against Uber and Lyft, separate cases, with 24-year-olds who are now quadriplegic for the rest of their lives because of bad drivers by Uber and Lyft. These are not good corporate citizens. They're not. And that makes me wonder why we are even...
Uber's not a good corporate citizen?
No, sir.
Can you imagine our streets without the services that Uber and Lyft are providing?
We had it for a long period of time, yes, sir.
Do you want to go back there?
I would say that for this purpose, the number of sexual victims...
No. You just made the blanket statement that Uber is not a good corporate citizen.
Yes, sir.
You would prefer our roadways without Uber?
I would prefer a roadway with the company that, as Quentin said, does proper safety and
security. You said Uber is not a good corporate citizen. You would prefer our roadways right now without Uber?
I would prefer our roadways with a system that is properly, that they follow the law like every other corporation.
If you want to come here, and I'm sorry for the frustration.
Yes.
But I'm frustrated because we're here, and I believe that Uber, which is not perfect, but wants to help us establish good and push forward and adopt good public policy in this state that protects Texans. I'm grateful for Uber and Lyft and transportation network companies, and I cannot imagine a state that doesn't have transportation network companies. They're not a bad corporate citizen. Are they perfect? No. Show me a company that is.
Yeah, and Vice Chair, I would simply say that, or Chair Leach, I would simply say this. I'm not suggesting that transportation network companies are inherently bad corporate citizens. I'm saying these particular ones, for instance, I have clients that could come and testify to you here today, but they can't, as Vice Chair Johnson noted, because they've been gagged by these companies, so they can't share their stories with you. And this is a recurring issue. I would suggest it's even far more significant than the statistics that Mr. Brogdon said. This is a significant issue. And what Uber and Lyft have done is they have gone into states and they have asked for special protections that are not afforded any other corporation. They don't want to operate under the same rules. And they asked for a bill in 2017, House HB 100 was passed, and it provided them protections that no one else received. And yet they're back here asking for further protections that I would question, if you're going to afford those to them, why? Why do they get treated differently than every other corporation? Why are they the ones that don't follow the 200 years of law we have on vicarious liability? Why are they the ones that can suggest that we have affidavits signed by lawyers? Affidavits which lawyers can't sign themselves, because if lawyers had fact knowledge of a case, they couldn't be the lawyer.
Uber didn't file this bill. I filed this bill. This is my bill. And I'm admitting to you right now that it's not perfect and it needs work. And if you want to work with us in good faith to improve it and to strengthen it, I welcome that. Because I promise you that Uber is at the table working with us, this bill will look substantially different before its final passage, before it's ever voted out of this committee. And if it doesn't, then we won't vote on it.
So,
But work with us in good faith instead of, instead of just, implying or suggesting outright that they're a bad corporate citizen.
well, Chair Leach, I heard Mr. Messina say that the reason for this bill is they feel like they're getting sued too often in cases in which the damages are less than $1 million. We currently have, under Texas Rules Civil Procedure 47, a requirement that every lawsuit disclose the amount at issue in a case. So if their concern was just that they were being sued in cases that are under $1 million, a very simple way to prepare that bill would say, okay, well, in cases in which it's pled in less than $1 million, you don't need to add Uber to them. That would resolve the issue that Mr. Messina raised. But instead, what we have is a bill that has all these obligations with affidavits and immunity in Section 005, immunity that no other corporation has. It changes the law on vicarious liability. It imposes an obligation that a company has to be criminal and be held liable for vicarious liability. It has these other requirements that are not existent in any other statute. And so the question would be, if the concern is one thing, that they're being sued too often, there are already remedies, but there's also an easier way to draft this bill to not include this expansive protection. I was very touched by...
Have you submitted language to my office?
No, sir, I haven't.
When can you get me language that you would be okay with?
Well, I don't believe that...
Can you get that to me by the end of the week? Because you're saying that there is a way that Uber could achieve its stated goal. That's not the way this bill is written. So I'm asking you, when can you get me the language that you're talking about?
Sir, I'm here to testify on behalf that this bill is not necessary at all in total. I don't think that this bill at all is necessary because no other corporation has this type of protection.
You just testified that there are some, I don't know your exact language, but there are some ways that the bill could be reworded or rewritten, some sections of the bill that we could take a different approach on.
Sure.
And I would love to hear from you instead of just coming here and opposing. Send me language. I'm happy to consider it.
Right. I believe that this it does not address the concern that they have raised. If that is their concern, as I said, the Rule 47 provides a way to address that concern, separate and apart from this bill, which goes far beyond what their stated concern is. And we haven't seen any data. We haven't seen any data about this excessive amount of litigation. We haven't seen any data about how many times courts have thrown cases out because they're unmeritorious against Uber and Lyft. We've just heard from them that they're getting sued a lot and that they don't like it and that they would like additional protections that no other corporation has had. These corporations...
You said you represented two, who were the victims in your accidents?
I have I've represented many victims. The two I referred to were
in lawsuits against transportation network companies?
Uber and Lyft, yes, sir.
Okay, and in that case specifically, did you recover a judgment or was the case settled?
They're two separate cases, sir.
Okay, so pick the higher one, the higher settlement amount or judgment amount.
Well, one of them was settled, but I can't discuss it because of the confidentiality, which I can't get relief from. The other one is currently pending.
Okay.
And I was very touched, Chair Leach, when you said, and I take you completely, that you would never file a bill that you thought would close the courthouse doors to these people. And I know you wouldn't do that. I do think, though, that Uber and Lyft would like to do that. That's the reason why they have passed, and I understand this is not their bill, this is your bill, but they have tried to pass similar bills in states around the country, both in 2017 when the initial bill was passed and this new round of bills. I think they do want to close the courthouse door because that seems to be what they have asked for through these legislators, is the ability to insulate themselves from liability that no other corporation has the protections from. And I just wonder why. Why these two companies? Why are they special? Why do they deserve more protections than anyone else does? What are they doing that suggests that they are the type of corporations that should be held out as
I think they're
special?
providing a great service to the people of Texas
and
roadways all across the country.
And I think they can provide a service without having all these protections. Taxi cabs did it for years. Other businesses could do it. I'm not getting, as Quentin said, I don't get phone calls about quadriplegic people because taxi cab drivers are unqualified or that victims of sexual assault from taxi cab drivers. But I do get those for Uber and Lyft, and something is fundamentally wrong with them. And instead of looking at that, we're offering them some further protections that no other corporation has. So I don't understand why we're considering this bill. It certainly hasn't had any data to support that it's necessary or that Uber and Lyft are going to leave the state if they don't get this type of protection. That was the type of information we had when we passed Chapter 74 back in 2003. There was a crisis we had to address. What's the crisis here? There's not one. We don't have any data to suggest there's anything that should elicit this type of protection. And so the fact that it's being requested, I think, is for their own self-interest and not for the interest of the citizens of Texas.
It's interesting. You talk about self-interest. I would love to see your contingency fee agreements with the clients that you represent.
Sir, as it comes to my clients, I have a 25-year-old who's a quadriplegic. If the courthouse door is closed to him.
We're not trying to close the courthouse door to him. No one is trying to do that.
Well, respectfully, the notion of trying to immunize themselves from any claim of vicarious liability.
There are still direct claims, all sorts of direct claims that can be brought against transportation network companies that survive this. No one's saying this bill is not, the aim of this bill is not to prevent companies like Uber and Lyft from ever being sued.
But in any other corporation, there may be ways to hold them liable that we cannot hold Uber and Lyft liable if a bill like this passed.
And the reason is, and then we're going to go on to the next panel witness, the reason is the drivers are independent contractors under Texas state law. There might be disagreement about whether that's actually the case, but that is the legal case. And so we're trying to figure out how we approach it from a vicarious liability perspective, how we can still, because I don't want a state where Uber and Lyft are not here and their drivers are not providing the services that they are on Texas roads. I don't want that state. I tell my kids aren't old enough yet, but I certainly tell my staff here and my law firm in Dallas, anyone that looks to me I tell people I will pay for your Uber ride home from the Christmas party.
And that's what my clients' parents thought too, and that's what these people thought as well.
I understand, and I've made clear that I'm not interested at all in preventing from Lauren and your daughter from seeking justice. And from where Uber and Lyft have messed up, where there are reasons for them to be held liable, where they absolutely throw open the courthouse doors to all your clients. But for the plaintiffs' attorneys that are out there looking to profit off of frivolous and meritless lawsuits and claims, I believe that we need legislation in this state to prevent that.
And as Vice Chair Johnson said, there's already, if your concern is about frivolous claims, there's already plenty of protections currently in place, and there's no data to suggest that there is an excess amount of frivolous claims against these two entities.
Members, any other questions? Vice Chair Johnson. Members, any other? All right, thank you for your testimony. The chair calls Andrew Tugel, Molly Fryer-Hedgepeth, and Ross Evans. Andrew?
Yes, Mr. Chairman.
Are you Andrew?
I'm Andrew.
Okay, Andrew. I've got you here registering on behalf of yourself against House Bill 1745.
That's correct, Mr.
And this is the last panel, sorry, before you go, this is the last panel of witnesses. Anyone else who wishes to testify on, for, or against House Bill 1745, please make your way to the kiosks and get registered. Andrew, I've got you here registered on behalf of yourself against House Bill 1745. Is that correct?
That's correct, Mr. Chairman.
Go ahead.
Mr. Chairman, my name is Andrew Tugel, and I'm really here to introduce Miss Molly Fryer-Hedgepeth. She's my client. When the gentleman from Uber talked about it's settled law that you can't recover against Uber or Lyft for accidents, Miss Fryer-Hedgepeth, she is the law. She's the case out of the Dallas Court of Appeals. And so she's here to share her story. Okay. Her case was already decided under the previous law passed by this committee, but it begs the question what further protections are needed. So with that, I will.
Yeah, thank you. Thanks for your testimony. Members, any questions for the witness? Thank you, Andrew. All right, the chair now recognizes Molly Fryer Hedgepeth. Am I saying that correct?
Yes, I got remarried, so I have the old one on there.
So I've got you here testifying on behalf of yourself against House Bill 1745. Is that correct?
That is correct.
Okay, you can go ahead.
Okay, so I'm opposing the bill 1745 because personal experience, what happened to me was that I was coming back home from the airport, and I got a lift from the app, and it was in 2017. It was around the time of Hurricane Harvey, so everybody was trying to leave, the area. So I was heading home, and I was leaving the DFW airport, and my Lyft driver, we were in Bedford, kind of on the highway. My Lyft driver, she told me that she might need to pull over in a minute because she's feeling dizzy, and I was like, just pull over. And she did not pull over. In fact, after I pled with her, please pull over, she passed out. She just closed her eyes and fell over backwards in her seat, and she hit the side of the retaining wall. And I was trying to get out of the vehicle. It slowed down. I didn't just jump out. And the car door closed on my torso, and my leg was drug out behind me, and my arm was like this. My head was like pinned in between the car door and the car. So like the car was just like, scrunching up in there, and my head was basically, I felt like the thing that stopped it. I almost died. I 100% almost died. And I thought I had a 2-year-old and a 3-year-old, and I thought of them at the time. I was like, I'm going to die. What's going to happen? And, so a police officer saved my life, put a tourniquet on my leg, and I spent the next 21 months with 13 surgeries. I went through a divorce. My career just kind of tanked. And I was never given the chance to have a trial. I have a fake leg. You can see that. Every day I have that. It's not going to grow back. But I was not given the opportunity to have a trial because of summary judgment, because of the independent contractor statute. Completely denied. Sorry.
Thank you for coming.
You're welcome.
Thank you. Are you finished?
Yes.
Okay. Thank you for coming. I know that that's very traumatic, and I know you've waited almost 12 hours to give your testimony. It just is a testament to how passionate you feel about this, and really thank you for being here.
Thank you.
Yeah, thank you. Andrew, the vice chair, thank you for your testimony. Can you have your attorney who's sitting next to you, if he is willing? I'm going to re-rate. Members, any other questions for this witness? Thank you. I'm so sorry what happened for you, but thank you for your testimony. Andrew, I'm going to come back to you. Sure. I've got you registered. I have one question for you. I've got you registered on behalf of yourself, opposed to House Bill 1745.
That's correct.
Can you share the pleadings in that case with me?
I certainly can.
What county was it?
It was filed in Dallas County.
Okay. Could you share those pleadings with me and I think some of the other members of the committee?
Absolutely. It'll take me. I can find them tomorrow, but
that's fine. By the end of the week is fine. I'd like to review those.
Absolutely.
Thank you, members. Any other questions? All right. Thank you both.
Pleadings, you mean the petition, motion for summary judgment,
Order, right.
Whatever you would like to see.
All the relevant pleadings to your testimony.
Okay.
Yes. Members, any questions? All right. Thank you so much for being here, and thanks for your patience today. The chair calls Ross Evans. Ross, I have you here testifying on behalf of yourself, opposed to House Bill 1745.
Correct. Thank you for having me here. Long day. I am batting cleanup. I've listened to all the lawyers. I'll try to be the good lawyer who doesn't ask questions or say things that have already been said at the deposition, so to speak. So I might be a bit erratic in my comments, but let me get through them. I'm a civil litigator in San Antonio. I've been practicing law for about 13 years. I've been on both sides of the docket. I was raised in a household where my father was a defense lawyer all of his life. I'm agnostic, pretty much. I don't drink the Kool-Aid on either side. But as I read this bill, it's highly problematic, especially for sexual assault victims. The last 5 years of my practice, I've picked up a number of sexual assault victims, and working through the mechanics of it, I see a lot of issues legally and practically where it will either stifle a sexual assault victim's right to bring a claim or completely extinguish it, and I'll walk you through those. The first issue is this affidavit issue, which we've talked about. I'm not going to cover the ground we talked to, but let's maybe talk about what if it's just softened and you have to completely outline the basis in detail, almost as if a federal pleading, because maybe this is how it looks or where it could go, and you'd have to outline the basis for your theories against Uber or Lyft, whatever rideshare company it's going to be. In order to do that, you need to conduct discovery. You need to have the information to do that adequately. There's been talk even earlier today about construction litigation, and I think one of the gentlemen from TLR said, well, you can just inspect the house, so you don't need to conduct discovery. Okay, so that's an issue, right? Or with MedMal, we've talked about MedMal. In order to conduct discovery, well, to file that affidavit, you at least ahead of your lawsuit, you can get access to your own medical records. So you have the information ahead of time. With, if you're going to sue a highway construction company, you can do an open records request and you can get that information to get your certificate of merit before you file your lawsuit. This is not true with Uber or Lyft. You cannot get that information from them until you file a lawsuit, and then you would, I guess, ostensibly conduct third-party discovery against Uber, who is a California corporation, in order to essentially try to get the information which would give you the basis to file a lawsuit against them. How do you think that's going to work out? I have had a case, and I'll be general because I've got to be general for reasons, but where we try to obtain third-party discovery from a California corporation. It's the background check company called Checker that does the background checks for one of these rideshare companies. We issued a DWQ. They said, we're not going to, and they're, by the way, they're based out of San Francisco. They said, we're not going to honor a Texas DWQ. Okay. So I went through the process of domesticating a subpoena in California. I got met with massive objections. The case resolved before we could take it up in California, but the logistical challenge would mean I'd have to go out to California, either get pro hoc vitaed in or get local counsel to argue my domesticated subpoena in California to try to get information I need to substantiate my claims in Texas to satisfy whatever affidavit or wild pleading we want to come up with. It doesn't make sense because here's the thing why this really hurts Texas women. As we've seen, y'all saw Lauren up here. I can't believe how brave she was for getting up here with this incident being so recent to her. As I recall, it only happened to her in 2022. But sexual assault affects women differently. I've represented so many of them, I know. They're all traumatized, but their willingness to come forward and their timeline on which they do it is totally different. It's unique as their own fingerprint. But imagine if a woman walked into my office and said, Mr. Evans, I've finally got the courage to bring a lawsuit against Uber, and it happened 2 years minus 2 weeks ago. I would have 2 weeks left on the statute to try to get the discovery I need to bring a lawsuit against Uber or Lyft. There's no mechanism in here which allows that. There's a kind of a muddied mechanism which says, well, you have 30 days to bring an affidavit. But the problem is Part C under there says the defendant doesn't have to file an answer during that period. So I have no jurisdiction over to which to conduct discovery I need to satisfy any type of pleading requirement or affidavit requirement. And essentially, I'm stymied. I can't bring a lawsuit against Uber or Lyft under that scenario. Even if a woman comes into my office 3 months before the statute of limitations runs, 4 months, then I'm back to trying to domesticate a subpoena in California and going through that whole process, which took me up to 6 months in the last case, and I still got nowhere on it. And that's the problem. I could go on and talk about it, but I will mention one thing. We talked about statistics. The interesting thing about these statistics is when you look at Uber's quote-unquote transparency report, which I'll submit to you is very much like the fox guarding the hen house, because I've tried to get discovery from Uber on what I call other similar incidences in Texas. I'm in the Supreme Court of Texas right now on a mandamus because they're fighting me on that issue. They will not give that up. There is zero transparency. So what information they're willing to share, in my mind, is, again, the fox guarding the hen house. But even looking at their own numbers, when you look at their own numbers, it happens on average 1 to 3 times a day in the United States. If there were Ford Focuses or Ford F-150s catching on fire 1 to 3 times a day and burning people alive, there would be a congressional hearing on it. It is a major problem. And so what we need to do, and again, I'm speaking hopefully as agnostically as possible, we have got to keep these mechanisms away from people's rights to bring a lawsuit against these rideshare companies. You know, there's this concept of a fishing expedition, but I'll give you an example of the case that I have pending right now in the Supreme Court of Texas on mandamus, currently also being litigated in the trial level. The driver had a clean background. When we ran our own background check, no criminal history. So with that, we're like, well, goodness, I mean, what's going on here? We filed a lawsuit. And by the way, this is a rape case. We filed a lawsuit and we get into discovery, and it was only because we got into discovery that we found this out. 3 months before our client was raped, it almost murdered, attempted murder and rape on our client. The driver was investigated for another prior incident with the rideshare company, and he was determined to have committed sexual misconduct and inappropriate post-trip contact with a different female passenger, yet he was continued to drive, allowed to drive. That to me is a jury issue that needs to be, was it reasonable for Uber to do that? That's a jury issue. That's a question of fact. But the only way I can get that question of fact to the jury is to be able to conduct discovery. And we need to keep laws like this, respectfully, Mr. Leach, out of the way so we can conduct the discovery we need. And by all means, if there are a bunch of boneheaded lawyers filing meritless lawsuits, go for it. Uber, slap them. Use the mechanisms we have in place to smack them down. I don't file meritless lawsuits. And I'm proud of that because plaintiffs' lawyers have a terrible reputation. We have a terrible reputation. I can't walk anywhere without getting a joke about ambulance chaser, but that's not who I am. Those aren't the cases I file. And I don't want to be harnessed by laws like this from representing women who truly need representation.
Well said. Great testimony. Thank you, Vice Chair Johnson.
I just have a quick question. What would the impact be on legislation like this if we mandated disclosure of the driver file and the review history by Uber of the drivers up front in these lawsuits before having to make a decision of whether or not to sue Uber?
Like full access to their driver profile, customer complaints.
Right, they just have to turn the material over up front, and then like we have mandatory disclosures all the time in our civil, you have things that you have to produce up front without objection. We have that in our, how would that affect this, their contention of, hey, I'm getting sued wrongfully, if they said, okay, fine, up front, produce the driver file, produce the complaint history, and if there's nothing there, then don't get sued, and if there is something there, then bring your case.
So I want to try to give you a simple answer, and I don't want to try to sound pessimistic either, but I'll start with this. Uber or these rideshare companies, I have a high level of distrust for, and I don't trust them, to be honest, with disclosing that information. It's not just me saying that, though. I have an article where, back in 2017, there was a criminal subpoena issued in a California criminal case where Uber just didn't comply with it. And the judge says, and by the way, I use this at my motion to compel hearings because I always tell the judges, it's not me, I'm not crazy. They're being totally unreasonable. The judge goes on the record saying, I don't think you have the authority to resist a search warrant, which is probably true. And the judge went on, told the attorney for Uber, later describing the company's attitude as give as little as possible, be as uncooperative as possible. There's also examples of, Uber was just faced boldly a $59 million fine in California when the California Public Utilities Commission ordered them to produce data on other sexual assaults occurring in the state of California. Uber boldly said, no, we're not going to do that, and took a $59 million fine. Full disclosure, it was later reduced to $150,000. I don't know how it worked out that way. The point is, I don't necessarily trust them. for that to happen. Now, setting aside my pessimism, it might be able to work, but the legal issues are more complex than that. Simply getting the driver's file, when you look at these cases, it merits more discovery to actually explore these issues of control and whether they are independent contractors. And Mr. Leach, or Chairman Leach, put it well. There's a nice academic disagreement over that. We know what the statute, how it reads, and then we also, on the other hand, know what the case law looks like. And that issue is one that might be decided one day at a higher court. But the point being is, maybe that's a good starting point, but I don't know if it's ever going to get us there. Yeah, especially with the distrust I have.
Thank you so much.
Welcome. Okay, members, any other questions? Did you want to add something? All right.
I did want to add one thing for
You got to wait for me to recognize you. The chair recognizes Molly Fryer-Hedgepeth. Molly, I have you registered against the bill, testifying by yourself.
Yes, I'm so sorry.
That's okay.
I was really upset when I was speaking a minute ago. But I will say that my Lyft driver that picked me up, the past 2 rides that she had done were both safety flags. And there was narrative on her driving record about how she was swerving all over the highway. And she was still able to pick me up. So I just wanted to add that. Thank you.
Okay. All right. Members, any other questions for Molly? All right. Thank you to the entire panel. Does anyone else wish to testify on, for, or against House Bill 1745? Seeing none, members, I'm going to close on the bill. Are there any questions? All right. With that, I'll leave House Bill 1745 pending at this time. Our last bill of the day, the chair will lay out House Bill 200. Members, this is my bill reestablishing the Texas Prosecuting Attorneys Coordinating Council. Members, over the last 2 years, we've been having more and more conversations, not only here in Texas, but across the country, relating to prosecutorial misconduct. We've had some limited discussion in here on this committee. We had it in more substance on the interim committee that Chairman Moody and I led together, the Criminal Justice Reform Committee. Members, this is a bill that reestablishes the Prosecutor Coordinating Council, which was in existence here in the state of Texas from 1977 to 1985. This council's tasked with delivering assistance, professional development, education, and training to Texas prosecutors, as well as investigating complaints regarding incompetence or misconduct by prosecutors. The council was allowed to sunset in 1985 for a variety of issues. This bill revives and renews this council with a singular purpose: to accept and investigate complaints alleging incompetence or misconduct by elected prosecutors across the state. The council will receive complaints from the public and then choose to begin an investigation or not. The council would have the ability to resolve those complaints by public or private finding, or reprimand or filing a petition for removal, which would go before a special judge appointed by the Supreme Court. We believe that the existing processes and procedures, and by we I mean me as the author of the bill, the existing processes and procedures for holding prosecutors accountable are inadequate. It's why, in addition to this bill, you've seen a number of bills filed relating to prosecutors. And I think that this council is a good way for the legislature to evaluate claims of incompetence or official misconduct, willful neglect of duty that we're hearing about. Some, not all, the vast majority of prosecutors are wonderful men and women doing their job and upholding their oaths of office to uphold the laws of the United States and of this state. But there are some prosecutors who, simply put, are not doing so and are refusing to do their job to enforce state laws. And in some cases, they're proudly doing so. And this bill is one effort among many proposals to rein that in. Members, I'm happy to take any questions, and I reserve the right to close. All right. We've got some public testimony. The chair calls Charlie Wilkerson, Jennifer Sezemansky, sorry, Jennifer, Rebecca Parma, Cleo Petrusek. Is Charlie here? He's not. Okay. Charlie wanted to register, or he did register for the bill, but he's not here to testify. And then is Matt Makoviak still here? Hey, Matt, come on up. Jennifer, let's start with you. I show that you're registered here on behalf of the Combined Law Enforcement Associations of Texas in support of the bill.
Yes.
Is that correct?
Correct.
Okay, you can start your testimony.
All right. Thank you, Chairman and members of the committee. My laptop died, so I'm on my phone now. I'm Jennifer Szymanski, Director of Public Affairs for the Combined Law Enforcement Association, or CLEAT. CLEAT represents over 27,000 law enforcement officers across the state of Texas, including the associations for the Austin Police Department, Fort Worth Police Department, San Antonio Police Department, El Paso PD, Dallas PD, Corpus Christi PD, and all of the large urban counties. Many of our members and their families have been negatively impacted by rogue district attorneys who have engaged in malicious prosecution, failed to prosecute suspects who have harmed officers, and have outright refused to prosecute crimes, including felony offenses at all levels. These district attorneys have undermined the will of the legislature and are destroying law enforcement agencies across our state. They've created an environment in which public safety is in jeopardy and criminals are free to victimize members of our community. In Travis County, we have 19 Austin police officers under indictment for first-degree felonies facing life in prison. Other officers have been indicted by this DA, their lives put on hold, and reputations scarred, only to have their charges later dropped after the DA's press release and boasting period is up. These politically motivated indictments are a travesty, and the district attorney must be held accountable. After several years of defending our members, along with some of the other testimony you'll hear, against this particular district attorney, we are committed to this piece of legislation and any other piece of legislation that seeks to hold rogue and Soros-funded district attorneys accountable. I could continue, but for now, I would like to thank the chairman for this bill, and we look forward to its passage.
Thank you, Jennifer. Members' questions. Chairman Moody.
Just a quick question. So is there a provision in the bill that if you receive funding from an entity related to George Soros, you can't serve as prosecutor? Is this a campaign contribution bill? I don't understand that.
No, there's no provision in there.
So my understanding is the issue we're talking about is when a prosecutor makes a blanket statement of clemency, which they do not have the power to do, right? They don't have that authority. Governor has that authority. Prosecutors can't grant blanket clemency, right? So when they have statements where they said our policy, our procedures will be, we will just not do this for any class of person ever off the book. They are granting clemency for a class of offenders. The issues you brought up, and I don't, we don't get into whatever you want to talk about, but discretion on individualized cases is the authority prosecutors have. So if they're individually looking at each case, making a decision whether to take that to a grand jury or not, that is the job they get to do. And there are accountability measures for them already. We have state bar disciplinary measures to go after them. We have numerous laws that we've passed since I've been here to hold them more accountable, to make sure they're disclosing evidence so that they're moving cases in a proper and efficient manner. We just removed our DA in El Paso, but it was because of incompetence in running the entire system. No cases were going forward. It had nothing to do with the political statement about clemency. And so my question is, in what ways do you think it's permissible to limit prosecutorial discretion? Because prosecutorial discretion is different from the conversation about granting blanket clemency.
Well, if you want, I can read my testimony for tomorrow's bill, which...
I don't like to be read to. Why don't you just answer my question?
No, don't.
Okay, well, I've already prepared a statement which directly, goes toward that specific portion of the bill, but if the chairman wants to explain the other portions of the bill that would allow for other types of
I want to make very, very clear that I believe strongly in I believe it's a foundational, fundamental tenet of our system of government, prosecutorial discretion on a case-by-case basis. Prosecutors reserve that right, and that right must be protected on a case-by-case basis. But when you've got certain prosecutors that are proudly, we've talked about this, proudly and publicly announcing that they're not going to enforce an entire class of crimes, willfully ignoring state law, thumbing their nose at the legislature, violating their oaths of office. Their oath of office is to enforce state law. If they want to be lawmakers, they should run for the legislature.
Well, no, and I guess my point is, happy to have that conversation, but the examples that were brought up went far beyond that. They took this, whether I agree with it or not, and I don't know the facts of any of these cases, But if you have a prosecutor that has a case and takes it to the grand jury and they return an indictment in true bill, that's the process of being a prosecutor.
Yes, but you have to present all the evidence, and that's not being done. And so incompetency is an issue. That's just one small piece. Like I said, I could go on for days about this, but the incompetency factor is there with this particular DA and others. And I didn't.
You have removal procedures in place right now.
Well, we like the bill, and we're here testifying in support of the bill.
Okay, and the issue that we have addressed, and we addressed during the summer, and this may implicate the situation here in Travis too, is these blanket statements of clemency. That's where I'd like to drive at.
I would love to as well.
I think that's where
When you're saying clemency, are you saying non-prosecution of entire classes of crimes?
The complaints that we've gotten and the complaints that we heard during the interim had to do with blanket public pronouncements of policy that this category of offense, as it pertains to everybody, not a subset, we're going to handle youthful offenders differently with this offense or whatever. Those are not blanket clemency pieces. But when they said this as a whole, our policy is we're just not going to implement this. That is them overstepping outside of prosecutorial discretion and into blanket clemency. That's what I understood the issue to be. Now,
That's one of the many issues, yes.
Well, that's the issue that I think is them stepping outside of their authority. Their authority to prosecute or not prosecute based on individualized investigations, whether we agree with those determinations or not, that's the system that we have when we elect our prosecutors. I can like that or not like that. There are procedures to make complaints about them in several ways, as well as disciplinary procedures that can be gone through. And so what I've been trying to narrow down is how can we insist that prosecutors stay in their lane, utilize their prosecutorial discretion properly, appropriately, and within the bounds of the law, and not overstep into the role of granting clemency to people, because that is where I think we need to stand in and say, no, that's too far. That's not what you're supposed to do. And so that's where I'd like to get to, and there's some of the, because there's misconduct and incompetency, and you have procedures that kind of mimic some of the language that's in the removal proceedings now.
Well, and I think, Chairman, there are other bills. You referenced one that's going to be heard tomorrow. I know our committee, your committee that you chair, is going to hear some legislation.
We are, yes. Like I said, I'm open to this conversation. I don't mean to be we start with one lane of conversation, then we get into I know when I worked at the DA's office, there was an instance where the district attorney and the chief of police had a wonderful relationship. He ended up taking a case to the grand jury. The chief thought that it shouldn't have gone there, should have just never been presented. And they true billed it. And they presented the case. This is someone who's now, a federal U.S. Attorney. And so I know he did his job in presenting it the best he could, but we had this complete meltdown in their relationship because he decided to take that case forward. Those are just the decisions they get to make, whether I like them or not. And so that's different to me than granting blanket clemency on certain offenses. So those are the two lanes of conversation that I want to kind of just separate. Because if we don't like results, that's different. And
That's not the only issue that I was testifying to. I think it was clear that I brought up other issues, and I can continue to bring up other issues aside from that I think this council that would be established here would be able to address and fully investigate.
The goal of the council, which by the way includes a county attorney, a district attorney, law enforcement, a judge, and 2 public members, would not be, Chairman Moody, to be some sort of super appellate court that reviews case-by-case grand jury indictments on a case-by-case basis. That would not be the purpose of this council.
Well, I think there's some language that could.
There might be other bills that seek to do that, and we should have that discussion. What this committee would do is, in addition to other tools that are allowed and available under Texas law to hold prosecutors responsible, this council would make sure that our elected prosecutors across the state are upholding their oaths of office.
willful or persistent conduct inconsistent with the proper performance of official duties. That is a very, very broad statement, so I don't.
Publicly signing a letter.
That's not what that says here.
Okay, but this is an example of a willful neglect of duty.
But then let's just say what we're saying.
Publicly signing a letter that said, legislature just passed this law, no one in my county will ever be prosecuted for it.
Well, I understand what you're saying.
It's very different.
And I think what you can do, and if you look at other, I don't want to talk about other bills, but there are ways to get exactly what you're trying to do. This is language that's way broader than what you just described. If that's what we're trying to collect and go after, which is what seemed to be the impetus for a lot of this conversation, whether it was out of Dallas County or Travis County or wherever, that seemed to be the beginning of the conversation. And so I think it would be smarter to be more precise with this if that's the conduct we're trying to prevent. And that's really when I believe prosecutors are stepping outside of their role as a prosecutor.
So if the problem is, and we've identified one of the problems, is this tendency of some prosecutors, and again, it's not most, it's not even, it's a very, very small majority. Now, I would say they represent a vast majority of Texans. Over half the state are in some of these problem counties. But hold on just a sec. If we pass a law this session.
I think characterizing counties as problem counties isn't.
If we pass a law this session, Chairman Mooney, that says a prosecutor cannot issue a public statement regarding a categorical refusal to enforce an entire class of crimes. Let's say that we passed a bill this session. A prosecutor could just ignore that and continue to do it.
I think you got to be careful with the public statement part of it and their ability to say what they need to say. It's about the net effect of what they're doing.
No, I'm worried about them violating their oaths of office. That's what this bill is aimed at. It's establishing a process whereby a prosecutor who refuses to do their duty and fulfill their oath of office can be held responsible.
Like I said, this is wide language right here. What I'd also look at is the makeup. Then if we're trying to get at the fact that we need someone to tell us what prosecutors should or shouldn't do, what is the proper performance of their official duties? The previous iteration of this council was 5-4 made up of prosecutors. The leader, the presiding officer, was the president of TDCAA. And they appointed 4 other prosecutors, elected prosecutors, and then there were 4 non-lawyers.
I'm open to that. Let's hear TDCAA's testimony later. And
my point is, if that's what we're trying to get at, and someone has to define what the conduct is, and it has to do with prosecutors' oath of office, having people all over the spectrum, I get why we do that in certain instances. I don't think it would be wise to change the makeup of what previously we had if we're going to do this. So there's a couple of concerns I have.
Representative Flores.
Yeah, I just want to make sure that if this is, and I understand what you're trying to do, and I appreciate that, but I also want to make sure that this is not going to be used as a tool for political vendettas against certain prosecutors that, groups happen to disagree with. Because I know for a fact that Travis County prosecutor, who you alluded to, has also gone the opposite way against with police officer cases involved with police shootings, where they have taken it to the grand jury and there was no indictment found. So you cannot say that they are one-sided. So I just want to make sure that we don't use this as a tool to go after folks that you disagree with politically. That's all I'm going to say.
No, this is a tool, speaking as, if any conservative Republican district attorney proudly announced that they're going to refuse to enforce the dog tethering bill that we passed last session, I would have a problem with that. And I think that any member of the legislature should have a problem with that, no matter what the policy is. Any questions? Any other questions for the witness members? Chairman, did you?
No, I have a great deal of respect for the job that you do. You represent people on the front line in law enforcement, but that is the work that you do day in and day out. And I know that is a difficult task. And there are sometimes that officers are accused, just like anyone in the criminal justice process, accused of things that they didn't do, and they need a defense. But there are, and it sounds like there are cases here where you don't like the result that a grand jury indicted someone. Remember, a DA doesn't, a grand jury does. And so I get that that's a difficult job, and if we don't like the result isn't then to create a construct by which to just pluck people out of elected office. because we don't like that result. That is why they're elected officers, and that there are other sanctioning regimes that we have. And so I get that these are challenging things to work through, but we need to be very cautious about stepping into the role of prosecutors in their discretion, because it is a very challenging job. It is very difficult to do their job well. And so when I talk about curtailing bad actors in that arena, it is when they are overstepping their authority. And overstepping their authority to me is granting clemency where they don't have the authority to do that. And so I'd like to get after how do we keep people from doing that? And we can figure out all sorts of ways to keep them accountable to it, whether it's this or other efforts that exist that we're talked about. But that's the space that I want to get to, because that's really when they're overstepping their boundaries. And so like I said, I appreciate the job that you all do. It's very difficult work that you do on a day-to-day basis. But we need to be very careful, because all of us at one time or another will or won't like decisions that are being made by prosecutors, but they have that discretion for a reason.
Agreed.
Right, and the council, like I said, is something that's a form of recourse for what we're seeing. We have zero recourse right now for what we're seeing. I haven't gone into the details because that would take quite some time. But there's evidence out there that things like exculpatory evidence not being presented to a grand jury in cases of police officer, presenting charges against a police officer.
Prosecutors hiding exculpatory evidence, I'm going to ask.
In front of a grand jury?
I'm going to ask people.
We have evidence of that, yes.
Okay, and you're
I'm
saying
100% comfortable saying
There's
that.
no culpability for a DA who's hiding exculpatory evidence?
Not that we've been able to find. And again, I mean, this would provide an avenue for.
That's interesting. And I want to, because if that's happening, right, that's something that needs to be.
Right, that's why we're for this bill, because that's something that the council could do.
What I'm saying is what we're trying to get at, the conduct is what I want to be very precise with. Because if we start stepping into, I like that they do this, I like that they do that, I don't like that they do this, that's their job. Their job is to make these discretionary choices. If they're doing something illegal, like you're saying, withholding evidence that people are supposed to have, that's different, right? That's not discretion, that's illegal conduct. So let's figure that out. There's state bar sanctions available. If we want to talk about it, resurrecting one of the few agencies that's ever been sunsetted in the state, we can talk about that too. But my point is, I think there are avenues available for some of that conduct where we're seeing the problem, in my estimation, is these blanket clemency matters. That's where I think the biggest, broadest issues, at least in the evidence that I've taken in during committee hearings in the last couple of years.
No, I agree, and it is one of the biggest issues, but when you have DAs, and I understand we don't want to make this political, but when you have them coming out saying, this is what I'm running on, to prosecute as many police officers as I can, and then they come in and make good on that promise, and at the same time, they don't even put forth to a grand jury when an officer is killed in a fatality where a driver is driving over 100 miles an hour recklessly. In that case, can't even be presented to a grand jury. I mean, there's a lot that goes into this, and it needs to be looked into, and that's why we're supporting the bill.
Representative Schofield.
Earlier today, we had a discussion about the difference between talking about legislative intent and what's in the bill. So I'd like to kind of get back to what's in the bill.
Right.
The bill would reestablish this council, and it gives it specific powers and duties to review and resolve complaints involving incompetency and misconduct, and then it defines them. It doesn't seem to give you this blanket ability to go after your political enemies. It defines what is incompetence, gross ignorance or neglect of an official duty, physical or mental defect which prohibits the prompt or proper discharge of the duties, or a failure to maintain the qualifications required by law, and then it defines misconduct. Again, the unlawful behavior prohibited by Chapter 39 of the Penal Code, and acted as a felony, and acted as a misdemeanor involving moral turpitude, to willful or persistent conduct inconsistent with the performance of official duties. The bill that you have presented us doesn't seem to provide the opportunity for wide-ranging attacks on your political enemies, and I think we ought to get back to what's in the bill before us.
Yeah, I agree. That's well said, Representative Schofield. Thank you. Members, any other questions for this witness? Seeing none, The chair calls Rebecca Parma. Rebecca, I have you, hang on just a second. I have you here testifying on behalf of Texas Right to Life for the bill. Is that correct?
That's correct.
Okay, go ahead.
All right. Thank you, Chairman Leach and members, for allowing me to testify before you tonight. My name is Rebecca Parma, and I serve as the Legislative Director for Texas Right to Life. I'm testifying today in support of House Bill 200. We have strong protections for preborn Texans in our state. However, even before the Dobbs decision was handed down last year, the hidden underbelly of the pro-life movement is often a lack of full enforcement of our law. Leading up to and since the Dobbs decision, district attorneys across the country, including several in our great state, have made public statements declaring their intent not to fully enforce our pro-life laws. While district attorneys rightly have discretion over whether to prosecute case by case, they do not have the authority to adopt sweeping policies subverting the lawmaking authority of the legislature. These individuals are refusing to do their job, refusing to enforce laws duly passed by you all, our legislature, and putting lives at risk. They have proven themselves unreliable. We must have a way of holding them accountable. We support Chairman Leach's attempt in this bill as one method of holding such lawless district attorneys accountable. The reestablishment of the Prosecuting Attorneys Coordinating Council will provide investigation, removal, and accountability for district attorneys engaging in misconduct, defined as persistent conduct inconsistent with the proper performance of official duties. The legislature is in a unique moment in this first session post-Roe to pass substantial pro-life policies that continue to build a pro-life state. We must not let flagrant neglect of our laws become the status quo or undercut the gains that we have made. We look forward to your favorable consideration of HB 200. Thank you for your time, and I'm happy to answer any questions.
Thank you, Rebecca. Chairman Moody.
No, and this is what I was, and this is exact, thank you for your testimony. This is exactly the kind of stuff that we heard about during the interim, which I think gave rise to a lot of the conversation. So so I appreciate you weighing in, because I think that's where we started getting, whether I agree or not with those laws, I voted against them all. But I do think it's important, your testimony, to make sure that we keep everybody in their proper lane, and there's individualized look at all those cases. And I've talked to prosecutors that made some of those statements. I said, could you envision a situation where X, Y, and Z happens and you would want to prosecute that case? And you have fact pattern that I think, even given their maybe political position on choice life issues, they said, well, yeah, in that case, I think we probably would. So individualized scrutiny in each case is important. It is critical. And that's where I think people, and we said this during the interim, people have gotten more enamored with making a press release, or creating a good hashtag or buzzwords, and getting away from just doing the job. And when we get into that lane, whether I disagree with or whatever, then we're stepping outside of the bounds of what prosecutors can and can't do. So appreciate you being here.
And Chairman Moody, that's well said. And you asked the question earlier, and I think we actually missed the answer on it, but I'll try to answer it about the Soros funded. And I know that's some political rhetoric and whatever, but
I just don't have time for that.
I understand, but the reality is, I talked to one of the prosecutors who signed a letter this past year that, in addition to, I think, over 100 prosecutors nationwide, that said that they will refuse. This is one of Texas' biggest counties, refuse to enforce Texas abortion laws. Publicly and proudly signed onto that letter, and that prosecutor was one, I think, of 5 or 6 Texas prosecutors, and he told me privately, he said, I didn't want to sign the letter. He said, I was threatened with a primary opponent if I didn't. And funded by one of those groups. And if that happened on our side of the aisle, on an issue that we cared about, I would have just as big of a problem with that. There is public oversight for elected judges. There is public oversight. We have oversight, the Texas Ethics Commission and others. Police officers have public oversight. Prosecutors have no public oversight other than elections.
State bar, you don't think the state bar of Texas has oversight for that? No.
Show me where the oversight is for the 5 prosecutors who signed a letter saying we refuse to enforce this state law.
No, I'm saying there's a body that does address those issues.
I don't see it. And if you have an example where the state bar has come in for one of these prosecutors and said, you cannot do it, don't do it again, I'd love to see it.
Someone's got to file a complaint.
Somebody has to file a complaint,
I don't.
as they did with the Attorney General.
I don't believe that the state bar, which licenses attorneys, there are licensing and regulatory agencies. I don't believe the state bar is the,
There are sanctioning body too.
yeah, they are, but not as not just prosecutors. Those are for private and public attorneys. This is a council specifically related to prosecutorial public oversight.
No, correct. What I'm saying is, I'm not saying you can't have this too. What I'm saying, it is not accurate to say that there isn't public oversight of.
I believe that
attorneys.
it's woefully insufficient public
And so
oversight.
that's a different statement than saying there is none. I don't think it's accurate to say there isn't. There is some. If we think it's not sufficient, then that's another conversation.
Show me one example where the State Bar of Texas has come in and exercised public oversight over an elected district attorney.
I bet you might hear about them.
Okay. I'd love to see that in terms of go ahead, Representative Vasu.
Oh, in these cases?
Yeah.
These just happened. These just happened.
I enjoy the conversation. It's elucidating to me because I don't practice in the criminal
What is that?
sphere. Elucidating. Word of the day means to be educated, to be raise knowledge. Remember, age is just a number. Raise a point. I mean, I think a bill like this, or a different oversight mechanism, is far more appropriate than the bar. When y'all were mentioning about the bar, I have some concerns about the state bar being a oversight committee of elected officials and their elected actions and decisions that they make in an elected capacity. I think that a different oversight committee would be more appropriate. And so I like the concept of the bill about, having a different means and mechanism to do that. And, I haven't dived into the bill at nauseum, as far as the exact contents, but, I like this type of a structure way better than I would trusting the bar to be the sole arbiter of all things appropriate.
I just want to make a point of clarification when we say the state bar. I think we use that as shorthand. It's really the grievance council, the office of the grievance, rather than the state bar. The state bar is a state agency, and there is a firewall between those. And I just, we need to make sure that when we're using that shorthand, when we say the state bar grievance process, it is a different office.
That's well said.
And yeah.
Members, other questions? Rebecca, thank you for your testimony. The chair calls Cleo Petrusek.
Yes.
Cleo, thank you for your patience today. All of you, thanks for your patience today. I see you here as registered on behalf of yourself testifying for House Bill 200.
That's right. Thank you, Chairman and respective members, for bringing this legislation forward. My name is Cleo Petrusek, and I'm a resident here in Austin. I am in support of this bill. The creation of the proposed council is desperately needed. We have an incompetent district attorney who time and again has been neglectful towards the numerous victims of crime in our community, ignoring the pleas of these victims while simultaneously maliciously prosecuting our police officers who protected our community during the summer of 2020. By having a place to take our community's grievances so that it doesn't tie up the already overburdened district court is critical. I am a Democrat. I support police accountability. I also support holding negligent district attorneys accountable. I am deeply concerned that DA Garza, since taking office, has unfairly targeted police officers. Recently, in the 331st District Court of Travis County, the judge granted the motion that required DA Garza to record grand jury proceedings related to an investigation into the use of force by an Austin police officer. This is another clear example of how DA Garza has shown repeated improper political motivations where an extraordinary number of police officers were indicted as a result of his office carefully selecting what evidence to show to grand juries and, more importantly, what evidence to withhold. I asked for feedback from several Austin police officers. Again, I'm just a mom, okay? I'm just someone that really cares and is passionate about this. I represent a lot of, I speak to victims of crime daily, basically. And I also have done ride-alongs with police officers. I'm a former probation officer. I work with at-risk children. And one police officer said, working under DA Garza makes me want to quit Austin PD. I would have already quit and gone to work for another agency if I wasn't stuck here waiting to be eligible for retirement. That's basically the attitude of everyone else here I know. Another officer, Austinites will never receive enthusiastic, motivated, or caring police work as long as people like DA Garza poison the system. Another one, Garza had no experience as a prosecutor when he was elected. Garza's political agenda jeopardizes the safety of 1 million Austinites and the increasing homicide and violent crime rate since he took office, and which has been higher than it has been in decades. Another officer indicated that there have been about 1,300 state jail felony arrests for controlled substances, and the DA's office has only prosecuted about 2 of them. Garza can claim he has this high conviction rate when you don't prosecute. Thank you.
Thank you, Cleo, for your testimony. Members, any questions? All right, thank you so much for your testimony, your patience today. Is that your son over there?
Yes.
He's done great today. He's done awesome. Matt Makoviak, good to see you. You're here testifying on behalf of yourself for House Bill 200. Is that correct?
Yes, Chairman, thank you.
Go ahead.
Chairman, members, thank you. Appreciate your hard work today. I agree with everything that's been said by the panelists here. District attorneys have tremendous power. You can argue of any government official, they may have more power than almost anyone else, and it is for the reason that they can impanel a grand jury without a defense attorney present, without a judge present, choose which evidence to present, and seek an indictment. And yes, indictment is not a conviction, but indictment does have a real cost. And it's not just in the decisions of the things that they do seek to prosecute, it's the decisions they make what not to prosecute. I was so heartened just a little bit ago to hear Chairman Moody identify this issue of sort of blanket unwillingness to prosecute particular classes of crime. I know we're talking about Austin, that's where I live as well. Our Travis County DA ran on a platform and has followed through with a platform of not prosecuting specific classes of crime: criminal mischief, trespass, petty theft, sex work, drug cases. The list goes on and on and on. That is simply not the role of a district attorney. It is not within their power to decide which laws on a wholesale basis to enforce and which ones not to enforce. The way you have set this up, Chairman Leach, with this bill is entirely fair. You have set up a council that we have a precedent for in Texas before it sunsetted. You have serious people who have been elected to office or are in serious roles who are going to consider complaints. And then if they find, if the facts lead them to a negative conclusion, they have then options that they can employ. The simple reality is there's somewhere between 5 and 10 district attorneys across the state of Texas that are doing what we're describing. And without this kind of counsel, we do not have a workable, proven recourse. It may be technically correct that the state bar exists for that purpose, or the specific office within the state bar, or separate from the state bar. But to Chairman Leach's point, in 3 of the 4 biggest counties in Texas, you have DAs who have just been reelected. They have been doing now for 4 years what we are all here talking about. None of them have been penalized or cited or anything by this state bar conduct body. So we do believe we need this kind of recourse. It's a thoughtful approach. I'm sure modest changes can be made, but we would definitely think that public safety will be improved and the accountability will be improved. And every single legislator should be irate that we have district attorneys in counties in Texas who are choosing not to enforce the laws you pass. They are literally thumbing their noses at the entirety of the legislature, not to one party or the other, not to one member or another, but to the entirety of the legislature. Thank you very much.
Thank you, Matt. Thank you. Well said. Members, any questions for Matt? All right. Thank you. Great panel.
Thank you all.
Appreciate again for your patience today. The chair calls Jack Rohde, Jacob Putnam, Nick Hudson, and Chris Harris. Which one's Jack?
Yes, sir.
Hey, Jack, how are you?
I'm well, thank you.
Good. Jack, I've got you here on behalf of yourself and the Galveston County Criminal District Attorney testifying against House Bill 200. Is that correct?
That's correct, Mr.
Okay,
Chairman.
go ahead.
I am Jack Rohde. I'm the elected district attorney for Galveston County. Mr. Chairman, Chairman Moody, y'all, through this conversation, have identified the issue that has created this storm this session. And that is, what do you do with an elected prosecutor who decides they are not going to enforce an entire category of offenses? And beyond Chairman Moody's remark about, and really the sacredness of preserving our discretion on an individual basis, that's not, I think, what these efforts are about. The efforts are about, what do you do with a prosecutor who says, I will not enforce this law and I will prohibit anybody in my office from doing so.
That is correct.
The concerns that you lawmakers have raised and the concerns from the citizens you serve are legitimate and need to be addressed.
respectfully, I don't think this bill is the best tool to do it. There are two very effective processes already in place. We've talked about the state bar grievance process. We haven't talked a lot about the removal statute. Those are both very robust. They have a proven track record of removing elected prosecutors who are either incompetent or violating their oath. In the last year, we've seen the El Paso DA removed. The Nueces County DA is currently under removal proceedings. The State Bar Grievance Committee has authority to disbar prosecutors and has done so in the past. Those tools work. Currently, my understanding is there is other legislation being worked on.
The state bar has disbarred currently elected prosecutors?
Through the grievance committee, they have lost their law license, yes, sir.
While they were elected DAs?
I would have to check and see when that happened.
Or was this after the fact? Because I know of a few cases you might be referencing, but those were long after that attorney had either been unelected or had decided not to run for office again.
I don't know the answer to that, and I don't want to misrepresent.
That's fine. If you give me that answer, that'd be great.
Yes, sir. There's work now on some other legislation that would take the removal statute and sharpen it and essentially define that if an elected DA refuses to enforce a statute in its entirety, which is what we're all talking about, then that would be recognized as a basis for official misconduct and could be taken as evidence as a basis for removal. The removal statute is already very effective. Work on that legislation to specifically sharpen that language would accomplish, I believe, Mr. Chairman, what you really want this committee to do as well, but use a process that's already in place and is working well. So
give me the 10-second Reader's Digest version of the removal statute.
Well, misconduct and incompetence and drunkenness.
Okay.
Right. And so really we're really not talking about incompetence at this point because that's just not handling cases well, but misconduct. And so then if we define misconduct as—
so who brings a complaint under the removal?
Any citizen can bring it.
Okay, and where does that complaint go?
It's filed in the county of the prosecutor's office, and then is either prosecuted by, if it's against a county attorney, the DA prosecutes it.
Okay.
If it's against the DA, the county attorney prosecutes it. And if it's a criminal DA, then an outside prosecutor.
What happens if a local prosecutor says, I refuse to enforce the removal statute?
Then good question. Okay, I'm following what you're saying.
Because right now that's what they're doing. They're saying we refuse to enforce the entire class of crime. Why could they not do that for the removal statute?
Well, they would have to answer to the judge that's entertaining the removal proceeding, and there would be an outside prosecutor. Now, how that would play itself out, I honestly don't know because I haven't tracked that one.
And by the way, I'm not saying we should get rid of our removal statute. And in fact, I think we do need to improve it. And I hope legislation passes this session that does that. What I'm saying is that we have a problem in Texas where there are certain prosecutors who are ignoring all sorts of state statutes for political reasons.
I recognize, Mr. Chairman, and I agree with it.
And this council is set up to supplement, to complement the removal statute and to provide another level of public oversight and accountability. It's not to take the place of the removal statutes. It's to supplement it in a case where a prosecutor might say, I'm just going to ignore that.
Well, there are, I'm out of time, I don't know if you want to hear from some of my colleagues.
Chairman, I know Chairman Moody has a question.
There are some concerns then, Mr. Chairman, about creating this third forum in which complaints can be brought against elected DAs, because a DA can already face grievance proceedings. A DA can already face having to defend against a removal petition filed under Chapter 87. And so the creation of this council would then create this third forum that it's a new mechanism, but it's not a new rule. It's not a new offense. It's not a new violation. The violations we're talking about already have two effective forums. And so, and the other problem is elected DAs don't really have insurance against this, and there's no guarantee that the county would provide counsel. And so you would have elected DAs facing, in many cases, which would be baseless claims, because any citizen can bring a complaint. I know that your bill excludes those who have been convicted,
but it doesn't exclude family members of those or those who have been charged or investigated.
I know we use the abortion laws and the refusal to enforce the state's abortion prohibitions as kind of the example. I want to put that aside and use another example. This is one of my concerns with the removal statute. If you have the legislature, we passed a hotly contested dog tethering bill that did not break upon partisan lines. It broke on rural versus suburban and urban. There were certain rural state representatives that couldn't vote against it because their constituents couldn't vote for it because their constituents were strongly against it.
Sure.
Ranch owners, landowners, whatever. If you had let's say a West Texas DA who said, I publicly did a press release saying, we're not going to enforce the dog tethering bill passed by the legislature. And all of the surrounding district attorneys in surrounding counties agreed with him on it. How would the removal statute work?
I don't know the answer to that because I haven't traced that out.
Because all the judges are running for re-election as well.
But you also, Mr. Chairman, have the grievance process, and that would be a violation of their oath.
Are you saying the state bar grievance process?
Yes, sir. Yes, sir.
Someone's going to have to really convince me that the state bar grievance process is doing a good job preventing willful neglect of duty from these prosecutors. If the grievance process was so effective, you wouldn't have had these handful of district attorneys representing the state's biggest, most populous counties doing what they're doing for political reasons. And so, do I believe we need a grievance process? Yes. Do I support the strengthening of our removal statutes? Yes. Do I think there needs to be additional public oversight? I do. I mean, if you had told me 10 years ago, when I started in the legislature, that we would have prosecutors proudly and loudly thumbing their nose at the legislature saying we refuse to uphold our oaths of office, I wouldn't have believed you, but here we are. Chairman Moody.
I can go through with you the functional way that the removal process works since we just lived through it. Well, I'll go through it real quick. But the complaint filed, like lawsuit filed, so you're right. And so then the district judge the case falls into a district court just like it would anywhere, or at least in our case it did, but anywhere else. That judge recused herself, as any judge in El Paso would, because they're not going to preside, and in any county, you're not going to preside over the removal proceeding. A judge is going to recuse himself, which puts it in the hands of the presiding judge to appoint a visiting judge to sit in the case. In that case, it was our former colleague, Tryon Lewis, was appointed as presiding judge to preside over the case. He then makes the decision, is there merit in this or not? And am I going to serve the district attorney with process? So that judge makes that decision and it triggers forward, right? The judge does in that case. And then the DA has to come and answer. In our case, they said, yes, there's enough to move forward. The DA has to come and answer. You made a good point. In fact, one of the biggest issues in the case with the DA could not really afford counsel. They brought the issue to county commissioner's court, asked county commissioners to have the taxpayers pay for her legal bill. And they said no. And that really is what got her, ultimately, I mean, this is my opinion, what got her to resign is she couldn't afford counsel. Not whether she thought she was incompetent or not. They never litigated on the merits of it. And so the county attorney then had the decision after served, because that's the way the statute's written. By the way, without getting into context of the bill, that mechanism is going to change to address the other issue you're talking about if they refuse to do this, that, or if you have someone.
Yeah, but you sort of just made my point for me. That's an additional concern I hadn't even thought about, is a district attorney who can't afford their own counsel. So they just resign or quit or not run again, which isn't good, because if there's a
But in this process, if they have that type of incompetence or misconduct the way that you found, and they want to go through the removal process, this starts the removal process. So they're still going to have the same problem. Yours just goes through a track of, you're going to have a lot of kind of triaging complaints. And then if there's removable conduct, it's going to go through the removal process that I just described unless we change it.
Well,
So
the
same
goal of
problem
all
persists.
of this, Chairman Moody, the goal of all of this, yes, is for it to work when it needs to work, but it's also to deter prosecutors from doing this in the first place. And right now, our removal statutes or our grievance process under the state bar is not effective, has not been effective in deterring What some prosecutors, again,
There's
not all.
I would say there's a former district attorney from El Paso County that would disagree with you about the removal statute working. It worked rapidly in that case and addressed, in my opinion, a very real problem in cases just not, in wholesale just not being. It wasn't a category of offenses or a policy she had. The entire office just wasn't functioning.
It worked. That's good.
Mr. Roddy, I want to ask you about this because I do want to make a distinction because I made comments about blanket clemency. You have policies in your office where you go, first-time offenders or this type of offense, like they're gonna go take a class. We're not going to use our resources. You're making a resource decision. They're going to take a class. We're going to dismiss the case. Do you consider that not prosecuting the case?
No, not at all. And that goes back to the importance of individual discretion, right? Our duty is to see that justice is done, and that's done on a case-by-case basis. And so we have diversionary courts, we have veterans treatment courts, we have drug courts. All of those are in place where we're prosecuting the case. We're accepting the charge. We're evaluating it. We decide which ones we want to try and rehabilitate, if that will work, and which ones we need to go to trial on. But that's always the exercise of individual discretion.
Yeah. And you look at classes of offenses or the class of offender, right?
Sure.
I've seen DAs do youthful offenders. We know that maybe we want to track them a little bit different. People with mental health issues, we're going to track them a little bit different. Veterans, PTSD, we're going to track them a little bit different. Substance use disorder, track them a little bit different for a wide array of cases, or types of cases.
That's correct, yes,
right?
sir.
I want to make sure, and for clarity for those that don't work in the prosecutorial world or haven't, or in criminal law, that's not a prosecutor not prosecuting. That is them making a policy decision about how to handle certain offenses or offenders within their discretion.
That's not what this bill's aimed at.
No, what I'm saying though is let's say I decided as an elected district attorney that for all offenses in this category, I don't really want to deal with it. I'm going to send them all before, we'll even do pre-arrest. We'll call it pre-charging, pre-trial diversion. We won't accept the charges yet. We'll let the paperwork come in from law enforcement agency. We're going to divert it, and we're going to say, go take a class. We'll never accept it. You won't have paperwork following you. You don't have to go get it expunged off your record. You don't have to go through that process. We're going to do that. That, to me, is exercise of prosecutorial discretion in handling those cases, and I don't think is the kind of conduct we're trying to get after, but I think because the broad language in that one section, it could be read to be, well, you're not carrying out, you can get a complaint. Maybe you look back at the complaint history from when this thing existed before, and this is when they had to type it out on a typewriter and find out where to mail it, I guess. I don't know. I mean, this would be now an online portal of some sort, I assume, how we receive complaints. You had, in a period of time, I don't know if this is an annual or this is biannual data, but the complaints are coming from, vast majority of them are coming from crime victims or defendants that were disgruntled in the process, not happy with results. Mm-hmm. The general public filed, out of 187, they filed 24. Law enforcement filed 9 of them. State and local officials, 6. Judges and commissioners filed 5. Grand jury foreman filed 3. And even an assistant prosecutor filed 1 against an elected DA. Most of those were dismissed out of hand because they didn't substantiate any claims under the statute, under the provisions, or the commission didn't have jurisdiction to go after them. So what I'm saying is we need to be precise and not step into the role of discretion, because there's lots of things an elected DA could do. There may be something specific in Galveston. You're trying to get to the root of it, and it's better for you not to go after it, what we would call aggressively, because of the type of result you're going to get. That way, you want to track people a different way. That's you using your resources how you see fit. And I think that's different from blanket clemency. Would you agree with me?
I would agree with that. I hope I've made that clear.
With that.
But I think what we will get lost in here is someone using that discretion. And I think that prosecutors should have the ability to be creative about the way that they're handling their caseloads, and so there are thousands of crimes, I guarantee you, there are thousands of crimes that have never been prosecuted in Galveston, not because you didn't want to, it's because they don't exist.
Chairman Moody, but we had 5 of our prosecutors in Texas sign a public letter. They made a public statement that said, we believe we have the, quote, well-settled to discretion and we decline to use our resources to prosecute those who seek, provide, or support abortion. They
I'm aware
believe
of
that it is well-settled discretion, that they have the authority to do that.
They do not have the ability to grant blanket clemency, and I've said that, and I will continue to say that. I have told that. In fact, I told to one of the prosecutors that came and testified that signed on to that letter. But my point is, we need to be precise when we get into this type of language, because some people are going to say handling cases a certain way for a certain class of offenders is not doing your duty. You're being too soft on them, Mr. Rohde. I know no one's ever accused you of that. Be very clear. You're being too soft on these folks, Mr. Rohde. You're doing this. You're in dereliction. That's not justice. You're not doing justice in that case. What I always told people when I was a prosecutor is that as you know, and when I was advising my clients as a defense attorney, you'd have to tell them the same thing. Like, different prosecutors are going to come at this different ways and how you advise them. But when you're a prosecutor, I would tell folks, justice looks different in every single case. That goes straight to what your point was individualized, looking at every case. And that's what those prosecutors should have done, in my opinion. They can say whatever they want to say. They have a right to say whatever they want to say. What they do is different, right? Because their actions are the issue, not what they say. Their actions, if they conduct and have policies that essentially grant blanket clemency, that's what we need to look at. So it's very helpful to help flesh out the differences between just cleaving off stuff and saying no, and getting creative in the way that we handle caseloads, but also the defendants themselves. So I appreciate you being here. It's good to see you.
Did you have additional testimony? Yes, Representative Schofield.
But I think this has been a very enlightening discussion, and I want to echo the last thing that Mr. Moody said, which is it's what they do and not what they say, because you can have prosecutors get smart and go, we're no longer going to say we're never going to prosecute a marijuana case. We're just never going to prosecute one. And that is as much a thumbing of your nose at the legislative prerogative to pass law as is an open statement that you're not going to. But more to the point, if you hear the discussion between Mr. Moody, Chairman Moody, and Chairman Leach, you see apples and oranges. Chairman Moody is talking about individual case discretion, and Chairman Leach is talking about broad categories where you're refusing to do your job. Not you, of course, but and understand, and all the prosecutors need to understand this, and all the elected officials throughout Texas, if you are given the power by Texas voters or by Texas law to do something and you abuse it, you may lose even the powers that you should have been able to keep. So I agree with Mr. Moody that prosecutorial discretion in individual cases is very important. But if prosecutors persist in saying we are not going to follow the laws that the legislature has passed, we may come down on you to the point where it does impinge on the very powers you ought to have. And I think prosecutors and others ought to keep that in mind. Sometimes we can't be as surgical as we'd like with our laws. And sometimes we may have to tie your hands together to keep you from hitting people, and we don't want to tie your hands together. And so I would really caution prosecutors not to just say, we don't have to do what the legislature wants. We're going to bypass them and do what we want, because then the legislature may bind some of the things we don't want to bind. And so, please take that back to your fellow DAs. Your job is to prosecute crime, and if you don't want to, don't run for that office. If you don't like the crimes in Texas and you'd rather be a public defender, be a public defender. But if you run for DA, you are running for DA, the office that prosecutes the crimes, and if you don't want to, don't run for it. And anything you have to say to that?
Well said.
Somehow that's a question at the end, but...
Do you agree or not? Chairman Moody.
No, I appreciate the comment. I think what you need to know is being a prosecutor is sometimes justice defines what you do in a way that you wouldn't consider being, straightforward on prosecuting a crime. Dismissing a case in many cases is justice in a case. So it is not as simple as that, as saying if you don't want to prosecute crime, don't be a prosecutor. Prosecutors don't exist just to prosecute crime. In fact, when you're sitting in the courtroom, you're looking out for the defendant's rights too, because you're going to have to, guess what, when that goes up on appeal, You better make sure that their counsel wasn't screwing up or that the judge didn't do something inappropriate. You're looking after every part of the process. You're responsible to make sure that the victim has their voice represented in that process too. So the job is complicated, and that is what I want to say. When you're getting into this and you're opening a door for these complaints and grievances to come forward, be precise about what you allow people to be removed for, because a lot of folks intersect with the justice system, and the job is very complicated. I've had very difficult conversations with the victims of crime, and the evidence doesn't look like we can make it. We just can't get there, or we think that we've seen a pattern of jury verdicts in the jurisdiction where we know it's not going to go well, and this is where it's going to go. So just know that when you open this door up, elected DAs that are doing good work the best they can, honestly and ethically, are going to be subjected to the same thing that you want to subject 5 of them to. We're writing state law to address some things that that we're upset about a handful of DAs doing.
Represent over 15 million Texans.
Okay. And guess what? We're going to subject Mr. Rohde here to the same thing if he has a victim that doesn't like the way he handled the case. And that is what's going to happen.
When we pass a law, it applies to all 254 counties, not just.
That's why I'm saying it's easier to address this in other places. I do understand what you're trying to do here. I do think it's important to address this issue, and I think we have to do it this session. I think the governor, lieutenant governor, speaker made it very clear that we're going to, and I think we should make sure that we do it in a way that's not going to catch up, get people that we're not trying to, or the conduct that we're not trying to get after.
I agree.
And so that's just the caution I urge as someone who's been both in the prosecutor's seat and the defense attorney's seat. It's a very challenging world to live in.
Representative
And
Flores.
just again, you said it act as a deterrent for bad conduct by the DAs. But again, I think there's also got to be some sort of a mechanism. I'm not going to say, I don't know how you would screen the types of complaints that can come, because then you do have folks who are disgruntled or just angry or political enemies or whatever, and they're able to file these, frivolous grievances, if I may borrow a term that everybody's been using tonight. But they will go after attorneys. I've seen it at the state bar. I worked there for 7 years, not in the not in the grievance part, but just observing everything. And I mean, and that takes a toll on people. And if somebody doesn't have the funds, as long as there's ways to deter, bad actors from, harassing prosecutors because they don't agree with their positions on certain things, and I think we need to be careful at that. And I'll just leave it at that.
Yeah. Well said. Thank you. Members, any other questions for Jack? Thank you for being here. The chair calls Jacob Putnam. Jacob, I've got you here testifying on behalf of the Smith County District Attorney's Office and yourself, and you're against House Bill 200.
Yes, correct? Chairman, that's correct.
Okay, you can start your testimony.
I'd like by saying Smith County is Tyler, Texas. It's 2 hours east of Dallas, halfway between Dallas and Louisiana. I'm a Republican. We're a conservative county. We're probably one of the most conservative when it comes to prosecution. I say that because I hear what the witnesses before us said, and it makes my heart hurt when I heard and have seen what DAs in certain counties have been doing over the last several years. It makes me angry. When I heard about the letter, it made me angry. I find it to be offensive, and I agree with all the comments that have been said that is not the place for the DAs to say, here's a statute, I'm going to tear it out of the book and ignore it. That's not their place. It's not my place. I've had these arguments with defense lawyers in my jurisdiction when they gripe at me about why I'm still prosecuting misdemeanor marijuana. Even after the hemp law made it nearly impossible to prove, I said, we're still prosecuting it. Well, why are you doing that? Well, because the legislature told me it's against the law, and that's what we do. We enforce the laws that y'all write, and I respect that very much. To be quite frank, I don't think this bill will accomplish what everyone hopes it will accomplish, with all due respect. It creates a bureaucracy that was previously sunsetted for being inefficient and not accomplishing it. I have looked at the number of ways that we are held accountable, of which there are several. Elections, obviously, first and foremost, of people running against us. The state bar has a specific rule just for prosecutors. It's Rule 309, and you're absolutely correct, Chair. There is no provision in Rule 309 that says if you refuse to do your job, you could be grieved for that, because I don't think anyone imagined that. much like in Chapter 87 in the government code, it's lists out incompetence and not being good at your job. I don't think the legislature, when they wrote Chapter 87, however many decades ago, envisioned anybody would run for office and then announce they're not going to do their job. They were worried about people not being very good at it, not refusing to do it, which is why I wholeheartedly support efforts to amend Chapter 87 to remove people who refuse to do their job, because that is, to me, an appropriate remedy to deal with the 5 prosecutors who have signed on to that bill and anyone that might come after them that would do the same. There are 336 elected prosecutors in Texas. 331 of us did not sign that letter.
It's not just that letter. There's many other instances in addition to that letter.
331 of us didn't sign it, and I would say by far 99% of us take our oaths very seriously. This bill would create a bureaucracy which we would have to answer to for complaints, and we make a lot of people mad. It is a part of our job. Defendants' families get mad when I prosecute them. Victims' families get mad when I don't. It happens every day. I probably made people mad in the 12 hours I've been here waiting to testify because somebody back in my office convicted somebody or failed to convict somebody else. We get lots of complaints. I get lots of bar complaints on me. Now, there aren't any rules specific to the kinds of things they complain on me for, but this council would be specific to that because it would hold me accountable for the proper performance of my job, whatever that means. I am trying very hard to do my job. At least 331 of us are. I would be in favor of a bill that spoke to that issue. But creating a council which was proven to be ineffective before, to me, does not seem the appropriate remedy. I'm happy to take any questions.
It was ineffective before because it wasn't funded properly or run by the right people. So there are other reasons that the council was not sunsetted then.
I don't know how a council would, with only 2 elected prosecutors on it, would be able to accurately determine the proper performance of our job.
I'm more than happy to increase that number to 4, maybe even more.
And it'd be nice if there was one of them was a criminal district attorney.
Perfect.
Because there's not any in there either.
I'd love to see that language. I'm actually absolutely happy to negotiate the actual specifics of how the council operates and who sits on it.
In addition to that, the 336 of us, if the goal is to be a deterrent to bad prosecutors, having to answer to another bureaucracy that's going to receive all complaints on us, it really deters people, good people who want to do the job, from running for district attorney in the first place.
Yeah. Well, okay. Members, any questions? All right. Thank you. Thanks for your testimony. Members, is it Nick?
That's right.
Yeah, Chairman Moody.
And it's not a question. I just want to thank, I've had the opportunity to engage with you in your office on a number of things. Hadn't had a lot of opportunity prior to this session to engage in Smith County. Not a lot of reasons for me to out in El Paso, but gotten to work with a lot of prosecutors over my time in my 14 years here. And your level of professionalism and thoughtfulness about a myriad of issues, and you've testified on a bunch of them that I've seen all over the place. And I just want to say thank you for doing that, being here long hours with us. I know it's a difficult job, and just wanted to commend you for engaging in the way that you have, because I think it's been very helpful to those of us who maybe are, need help being guided along by folks who are on the front lines there. So,
thank you, Chairman.
Yeah, thank you for your testimony. Is it Nick?
That's right.
Nick Hudson, I've got you testifying on behalf of the American Civil Liberties Union of Texas against House Bill 200. Is that correct?
That's correct.
All right, go ahead.
My name is Nick Hudson. I'm with the ACLU of Texas. We're here to testify against House Bill 200. I want to say I hear the intent that you've talked about, that this committee has been clarifying tonight. But when I read HB 200, I see a bill that may make it difficult for prosecutors to carry out basic functions of their office. And I think it may make it difficult for them to prioritize certain cases or decline or divert or dismiss cases in the interest of justice. And part of the reason is because of the vagueness and the definition of official duties in the bill. We've heard a little bit about this right now, but because the term official duty is not defined, it is unclear what constitutes gross ignorance or neglect or willful or persistent conduct inconsistent with the proper performance of it. And so we're concerned that this may put DAs and county attorneys in the position of needing to make decisions about particular cases, not based on what is in the interest.
Does the ACLU have some suggested language you'd like for me to look at for official duties?
I'm happy to think on this and get back to you. And we also have some written testimony that I'll share.
You've testified that one of the reasons you're against the bill is because official duties isn't defined. So let's define it.
I think that the narrower definition that has kind of been emerging in this discussion, where we're talking about blanket non-prosecution, would be a better alternative.
Right.
One of the other concerns that we have is or ask us to clarify that provision, and we're happy to help with that. Another provision we're concerned about that we think may actually raise the potential for kind of an abuse of power on behalf of the council is one of the most problematic provisions is the one that disqualifies county attorneys and district attorneys while a removal complaint is still pending. While there has been no determination by a judge on the merits of the case, it would create opportunities for the state to effectively take over the administration of an entire county and their criminal prosecutions without proving that removal is actually warranted in court. And that is different than the existing removal statute, where there's actually a judge who's kind of makes a decision on the merits about the individual case. And so our recommendation on that would be remove the provision that allows automatic removal while it's pending. The third thing I just wanted to touch on, the previous council was actually, there were a number of reasons it was disbanded. One of them was because it performed duplicative functions to the state bar. It was specifically called out, and they identified that it was an unnecessary inefficiency and it cost taxpayers' money. The last thing I just want to mention is it's ultimately there are many sanction regimes we've heard that are pretty effective, and ultimately we think that voters are the ultimate safeguard on ensuring that district and county attorneys are performing the duties that they should be. So thank you.
Okay. Members, any questions? Chairman
Nick, I don't have questions. I just it's about 8:10 in El Paso right now, and my boys just tuned in because they're going to be heading to bed soon. And I said good morning to them when they were going to school, and we started this when we were starting the first bill this morning. And I told them I might still be in here when they went to bed. So William and Preston, I hope you had a wonderful day, and I love you, and good night. Be nice to your mom.
Members, other questions? All right. Thank you. Chris Harris. Is Chris here? Chris Harris on behalf of the Austin Justice Coalition. All right, thank you for each of you for being here. The last witness of the day, Rob Keppel, Texas District and County Attorneys Association. Rob, I have you testifying on the bill, is that correct?
Yes, sir.
Okay, you can go ahead.
Good evening, Mr. Chairman, members. My name is Rob Keppel. I'm the Executive Director of the District and County Attorneys Association on the bill as a resource. Primarily just number one is if there's any questions about the old prosecutor council. Once the bill was filed, I spent a lot of time at the archives examining how that operated, so I can answer those questions if you have any. Also, we took a little time at our association to look back over the prosecutor accountability. With your indulgence, I'll go through some numbers about what's happened in the last 10 or 20 years or so with prosecutors. There have been 7 removals, actions filed. 3 have been successful. 1 is pending in Nueces County right now. One of the issues in the one in Nueces County is actually the issue concerning the letter that was signed by the 58 prosecutors in the Fair Justice Coalition. That's one of the issues that could very well be litigated. In the last 10 years, there were 10 state bar disciplines, 3 disbarments. 1 attorney just recently resigned while facing disbarment. But you're correct, the 2 electeds were former electeds when they lost their bar licenses for things they had done when they were elected DAs. So I don't recall any elected DA who's been disbarred while in office as an elected DA under the bar rules. Surprisingly enough, in the last 30 years, we've had 9 prosecutors convicted and sent to prison or resigned in lieu of prosecution. So that remains an active field for prosecutors. We've had 5 courts of inquiry in the last 15 years. 1 prosecutor was convicted and sentenced to jail as a result of that court of inquiry. Civil liability, we don't think about that very often, but 1983 actions are alive and well. Our Travis County District Attorney, the former one, had to settle a lawsuit. Lamb County had to settle a lawsuit, and Shelby County DA had to settle lawsuits over their conduct. None of them are in office anymore. Ballot box, in the last 10 years or so, we've had 10 prosecutors who could quite fairly be said to have lost their offices because of their conduct in court or in their offices. So there are a lot of different ways that prosecutors are held accountable. And the bar grievance is one way, but the removal is becoming a more significant one. And that's why I guess we're talking today about how you look at removal, how you focus, what rules the prosecutors have to follow so that they know what's expected of them. I'd be happy to answer any questions.
Rob, thank you. Great testimony. Chairman Moody.
Thank you, Rob. I appreciate that. You actually mentioned courts of inquiry, and I hadn't thought about that. And just, I don't know if you could just expand on what that process is so that people kind of understand it a little bit better.
A court of inquiry can be brought by any lawyer if there's a suspicion that the prosecutor has engaged in illegal conduct or unethical conduct. And if the judge certifies that, then it can actually, it's almost like a public grand jury where at the end of that grand jury testimony, the judge can refer the case for a criminal prosecution, which has happened in the past. So,
if a prosecutor is secreting exculpatory evidence, as was alleged here earlier today,
yes,
that's something that could be subject to the court of inquiry.
It could be subject to the court of inquiry, and it, like I said, it operates as a public grand jury.
Yeah, isn't that also? I mean, maybe I'm wrong, but I think we've passed a number of laws since I've been here going after that exact conduct. You talked about prosecutors that have gone to prison or have been sentenced for certain conduct. Is that the kind of conduct that they were accused of?
Absolutely. What y'all have done recently, first of all, is the court of inquiry, but y'all have also made sure that the state bar rules have no statute of limitations for prosecutors. So if any prosecutor has an issue involving exculpatory evidence, they're always on the hook for that.
Because some of this stuff doesn't come to light for years, right?
Right.
And we've seen that happen in a number of cases, which is why probably you don't see disbarment while someone's in office, because you don't really have access to the evidence to be able to get after them until after they're gone. But I don't want to harp on this, but I don't like people being misled here. If someone is keeping exculpatory evidence away or secreting it as a prosecutor, they can be held accountable for that conduct under the law today without any new law at all.
Yes. I think the allegations you heard here today, with all due respect, were people saying that the exculpatory evidence wasn't presented at a grand jury level, which there is no requirement to do that. So I think that's what that complaint's about, honestly.
Okay.
I'm not familiar with any other complaints about hiding exculpatory evidence, and not in this county.
Okay. I just want to be very clear about the difference between the two and how the conduct is described. I know there's an active, antagonistic relationship here in this county. I don't want it to dictate the way we pass policy for the entire state, because I don't think that's wise. So, thank you.
All right. Thank you. Members, questions? Yes, Representative Schofield.
Mr. Keppel, two questions for you. Well, the first one is short. All of the cases you mentioned of prosecutors being prosecuted for their actions in office, were any of those for just declining to prosecute an entire area of the law?
No, sir.
They were all for actions, not omissions?
Sure.
Right. And then the second one is, you mentioned that you had done some work, and we hate to let work go unrewarded. So you had done some research into the council as it existed. Were we to pass a bill reenacting the council, what would be some of your recommendations for ways it could operate better than it did the first time?
One of the big problems with the council back then, which isn't in this bill, by the way, is that it was passed at a time when the Professional Prosecutors Act was passed in the late 70s. The whole purpose, what the legislature was doing then, was trying to aid and lift the profession up, not discipline it. So there are a number of parts to a Professional Prosecutor Act. The council was actually formed to train prosecutors and also accept complaints to help the public better understand prosecutor discretion. Quite frankly, almost all the complaints were by victims. They were by defendants who didn't understand and appreciate a prosecutor's discretion. There were some removals. There was some bad conduct. There were some disciplines that occurred during that time. But the problem was that they were told to look at prosecutor discretion, and there were no rules. There's the state bar rules, And then you have a general removal petition that's just like what we have today. So when Sunset looked at it, they said, well, wait a second, state bar rules are already being done here. Assistance is being done by the Attorney General and TDCAA. Removal's already there. Why do we have an agency to do something that's already being done? So I guess what I'm trying to say is, if you're going to have a council that disciplines prosecutors, tell them what rules they're supposed to enforce against the prosecutors. Here's the reason why. There was no other council like this in the country except New York has started one in 2017. It was held unconstitutional, and it has yet to get started again. But a lot of them have judicial conduct commissions because the judges have their own set of rules. So there's a set of rules you can guide and judge them against. Prosecutors right now, we have the state bar rules and we have the removal statute. And I think what we're talking about is talking about how you make that removal statute more robust to aim at the conduct you want. You may be able to do that without having to have a commission that touches every other facet of a prosecutor's life.
Now, I guess I do have a third question. You and others on this bill have mentioned, well, when we had a council, you got kind of frivolous complaints from people who didn't like the result, whether it was victims or whether it was the accused. Isn't that basically the level of complaint we get in the bar grievance process? I mean, everybody's holding that up like it's some great thing, and I don't see it.
Well, that's a great question. You know, back when these things were done by a typewriter and someone had to figure out where to send it, there were 187 complaints over 5 years. Today, I'm going to tell you, I think that would be a little different if you told all the police officers that they could file complaints against the district attorney in Travis County. I think there'd be an awful lot of work for them to do. And I don't know that there's a rule that they would guide, but if you wanted to complain about something, those have to be dealt with. And I can tell you one of the concerns from my members, every single one of them all over the state, is that they don't have a lawyer for that. They don't have insurance for that. And they're going to be in a position where they've got to defend against bar grievances, against removals, and against complaint. They could have 3 different complaints pending at the same time.
Isn't all that true about the bar grievance process? You don't get a lawyer for that. You don't get insurance for that. All of the things that you're saying could be opened up if the chairman's bill passes are true today.
Absolutely.
Any police officer could file a grievance with the state bar complaining about the DA's conduct under his license.
Well, I think it's a little broader. With all due respect, I think it's a little bit broader under the commission. When you invite someone just to look at the officer's or the prosecutor's general conduct, the state bar really pigeonholes it at 3.09, the rule that affects prosecutors, and you're not going to get a lot there. When you open it up for a public just complain about the prosecutor, that's when you get victims, police officers, defendants, anyone who's just unhappy with the prosecutor's exercise of discretion, the commission's going to be invited to review that. And that's what happened back between 77 and 85. They were invited to let's just see what the prosecutor did. So I think you're going to invite that kind of a system again, unless you ratchet down exactly what it is the complaint can be about.
Thank you.
You bet.
Members, any other questions for Rob? Chairman?
No, just a comment, Mr. Chairman. If we do end up passing this, I did do some historical research as well. The jurisdiction and oversight of this council went to the Committee on Criminal Jurisprudence. So I'm just letting you know that's the committee that made sure that it was operating properly once it was created.
Okay. Members, any other questions for this witness? All right, seeing none, thank you, Rob. Does anyone else wish to testify on, for, or against House Bill 200? Seeing none, the public testimony is closed, and the chair will close on his bill. Are there any questions for me? No. The House Bill 200 is left pending at this time. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to the call of the chair.